All right, good afternoon, everyone. I see we're live. Apologies, Chair Kelly, for running a little bit behind here. We'll get you right out of here. All right, well, good afternoon, everyone. Today's Wednesday, February 17th, 2021. Welcome to the Judicial Proceedings Committee. We have 11 bills on the docket. We're going to start off with Senator Kelly with Senate Bill 497. We'll go next to 515, then to 560, 624, 494, 583, 588, 589, 590, 607, and 608. So with that, without further ado, we'll go to Chair Kelly, Senate Bill 497. Welcome.
Thank you very much, Mr. Chairman and members. Given that the Maryland State Department of Education operates no county or other school system except for Maryland's Juvenile Services Education System, and given the lack of an independent school board focusing on the unique education, psychosocial, and other special needs of students in the custody of the Department of Juvenile Services, there is a critical need for the creation of a separate school board and school system adapted to the unique needs of youth committed to the Maryland Department of Juvenile Services. Let's review briefly some of the other serious problems with the status quo, which this bill is here to address. The children served by JSES have experienced a disproportionately high rate of trauma and are in need of a higher level of special education services for which there are inadequate budgetary and staffing resources. JSES struggles with stretching its resources over a 12-month calendar rather than a 9-month calendar, which exacerbates difficulties when filling staff vacancies in a timely manner and maintaining an adequate lineup of substitute teachers. There are very limited options available to students in JSES for earning credits, taking online courses, or enrolling in a post-secondary program. Instruction available to JSES students is not based on the academic interests or achievements of the students, but on housing assignments of the students. JSES lacks systemic protocols for ensuring that as a student graduates from the program, a transcript of the student's completed work is available in a timely manner to a public school to which they might return. And the pay, working conditions, and attrition rate of JSES teachers, principals, and support staff are in need of significant improvement. I want to share for a moment some of what the Juvenile Justice Monitor in the department in the Office of the Attorney General has had to say additionally about just the deficits in the system, the way it is presently running. And I'm talking about Nick Maroney. MSDE JSES is not organized to operate as a school system and does not have its own internal procurement or human resources department to ensure that adequate supplies, tools, and staffing are delivered or available to faculty to facilitate schools in a timely manner. Compounding inadequacies in the organizational structure is the insufficient funding. These structural shortcomings have directly impacted the availability and quality of education services in the Department of Juvenile Services facilities. Ongoing problems with teacher shortages through both vacancies and absences continue from the perspective of the Juvenile Justice Monitor to significantly disrupt education services. As a result of staffing issues, students do not receive comprehensive, consistent daily instruction with appropriate education supports. Students are unenrolled from their community school upon entering a DJS detention center, even though they are often, sometimes within just a few days, released to the community following a court hearing. Parents or guardians then have to appear in person at a county or city school administrative office to try to re-enroll their child in his or her local community school. Youth also experience difficulties transferring credits from MSDE JSES schools to local school systems when the students return home. Credits that they have earned in the MSDE system or JSES system are not necessarily accepted at their local schools. In other words, in Maryland, we don't have the local community schools and the JSES school really working in tandem on behalf of these students. Vocational, career, and technology education is limited. And then there was a bill passed in 2018 that was going to create a pilot whereas the Noah's detention center would be served by Montgomery County Public School instead of by MSDE. But that pilot has just yet to materialize. So these kids that we need to grow up and be not in the criminal justice system, but to be taxpayers, to be civic minded, to contribute to the society, to have families in their own rights that can be forward looking and progressive. These children are not well served under what we in Maryland have provided for them under the status quo. Senate Bill 497 is here to improve equity and opportunity for the largely low income and predominantly minority youth who are committed to the Department of Juvenile Services. We need these juveniles to become high school and college graduates. We need them to be a part of civic engagement. We need them to testify on bills here in the General Assembly and not to give up on them at this time by not serving them well. The Department of Juvenile Services has not been provided with a separate procurement, internal procurement division, or with a human services department focusing on education. So you're asking them to do a job with their hands kind of tied behind them. These students cannot be educated without an adequate system run by an appointed school board of dedicated professionals, such as the proposed Juvenile Services Education Board in Senate Bill 497. The new board, and you can read for yourself, I don't need to tell you who all would be serving on it, but it would be like a real school board with the appropriate people representing the appropriate entities in the state of Maryland who could bring value, could help to get the resources that are needed and to make sure that these students have a fighting chance. The appointed members of the board shall all have a high level of knowledge and expertise in at least one of the following areas: teaching or educational administration, prior service on either the State Board of Education or a Board of Education for one of our counties, social work, services for individuals with disabilities, working with institutionalized youth, mental or behavioral health services, civil rights law or advocacy, digital learning, online administration, or higher education administration. We need these kinds of professional backgrounds to be reflected on the school board for juvenile services. Senate Bill 497 specifies the term of the board appointments for full terms, as well as for partial terms following any vacancy. This bill specifies a number of standard parliamentary procedures and standards for board actions, and specifies that the department shall staff the board, which becomes active under the terms of this bill as of July 1, 2022. Staff training for every residential facility shall be developed, recommended, and approved by the board, and accredited by an approved accrediting agency. The board shall consult with the Juvenile Justice Monitoring Unit and with the department on the development of minimum standards and reporting structures to measure education outcomes and assessments. The board shall review quarterly quality assurance reports, conduct performance reviews of the superintendent at least every 4 years, and shall approve post-secondary education programs, including vocational and online programs designed to meet student needs. There's a requirement under the terms of this bill for at least monthly public meetings of the board, just as normal county school systems have county boards that meet regularly and in public. Education staff in the department shall be subject to the career ladder and salary provisions for the blueprint for Maryland's future. This bill authorizes the Department of Juvenile Services to adopt regulations applicable to the responsibilities assigned to the board and to the education staff, beginning on various designated dates specified in the bill. The bill specifies the general types and scopes of education services to be provided. It requires the board to hold public meetings which meet certain requirements, and requires the board to appoint a superintendent as well as other staff. The bill specifies the duties and salary of the superintendent and directs the Department of Juvenile Services to implement juvenile service education programs that meet certain requirements. This bill requires the governor to include in the annual budget bill a certain appropriation. The bill also requires a degree of cooperation between the Juvenile Services Education Program and the county community-based schools where JSES students were most recently enrolled and or to which they return. In that regard, Senate Bill 497 prohibits uncoordinated disenrollment of students who move in either direction between the county school system, the juvenile services school system. Among programs to be offered by the juvenile services education schools are programs meeting the specific needs of the juveniles in each of the department's residential facilities. And all such programs must be approved by an appropriate accrediting agency. The board shall also approve certain post-secondary education programs. The JSES board shall consult with Maryland Juvenile Justice Monitoring Unit and with the department when developing minimum standards, the structure for measuring and reporting education outcomes, and when assessing the implementation of the Juvenile Services Education Program. The school board is required to do all of the things that other school boards are required to do, in addition to reviewing the total performance of the superintendent at least once every 4 years. At least monthly, the school board shall hold a public meeting where a majority of the board members then serving will constitute a quorum. The board shall respond to information requests regarding its budget, activities, and programs, and allow time for public comment at each of its meetings. The superintendent of the new school system is charged with the typical duties of counterparts in community-based school systems, and will serve at the pleasure of the board, will manage all resources provided by the state, including the hiring, resourcing, the evaluation of all staff and of all programs. I won't go on, but you can see we don't want a mini board. We want a real school board with real professionals who will do real work and make sure that cooperating with the Department of Juvenile Services and with the Maryland State Board of Education, that this is a real school from which graduates can go on to higher education or to real jobs and pay real taxes. The bill specifies certain waivers of county school graduation requirements, considering that it would be difficult for this one school to adjust to all of the requirements that aren't core education requirements, since there are so many counties from which the students come. Starting December 1, 2022, and annually thereafter, the department shall submit a report to the governor and to the General Assembly on aggregate education outcomes of programs required by the statute, by this subtitle at each residential facility. Finally, the JES board shall be subject to audits by legislative services, investigation by the Office of the Inspector General for Education, and oversight by the State Board of Education. The Juvenile Justice Monitor in the Office of the Attorney General is also required to monitor education outcomes at each residential facility on or before December 1, 2022. Both the lead House sponsor and I have agreed on some amendments, and I have provided for you today the amendments. They aren't very significant, but they are significant enough that one educator employed by the state who is engaged in the education of juveniles residing in a residential facility shall meet certain criteria. The amendments also deal with they deal largely with some terms and conditions for the educators who will work in the schools, and to make sure that at the end of an educator's period of service, that they have the same kind of outlook and possibilities in terms of a retirement as would be applicable for teachers and educators in other county school systems. I'm going to stop except to say that the act will take effect if JPR and the members of the Senate will move forthwith, as I believe those in the House will. The bill has already been heard. It had a very effective hearing in the House of Delegates. And by July 1, 2021, we want the superintendent and the board to get going so that the kids in this department can stand and receive their diplomas. And I'd like to see the superintendent, the head of juvenile justice system, able to shake their hands and to know that he's sending out promising young people whose wrong turn has been righted, whose psychosocial needs have been met, whose academic promise is obvious, and who are ready to face the world in a bright future. I want to thank you for listening, and I certainly am asking for your support for Senate Bill, what is the name of the bill? 497. Thank you very much.
Thank you, Madam Chair, for the thorough presentation. We really appreciate it. And now for your primary witness, we'll go to Professor Peter Leon. Professor Leon, you're up.
Thank you very much, Vice Chair Wall-Streicher, and thank you, Senator Kelly, for the opportunity to speak in support of SB 497. My name is Peter Leone. Until very recently, I was a professor at the University of Maryland, College Park. I retired after 39 years in College Park. During the bulk of my career, I've studied education programs for children in institutions and settings like those operated by the Maryland Department of Juvenile Services. I have worked with the courts, the U.S. Department of Justice Civil Rights Division, and a number of advocacy groups around the country to ensure that students receive quality services. Currently, I monitor and have done so for several years the Illinois Education Services and Illinois Department of Juvenile Justice. I was recently appointed to monitor education in the Los Angeles County juvenile halls. As you well know, in 2004, the General Assembly transferred the responsibility for education within the DJS facilities to the Maryland State Department of Education. However, I believe MSDE has struggled for many of the reasons that Senator Kelly shared with us. It struggled to meet its statutory obligations. In contrast, in many other jurisdictions, they've done a much better job of serving youth, their families, and communities. In juvenile facilities with high quality education programs, There's measurement and accountability for student performance. There's strong links between communities, programs, and facilities. There's also a shared sense of responsibility between custody and security staff and education and treatment staff. In facilities with strong education and vocational programs, youth and staff are excited about what they're learning. In facilities with strong education programs, students clamor to get to school in the morning and drag their feet at the end of the day when it's time to return to the living units. Each year, I talk to dozens of youth in juvenile facilities around the country. I ask them what they're studying, who their favorite authors are, and how many credits they have. Most often, in well-operating programs, students are able to share the passion about what they're learning. Their complaints in these facilities have to do with the number of books they can have in their rooms and whether their book club that they're a member of can meet more than once each week after school. Other students may ask, why isn't this course offered during the current semester? What I learned from these youth is that they have hope and aspirations for the future. The educators and other staff recognize and support their potential despite educational challenges they may have experienced earlier in their career. The youth in Maryland DJS facilities, like those in many states, are disproportionately children of color and disproportionately eligible for special education services. As Dr. Desmond has reminded us, and as Senator Kelly most recently reminded us, the education needs of these children have too long been neglected. Most recently, during the time of COVID, I believe MSDE has struggled to provide adequate educational services. In contrast, in other states that I'm in contact with, they've used technology, personal protective equipment, and blended learning with web-based instruction to connect youth and to ensure that they receive quality educational services. I do believe that many teachers and administrators and others in the current system want to do the right thing, but as currently configured, the system is unworkable. I won't repeat all of the points that are in my written testimony about the importance of an independent agency deliver educational services. But I would like to emphasize a couple of things about the bill that I think are just terrific. One is the guarantee of post-secondary education for youth who have completed their high school diploma or who have received a high school equivalency certificate. I think that's huge. I think autonomy and accountability, credits, and the opportunity to offer diplomas are really, really, really key. I believe, let me end with a couple of thoughts here. One is, I believe that children in DJS facilities are entitled to the same quality education service and supports that we want for all of our children. I believe that education is crime prevention. There's a strong positive correlation between levels of education attainment and literacy and the likelihood of children returning to their communities and becoming contributing members of society as young adults. And in fact, educational attainment is one of the best predictors of whether youth will return to the justice system following release. I urge members of the Judicial Proceedings Committee to support Senate Bills 497 and the creation of the Juvenile Services Education Board and Program. I believe it's time for Maryland to create an education system commensurate with our expectations for all children in the state. Thank you.
Thank you, Professor Leone. Appreciate it. Now we'll go to the Office of Public Defender. Ms. Rusing, you're up.
Thank you. My name is Grace Rusing, and I am an attorney with the Office of the Public Defender, and I represent the students who are enrolled in the JSES schools and the detention centers and placements. The Office of the Public Defender is in support of Senate Bill 497. By way of background, in 2013, when I started in my position, I did not know one thing about education law because I was a criminal defense attorney. But that was the year that I started working with detained juveniles in the detention centers, and I was contacted by former JSE teachers and principals sounding the alarm that the MSDE takeover of the system was not working. That was 8 years ago, and the system is still broken. And since 2013, I have filed over 40 special education complaints, documenting the egregious shortcomings that bar educational equity to our clients, from students not having their IEPs implemented, to chronic staff shortages, inadequate course offerings that cause students to lose the opportunity to earn credits, lack of differentiated or individualized instruction, and to leadership that does not have the track record or any real experience in operating or implementing educational services to at-risk youth. And I could probably, like everyone else, go on and on. And since I've had limited time, I attached to my written testimony a 40-page document that chronicles my history with this issue. And it shows the data that proves that the current system is not working. But I think many of you already know that. And I think the issue really is this legislation going to solve the problem? And we think it is. And I think most importantly, the ability to provide an independent school board with the ability to appoint a superintendent is going to provide the level of autonomy, the transparency, and the accountability that we currently do not have under the current system. And although I can say that JSES has made some improvements over the years, it's far too little, and I believe way too late. And the system is in dire need of change for these students. Because to do nothing at this point after all these years and to decide to keep the status quo should be intolerable. Because we all know that the failed educational system only strengthens the school to prison pipeline. And I think that's what's going to be happening if we decide to keep the status quo. Thanks.
All right, Mr. Secretary, I believe you're next. Go ahead, Mr. Secretary.
Thank you, Mr. Chairman and members of the committee. Sam Abbott, Secretary for the Department of Juvenile Services, testifying in support of Senate Bill 497. As you know, DJS is an operational agency that maintains and operates residential and non-residential services across the state. And to manage this successfully, we've developed a system of quality assurance so that we can effectively oversee the quality of the services that we deliver. We don't just collect and report that data. I know you've seen the data resource guide. It's a very comprehensive look into the major metrics that we use to operate. But that data resource guide is not just there to provide information for outside partners. We use it to manage the system. And so we use it to track all of the critical areas of the agency. And we actually develop reports that are given even more frequently than the annual report that you see. On top of this, we have an audit committee that also reviews the electronic systems and audits our staff files and our court records to ensure that everything in our management reports are in fact accurate. And while we're not perfect, and we're far from perfect, this level of scrutiny of the work is essential to a well-functioning system. And I think that that's what this bill brings to education. Currently, we do not have visibility into whether youth are receiving what they should. Even basic metrics are not able to be produced without great manual efforts. And that leaves significant gaps in education. We need to have a process that ensures youth are actually receiving what is contained in their education plans. As an operational agency with an independent monitor, DJS has developed these tools and systems to allow us to track the data elements down to individual workers and individual youth, and even manage decision-making for our staff. And as I said, we report this data not just for transparency, but to manage decisions. And Senate Bill 497 leverages the investments that we've made into managing with data while still maintaining an independent education system. And the way it does this is by taking the operational and ancillary functions and moving those to DJS. And these are things like human resources, information technology, our research and evaluation team. I'm sorry. And so let me just wrap up quickly and just say that using those resources that we have already created and that we do very well, along with an independent education board, will get us the best outcomes. And for those reasons, I support Senate Bill 497.
Excellent. Thank you, Mr. Secretary. Next, we'll have Ms. Desmond.
Hello, can I be heard?
You can. Yes, we can hear you.
Good afternoon, Chair Smith, Vice Chair Wall-Striker, and distinguished senators. I know some of you, I've been before you before. I am Dr. Barbara Desmond. I've come today on behalf of the National and the Maryland State Conference NAACPs in support of Senate Bill 497. We have submitted extensive written testimony. I have a long history of civil rights of 60 years, including personally the opportunity to learn from Clarence Mitchell, Thurgood Marshall, Elijah Cummings, Perrin Mitchell. In fact, two ladies whom I refer to as mentors and knew, Verda Welcome and Irma Dixon, were the first two African-American women elected to the Maryland House. So I come with a good pedigree in civil rights, I know it. I also provided leadership to MSDE for over a decade to improve diversity in the situation of African Americans and other minorities in public schools, including writing legislation or regulations. As a result of investigations which began in 2014, both the National and Maryland NAACP found failure of the Juvenile Services Education Program as governed by MSDE. Consequently, we filed a multiple 100-page complaint with the Federal Office of Civil Rights. Our documentation showed that JSCP schools under MSDE flagrantly disregarded standards, demonstrated numerous examples not meeting the provisions of IDEA, as well as repeated and admitted violations of COMAR. Most of these children are Black and male, and an historically endangered population. We have come to wonder, would this situation have been tolerated had these children not been primarily Black offenders or considered by some offensive? In Maryland, these children, as all others, have an essential right to a quality education. They are not to be written off. The Organization of Human Rights for Kids, which focuses on juvenile justice throughout the nation, recently released a report that ranks this state as one of the worst states for protecting children's rights in the justice system. It is time to move beyond futility, excuses, and promises to do better. Senate Bill 497 presents an opportunity for us to rectify wrongs that have existed too long. Therefore, the NAACP commends all of the sponsors of this bill and urges a favorable report from the committee. Finally, as Nelson Mandela himself, a detainee, powerfully said, "There is no keener revelation of a society's soul than the way in which it treats its children." I beg you to search your souls. Thank you.
Thank you, Ms. Desmond, for your inspirational words and your testimony. We'll now move on to Mr. Wharton. Have you already testified? Mr. Wharton? Okay.
I don't think he's here.
Okay, great. So with that, that'll conclude the testimony for Senate Bill 497. Now turn it over to the committee for questions. Looking, Senator West, you're up.
Thank you, Mr. Chair, and I want to commend the sponsor of this bill. Well, I guess all the sponsors of the bill, as I would have been if I'd been asked. And I do have a couple of questions, though. As Mr. Abed knows, I was on the Juvenile Justice Reform Commission. We met a lot of times this past summer. I don't see Mr. Abed. Is he still here? There he is. There he is. I lost you. So there are two different levels of youth who are in the system. In the one case, they're being detained and held before trial. And then in the second case, they're being held in incarcerated facilities after trial, correct? So you might want to unmute Mr. Abed. So currently, how many youth are there in the detention facilities, and how many are there in the incarcerated facilities?
So I need to get my population sheet, but we have approximately a little bit under 200 kids detained statewide, and about that many in our after the detention centers in the committed facilities. The numbers right now, I just want to say, are extraordinarily low from where we typically are, because of COVID. I think COVID has had a tremendous effect. So while our numbers are very low, I think that is an effect of COVID, and we'll have to see if they remain that low.
Okay, so let me ask you, this is a topic we sort of got to around the edges of this past summer, but really didn't focus on too much, the education of the youth while they were in the facilities. Suppose in a particular detention facility, but let me ask you this first. How long does the average youth stay in a detention facility?
So on average, a youth would stay approximately 15 days in detention. And the recent, and that's for pre-adjudication detention youth, but we have different populations in the detention centers. So while a typical youth charged in the juvenile system stays about 15 days, if you're a youth charged as adult, you could be in detention for upwards of a year awaiting your transfer hearing or other things. So we have, sort of two different populations that we have to look at, those very short-term stays for the juvenile system and the much longer stays in the youth charged as adult system.
And of the 200 youth that are currently in the detention portion of your facilities, how many fall into the first category? They're just being held for a short period of time pending trial. And how many fall into the latter category of adults who might be there for up to?
Well, a larger number now are in that youth charged as adults category, and that has been a growing number. So they're about half of the population now.
So it's about 100 in each category?
Yes.
Okay. So let me just give you an example. I'm trying to figure how it works right now and then how it would change under this bill. So you'll have youth anywhere from the ages, let's say, of what, 10 up to 18. Is that right? Would that be fair?
We don't have 10-year-olds in the detention centers. Typically, our ages are going to be between 13 and up to 21. But our average age is going to be between 14 and 16 years old. That's
okay. So you have kids. You have kids at various different levels. So let me just take a hypothetical kid who's 18 years old and who is operating with, say, a 5th grade education. So currently, is the education provided to that particular young person tailored to the fact that he has a fifth grade education as opposed to his age? Because most 18-year-olds are in the 12th grade. So what level of education is being provided to that young person?
So I think the issue here isn't the plan. I think that all of our youth have education plans. The real issue is we don't have visibility into progressing on those plans or what kind of progress that the kids have made. So I think there certainly are evaluations that the education system makes to determine what an individual youth's education plan should be. Where we don't have visibility is what are kids actually getting?
Right. So I'm not sure that your answer was as clear as I'd hoped it was going to be. So if you have a young person whose educational level is at the 5th grade level, but the person is 18 years old.
So they would get the 5th grade in their plan. They would get the right education in their plan. As far as I know, they would. The question is, are they actually getting the education that they are supposed to be receiving under that plan? Right. That I cannot answer.
So let me flip to this bill, if I could. How would that hypothetical young person's education change if this bill were passed?
So what this bill would do, the two things I think that are important to understand what this bill would do. Number one, we have gaps in the educational services that are driven by the operational failures. And when I talk about human resources, so if we have a teacher that is, or a teacher vacancy that is extended for a long period of time, that represents a gap in the curriculum. And what the education system will have to do every time there is a shortage of teachers because of vacancies is they're going to collapse down to the core requirements of education. They're going to do the math and the science and the history, the things that are absolutely required in the core. And what gets lost oftentimes are the vocational education and those other types of education, those alternative education programs that we really need in higher rates in our facilities. So that's one way this bill addresses that, by addressing those sort of ancillary functions and getting to getting those teachers in those positions and the materials needed to bear quickly on the youth. The other way that it addresses your issue is through the transparency of data reporting. So it does bring the JJMU, our independent monitor, into legal oversight over the education program, but it also requires us to set standards, or required to the education board that would be created here to set education standards. And then we would have to monitor those standards and report those standards transparently. And then we could all, whether it's the OPD or the department, review and discharge our duties and understand what's working, what's not working, and where we need to make changes.
Okay, well, now let me get to the nub of where I was going with this line of questioning. And that is, you may recall that at the first meeting of the Juvenile Justice Reform Committee this past summer, there was a young man there who had been in the system and had come out of the system and was appointed to be a member of the committee. And I remember quite vividly his raising his hand and his saying, to be perfectly frank, the education I got in the system was totally useless to me. He said, all I got was college preparatory courses. He said, I know I'm not going to college. What I needed was vocational education, and I didn't get it. So I went up and talked to him afterwards, and we had an engaging conversation about this subject. So here's my question. Does this bill, I'm looking at it on page 10, it says it's designed to meet the juvenile's individual needs. So in the case of a juvenile who informs his supervisors, superiors, or whatever they're called, that he doesn't intend to go to college, and what he really needs is vocational education. Does this bill provide for such an individual to get needed vocational education, or alternatively, will he be subjected to college preparatory courses?
Now, I believe it will get him that vocational education that he or she would require, because having that independent board with the makeup of that board, so it doesn't necessarily specifically say it in the bill, but it puts the right people that understand, just like you understand, how important it is to have that vocational education. I think all of us in the system understand it, and we're trying to attack it from the various places that we see are causing that part of the system to fail, whether it's because of vacancies or lack of resources, procurement resources to get things up and running quickly enough, or whether it's because the plan wasn't contemplating that in the first place. I think both of those get addressed by the bill.
Okay, let me move over, if I could, with just one final question along the same lines to Dr. Leone. Dr. Leone, if he could be unmuted, when you were giving your testimony, it seemed to be rather college preparatory in nature. Is it also your understanding that under this bill, if a student feels that he's best served by vocational courses rather than by 12th grade history courses and the like, that he would be able to design it or have a plan designed for him, which would give him the education that he desires?
Yeah, absolutely. And if I left that impression, that wasn't intended on my part. I've seen terrific programs, career tech ed programs, culinary arts, horticulture, kind of building maintenance, entrepreneurship. In Illinois, where I'm very familiar with what's going on, they have an independent school board, and they have partnerships with Lakeland College, and they have courses in the facilities for kids who are interested in those kinds of things. And kids balance maybe a half day of academic prep with a half day of career tech ed. And it's really terrific. I mean, the kids in culinary arts and in the wood shop, they're so excited about what they're able to do. And they have a partnership where they support activities within the facility. So if the superintendent of the facility is having a reception for something, they'll go to the culinary arts teacher and they'll put a plan together with the kids and they'll prepare the food. And then the kids are there in their whites, with their hats on, serving the food. And it's pretty exciting. And I think it has a real salutary effect on the facility as a whole, because the kids buy into education and they really feel like people are interested in helping them and supporting them. So yeah, so Nancy, and I could go on and on about career tech.
Well, let's
Yeah,
stop
yeah.
here.
Great.
Let me just thank both Secretary Abed and Dr. Leone for their answers to my questions. Thank you.
Excellent. Thank you, Senator West. Actually, I learned a lot, so thank you for asking those questions. Good. Looking around the room for further questions, seeing none. Senator Lee, you faked me out there. Seeing none, that will conclude the testimony in the hearing for Senate Bill 497. Thank you, Chair Kelly. All right, I see that Senator Klossmeyer is here, so we'll now move on to Senate Bill 515. Senator Klossmeyer, you are up.
Yes, thank you, Mr. Chair and Vice Chair and committee, and I appreciated hearing some of Senator West's questions as well. Thank you. Senate Bill 515, Criminal Procedure, Registered Sex Offenders Entry onto School Property. Senate Bill 515 prohibits students who are registered sex offenders from attending classes on school campuses. The legislation requires registered sex offenders to receive their education by way of home and hospital or through a regional institute for children and adolescents. This issue is not new to this committee. Last year, this committee passed a similar bill that would have required registered sex offenders to get their education somewhere other than a regular school building during a regular school day. But there were concerns about the definitions in the bill when it crossed over to the House. Therefore, the main change to the bill is that it's defined where these students will receive their education. It is still up to the local boards to implement policies on how students should receive the education, along with the guidance from MSDE. And I just would like to say that during the interim, the delegates worked with the chair of the judiciary, Delegate Clippinger, Chairman Clippinger, and came up with that new wording. And I think the bill should be good to go. And I thank the committee for their consideration of Senate Bill 515 and ask for a favorable report. And the bill did pass out of your committee and it passed off of the Senate floor last year. So.
Excellent. Thank you, Senator Klossmeyer. And Mr. Schellenberger, you're up next. You're the primary witness. You have 5 minutes. Good
Thank you so much, Mr. Chair, Mr. Vice Chair, members of the committee. I'm here in support of Senate Bill 515, which seems like a very common sense idea. And a lot of this is as a result of an incident that occurred here in Baltimore County. In December of 2019, Santino Sudano was charged with second-degree rape as a result of an incident that happened in Parkville High School. At the time, Sudano was 21 years old and a student there. The victim in his case was 15. Sudano had enrolled at Parkville in July of 2019, despite the fact that he had previously been convicted of a fourth-degree sex offense in a 2017 incident when he was 19 years old and had sex with another student who was only 13 at the time. He pled guilty in that case in 2018, which caused him, that conviction, caused him have to register on the sex offender registry. When he applied for school in July of 2019, he was granted permission, despite being on the sex offense registry, granted permission to attend Parkville High School, which then gave this 21-year-old access to another group of young students. Senate Bill 515 would prevent any student who is registered as a sex offender from attending a traditional school. Now, fortunately, Senator Klossmeyer has crafted this nicely. The law does require the sex offender to be able to get an education through more non-traditional means, either through home or a regional school where there would be at least a lot more oversight while that goes along. It really kind of goes without saying that 21-year-olds should not be regularly going to school with 13 and 14-year-olds. And the same is true very often of 19-year-olds, particularly when they've obviously committed a sex offense. We think this is a very logical sensible approach. It keeps those on the sex offense registry off school property, but yet allows for them to still obtain their education through other methods that are already accepted. And with that, I urge a favorable report of Senate Bill 515.
Excellent. Thank you, Mr. Schellenberger. And so with that, that'll conclude testimony for the proponents. We'll now switch over to the opposition panel. And Ms. Gross, you're up next.
Good afternoon, Mr. Chair, Mr. Vice Chair, and members of the committee. My name is Michal Gross, and I'm an assistant public defender in Southern Maryland, where I represent children and adolescents in both juvenile and in adult court. This bill won't actually achieve the goal of making people safer. And instead, this misguided legislation is an overreaction that would cause more harm both to individuals and to the community. This legislation is unnecessary and harmful. It doesn't offer a viable alternative education plan.
Yes,
and
it
it is
does.
contrary. Yes.
Yes.
I'm sorry. It is contrary to expert recommendations. Research shows that youthful sexual offenders are unlikely to reoffend. That low risk of reoffending can be further reduced through effective treatment, especially when those individuals are engaged in holistic services and reintegrated into the community, including within a school setting. The bill offers, as was discussed earlier, an alternative education plan, but that alternative education plan is both expensive and unrealistic. The two options offered by the bill are the home and hospital program and the regional institutes for children and adolescents. Both home and hospital and the second option is referred to as RICA. Home and hospital is a program that sends tutors to the homes of students who can't attend school because of medical reasons. Anyone who's read the fiscal note will notice that Anne Arundel County actually estimated that it would cost them $35,000 per student per year to educate each individual through the home and hospital program. That's more than twice the average cost of educating a student in Anne Arundel County right now, which is $16.7 thousand. The second option offered, RICA, only has two locations, Baltimore and in Rockville. Both of those locations operate residential facilities that have admission requirements, including a necessary diagnosis and bed limitations. Rockville, RICA in Rockville also has a day program that's run by the Montgomery County Public Schools. The bill doesn't really discuss who is going to pay to send those excluded students to RICA or to pay for the home and hospital program, doesn't discuss transportation, doesn't discuss admission requirements or anything else there. And I did mention, and I think it's important to note that the experts warn against this. The Department of Justice operates a sex offender management assessment and planning initiative. And that sex offender management assessment and planning initiative specifically warns legislators against using a one-size-fits-all approach when talking about youthful sexual offenders. Instead, what the initiative encourages is risk assessment and limiting the most aggressive strategies and the most intense interventions to those who require the greatest level of supervision and restriction. Thank you. So this bill is exactly what the research warns against. And for these reasons, I urge an unfavorable report. And I'm happy to answer any questions.
Excellent. Thank you very much. And with that, that'll conclude the testimony for Senate Bill 515. Now I'll turn it back to the committee for questions. Seeing none. Actually, here we go. Senator Sidnor, you're up.
Thank you. Would either of our attorneys, well, actually, no, I'll direct this to Mr. Schellenberger. The fourth degree sex offense, could you remind the committee, what is that?
A fourth degree sex offense would be one in which someone who is 4 or more years older has sex with a younger individual, someone 13, 14, or 15. There does not need to be any force involved. It can be consensual, but because of the 4-year age difference, we have all decided that that is improper and against the law. And that's why it made it very difficult with Sudano, because he was in school at the age of 19 and then at the age of 21. And so even if the individual had some form of consensual sex, that is against the law because we presume that they cannot consent.
And in those types of cases, I'm trying to think back to my first day when I was a law clerk. The judge that I worked with, he had a sex offense docket, and I remember some of these cases coming through, and at least one or two of the defendants who were being prosecuted, essentially saying that, in those cases that they were under the assumption that the young women that they had intercourse with was not younger than what they had said that they were. And I remember Judge Quarles saying essentially that his hands were tied, that there was no excuse. Is that correct?
Yes, that's correct, particularly when you're dealing with someone who is 13 and 14. And I do need to add a few things. I was very specifically honing in on what happened at Parkville the first time. You can also commit a 4th-degree sex offense by touching an intimate body part, and the person didn't want it to happen. But I was focusing on the facts that actually happened in the Sudano case in the first one, where he was 19 and the girl was 13. And Senator, I certainly understand the comment when we're discussing individuals of a certain age, which is why we've had this argument for many years about 16 and 17-year-olds. And that's why this legislature has saw fit to make it 15 and younger and 4 or more years or older. But certainly, specifically with the first case, we're looking at a situation of a 13-year-old, which is a far cry from a 17-year-old.
Right. The other example, the 4th-degree offense that you're talking about, is it possible for a young man to be charged with a 4th-degree sexual offense for slapping or caressing a young woman's backside or breast?
It is possible. I can tell you that doesn't happen very much in Baltimore County or in the state of Maryland, but it is theoretically, if it's against the will and against the consent, and that is proven beyond a reasonable doubt. And that's the key element. I have to prove beyond a reasonable doubt that it was not consented to.
And this is where I'm not certain. I hope you can help. Is it mandatory that these offenders then be placed on the sexual offense registry?
I think when we get down to 4th degree, there's a certain level of discretion.
Okay, thank you very much.
Sorry about that. All right. Senator Reedy.
Yes. Good afternoon, Vice Chair.
Good afternoon. Senator Sidnor, let me unmute you. I'm just coming back to the hearings here.
No, I was just mentioning Senator Heddleman had her hand up. I think Senator Reedy.
I see it. Got it.
Still, that's all.
I got it. Senator Heddleman, go ahead.
Thank you very much, Mr. Chairman. I just wanted to follow up on that line of questioning. So am I correct with Mr. Schellenberger, if that's okay? So am I correct in thinking then that if somebody is 19 and they are accused of offending a 15-year-old, right? So they now are a registered sex offender, that 19-year-old then cannot, under this bill, cannot attend school.
Cannot attend a traditional
school in this setting.
Correct. But the Board of Education would have to provide other education.
Okay. And do you have any sense of the people who are convicted sex offenders, kind of the age range?
Yes, and I think that's an excellent question, because my friend from the public defender was concerned about the fiscal note. We are talking about a small number of individuals who have been convicted of these crimes and are required to register as a sex offender. So I don't think we're talking about a huge number of individuals in this case, but even the mention of the $35,000 to educate this individual outside of the school, I got a rape victim. And you know, I got a sex offender attending a high school, and now I have a second rape victim. I don't think $35,000 is an unreasonable number to protect the other individuals in that school.
But I guess my follow-up question to that is, of the people, if it is a small number, of the people who are convicted sex offenders, how many are, let's say, 21 and below?
Again, I would say that's a very small number. I don't know the actual number. I'll see what I can find out.
Okay, thank you.
Yes, thank you.
Thank you both. Any other raised hands? Senator Carter, go ahead.
Thank you, Mr. Vice Chair. Mr. Schellenberger?
Gotcha.
Oh, thanks. It says I'm muted, but I'm not. Thank you. I just wanted to follow up on what you just represented about the discretion that is allotted for fourth-degree sex offenses. Can you elaborate on that discretion and how it works?
Candidly, no. I have to research that for you. And I promise I will forward that research to all of you. I know there's a level of discretion. I'm just not exactly sure where that level comes in. So let me check that for you and send you all an email, which I know you all get.
Thank you.
Thank you for the question. I appreciate it.
Thank you, Senator Carter. Looking around the room, I don't see any further questions from members. Thank you, Mr. State's Attorney. Thank you, Senator Carter, for bringing the bill. And now we'll move on to Senator Reedy with Senate Bill 560. Senator.
Thank you, Mr. Vice Chair and members of the committee. It's good to be back with you. And boy, sex offenses, I got to listen to the last little bit of hearing. It's bringing back, I won't say good memories, but it's great to be with you all again to talk about an issue that I think is important to all of us. And it's an issue that we sort of dealt with last session, but we didn't get it all the way through the finish line. So I want to present Senate Bill 560 to you, which deals with the theft of a handgun. Senate Bill 560 would classify the theft of a handgun as a separate felony offense. First conviction would be up to 5 years imprisonment with a minimum of 2 and up to $1,000 fine. Second conviction would impose more time, minimum of 5 and up to $2,500 fine. So I have some statistics that I think you're all familiar with, but looking back a couple of years ago in 2018, the total number of firearms recovered and traced in Maryland was over 11,000. From the Maryland State Police database, there were 569 murders in 2017, 401 of those in Maryland, and 401 of those were committed with handguns. 45% of robberies from that year were committed with handguns. We've seen in statistics from places like Baltimore with the high amount of violence that's ended in murder and shootings that the vast majority of them come from handguns. And as we've heard before in our committee, there is almost never a case where a legally obtained, in fact, they can't find for the last several years, a legally obtained handgun being used in a crime. So this bill seeks to say if someone steals a handgun, we know that handguns are used, they're much more likely to be the kind of gun used in a crime than any other kind of gun. We want to send a very clear message that it's unacceptable, and we want to have people serve real time for stealing a handgun. As I've often said and said recently on the Senate floor, we have a lot of groups and a lot of people come in and talk about gun violence and how they're against gun violence. I don't like violence and gun violence either. I think handgun, particularly illegal handguns, are really the sort of the tip of the spear of where that is. And so we need to do everything we can to punish those who would certainly traffic in illegal guns. I know it goes beyond just stolen handguns, but if someone steals a handgun, that needs to be a very serious crime that gets real time. And I know that it was rolled into the omnibus crime package we did last year that made it through the Senate. And I think Senator Huff has that bill in again, and this is a part of it. But I wanted to put the bill in here to spotlight it. It is really, for anyone who is concerned about gun violence, the theft of a handgun is a very serious crime and needs to be treated as such in our law. So I would ask for your favorable support for Senate Bill 560. If it's included in a bit, if we can pass that omnibus bill again, obviously if that's in there, that's great too. But I wanted to take a moment to really be sure it was clear that this is a change in our law that's needed. I do have some witnesses here who will testify. I invited groups that are usually on the opposite side of me as it relates to firearm issues for law-abiding citizens. I invited them to participate and testify in favor of this bill, and they did not get back to me to do so, which is, I'm disappointed. I actually thought it'd be a great thing we could come together on. Hopefully we can get some support from them. But at any rate, I'd be happy to answer any questions, Mr. Vice Chair, and look forward to working with you all as we bring good legislation to the floor to deal with gun violence.
Thank you, Senator. I think our tradition this year has been to wait till the end.
Oh, that's fine.
Unless you need to get back to committee immediately.
If I duck out, there is one other thing I might have. If I duck out, I'll duck out, but I think I'm okay for now.
Okay. Thank you, Senator Reedy. Mr. Pennock, you're up. And as Mr. Pennock is turning on his video, I'd note that Mr. Pennock is a constituent of mine. So to the extent anyone has any stereotypes of the makeup of District 18, I think helped dispute those. And I think he lives around the corner from the Chief Justice of the United States, who thinks similarly to him on some of these issues. Mr. Pennock, you're up.
I am delighted to be here, Mr. Vice Chair, and indeed I am one of your constituents, and it's always a pleasure to see you. So we think this bill is a bill of great common sense. And you have my written testimony that talks about the disparities imposed under Maryland law. Theft of a firearm, indeed this bill doesn't even talk about a firearm, it talks about a handgun only. So it's actually more narrow than the HB 35 that passed last year into this committee. Is one of the worst things that you could have, because those firearms immediately go into the black market where they are sold and resold again. And I can assure you that none of those sales are accompanied by background checks. They are sold to prohibited persons. The ATF has repeatedly found that these are used in crimes of violence. There is really no conceivable reason to tolerate theft. Yet under Maryland law, the theft of a firearm between $500 and $1,500, and that's the worth of it, and that covers most handguns, by the way, is a misdemeanor that's punishable under the Maryland guidelines with probation. Second offense, probation. There is no incentive whatsoever to prosecute these crimes for prosecutors, because all the perpetrator of these crimes do is get probation. Those guns are immediately sold and resold. So there has to be an incentive to stop these kind of thefts. Indeed, by making it a felony under Maryland law and under federal law, the person becomes a disqualified person who is prohibited from owning or possessing, constructively or otherwise, any firearm, any modern firearm, or any modern ammunition. It is a powerful disincentive to carry out the crime, because if you're caught with a handgun or any kind of firearm after becoming a disqualified person, you can see long time in federal, that's 10-year felony in federal prison. And there's no probation for that one. And it's up to 5 years just by being a disqualified person under state law. And there's lots of probation from that. So there is an incentive for people not to do this sort of crime, which is a huge danger to the community. And it's odd, you see that in my written testimony, how often this is, in which innocent transgressions by law-abiding people are severely punished, and yet we have no punishment for this really dangerous crime. So I'm happy to take questions.
Thank you, Mr. Pennock. I think we're going to take questions at the end. Ms. Novotny, you're up.
Vice Chair, members of the committee, thank you for having me here. I'm Katie Novotny and I live in District 7. And so I support this bill. Kind of to expand a little bit on what Mr. Pennack said. I'm not going to go into all the penalties. We've kind of covered all that, but I found it takes 4 convictions of this misdemeanor theft to have a penalty strong enough for a person to actually become a prohibited person. And when you look at the fact that these generally, often aren't even pursued, they get null prost, they get dropped, they get probation, whatever the case may be, that we're not getting convictions for this crime, these people are, just going to continue to do this behavior. And I think it's very important that a penalty for, a crime that, is not done innocently. There's no innocent reason that you're stealing a handgun. As has been alluded to before, these are predominantly the firearms used in crime. And this is the crime that's, driving a lot of these murders. I hate to pick on Baltimore City, but, that's where we're seeing so many of these murders. And, we constantly see legislation trying to slow this down. And in my opinion, having, some teeth to, as a penalty for this crime can go a long way in keeping the community safe. So I request a favorable report. Thank you.
Thank you, Ms. Novotny. Mr. Jocelyn, you are up next. Whoops, I apologize. That was me who did that. Go ahead.
Good afternoon, Mr. Vice Chair, members of the committee. John Jocelyn speaking for 2A Maryland. I won't rehash what you've already heard. All of it is valid. I will point out that Maryland has established a system to legally acquire a handgun that is nothing short of draconian. We're looking at training, fingerprints, background checks, investigations, fees, all of this just to get the handgun qualification license. And then, and only then, can you then apply to purchase a handgun and pay another fee and go through another background check and wait 7 days. On the other hand, the criminal can simply take what he wants and make off with it. And unfortunately, under our current structure, the theft of a handgun is considered no more serious than the theft of a lawnmower out of a garage. We believe that this is certainly a disparity, and we would strongly support a favorable report on this bill. Thank you.
Thank you, Mr. Jocelyn. Mr. Doherty, you're up next.
Good afternoon, Mr. Vice Chair, members of the committee. Mike Doherty, Maryland State Rifle and Pistol Association, in opposition. I'm sorry. Ugh, I'm so used to saying that. In support of this bill. We just went through a whole arrangement. The legislature overrode the vetoes of the long gun bills from last year. The long gun bills from last year make it a penalty that if 30 days from now, if I want to sell Mr. Jocelyn a firearm and I meet him somewhere else and don't go through the services of a dealer and sell him that firearm, I'm guilty of an offense that is now subject to not exceeding 5 years or a $10,000 fine or both. But this theft of a handgun that we know is a prime vector for being used in a commission of another crime subsequent to that theft is punishable as a misdemeanor that's rarely ever charged. So for those reasons, we'd request a favorable report.
Thank you, Mr. Doherty. That completes the panel for this bill. I'm looking around to see if anyone has any questions. It appears no questions. Thank you, Senator Reedy, for bringing this bill. Thank you to all the advocates for your testimony today. That concludes the hearing for Senate Bill 560. We'll now move to Senate Bill 624. Senator Lee, you are up.
Okay. Thank you, Mr. Chairman. This is SB 624. Untraceable firearms are not just guns with serial numbers crossed off, but they also include guns that have been designed to get around state laws and the federal definition of firearms. These are not homemade guns in the traditional sense. Today, in this do-it-yourself culture, we are not just buying meal kits, we are buying gun kits. Someone who prepares a meal from a kit is just about as much of a chef as someone is a gun manufacturer for drilling a few holes into an unfinished lower receiver. we cannot allow the exception to swallow the rule. The state of Maryland can join many other states that have recognized proliferation of so-called 80% receiver cells on the internet and have deemed public safety to be a priority. So SB 624 is nuanced approach to restrict gun sales to bypass our background check system in the state of Maryland. This is a different approach than our last year's bill, SB 958, which you all remember, which would have banned ghost guns completely in the state of Maryland. Lawful hobbyists should applaud this evolution because it's not the same bill. After consultation with law enforcement and activists from a wide range of perspectives, including the hobbyists, our bill creates a background check process through our existing handgun qualification license and a serialization process in line with our existing requirements for firearms that are sold in Maryland. The costs are de minimis to enact this bill, and the cost of inaction is sizable as MS-13 and other organizations exploit these loopholes to avoid detection and prosecution. For the justification of this bill, I challenge you to watch a video of kids assembling guns with mere hand drills. After the veto override of SB 208 and HB 4 from 2020, we can't let one loophole filled while another one metastasizes. These guns are used in very serious crimes for the specific purpose that they are not traceable and they don't require background checks. The penalty should be similar to crossing off a serial number on a gun purchased lawfully. Prosecutorial discretion will play an important role for the implementation of this bill. So we have an amendment to remove references to the enforcement of those provisions and clarify the registration of these guns, of course, includes the serial number engraved on a former ghost gun. The bill does not hamper lawful possession or construction of firearms, but it does close a deadly background check loophole and provides law enforcement a mechanism to investigate crimes as they would for any other firearm manufactured after 1968. Again, these are not guns made from a gunsmith. If the users want to fashion a gun from scratch, they would be exempt under the language of this bill. The term firearm under federal law is the tripping point here, and the difference between a 80% lower receiver and a firearm are potentially just 4 little holes, as can be seen on the testimony submitted titled ATF and Rising Threat of Ghost Guns, if you will refer to that. To review, a ghost gun is a do-it-yourself gun, but the kits that are sold don't require you to do much to make a firearm. This is like saying a Blue Apron food kit sold to your house is not food because it's not a finished meal. The actions of a non-specialist can transform the kit into a meal or here a gun, and to use federal definitions to argue otherwise is illogical, dangerous, and disingenuous. The 80% receiver is a misnomer as well, because while the final 20% of the work is minimal, the 80% that is sold encompasses not only the raw material, but a prepared material ready to eat, to revisit our prior analogy. This isn't even Blue Apron. This is a TV microwavable dinner, and yes, it looks, sounds like, and even tastes like a meal, just like an unfinished frame or receiver looks, sounds like, and even kills like a gun in the time it takes to prepare a meal. There are provisions for undetectable firearms as well in this bill, but those provisions are secondary to the importance of the common sense requirement of a background check for purchases of all firearm varieties and serialization. There is federal law in this space, but the language we provide is better and something local prosecutors could use in Maryland. There are at least 2 clarifying amendments the supporters of this bill are willing to accept, and it's fine with us. Those include removing reference to the penalty structure and allowing for common sense prosecutorial discretion and allowing serialization numbers explicitly on the registration equipment. With these clarifications and perhaps a few others, we believe the bill is not only ripe for action, but the language is nuanced for a variety of real life scenarios. The status quo, of course, is not the option. The background check loophole for ghost guns must be filled immediately. For these reasons, I respectfully request my wonderful colleagues vote favorably on SB 624 as amended. Thank you, Mr. Chairman.
Thank you, Senator Lee. We'll move on to your lead advocate, Mr. Levy. Mr. Levy, does this find you in New York?
Yes, sir, it does.
The benefits of the COVID session. Go ahead, Mr. Levy.
Thank you, Mr. Vice Chairman. Thank you, Senator Lee, members of the committee. It's good to see you again, if only virtually. Hope you're all well. I'm here today to urge you to vote favorably on this very important bill, a bill that would regulate ghost guns in the state of Maryland. As the senator mentioned, ghost guns are the fastest growing public safety problem in our nation when it comes to gun violence. They are turning up with increasing frequency at crime scenes, and it's no wonder why. These weapons are designed to subvert gun laws. They are a way for prohibited persons to access firearms they could not buy legally by passing a background check, and they are a way to stymie law enforcement investigations for those who want to use those guns to commit crimes, because again, by design, they are untraceable. Ghost guns are not the sole provenance of hobbyists. They are not a pastime. They are becoming a weapon of choice for extremists, gun traffickers, and prohibited persons of all stripes who the state of Maryland has taken great pains to prohibit from possessing firearms and who couldn't pass a background check if they tried. So I want to take a moment to define the scope of the problem. As the senator mentioned, the most pressing issue is firearms built from kits and parts that are available online without a background check. These are colloquially referred to as 80% lowers. This problem exists because of a faulty interpretation of federal law that's been in place thanks to ATF for a number of years. And I'm going to hold up, forgive me, I can't share, but the visual that the senator spoke about, an ATF ruling that draws a distinction between this item here on the right and this item on the left. These are both frames to be used to construct a handgun. In one instance, 3 small holes have been drilled and the rails have been filed down, and the other they have not. And due to ATF's failure to clarifying and make the point that these are both the same thing, these are both firearm frames, one is covered by federal law and one is not. One falls within the definition of a firearm and one does not. And that means one requires a serial number and one cannot be purchased without a background check, and the other can be bought freely with nothing but a credit card and no questions asked. And the work that has to be done here is de minimis. These parts and kits are sold as all-in-one operations. They will send you a jig that fits over the frame or receiver. It shows you exactly where to drill the holes. This work can be done with no expertise and readily available hand tools. Many of the kits involve the drill bits you need to drill those holes and finish these receivers so that they can then be built into an operable firearm. It is a market that is exploding. It is a market that, for context, 68% of sellers of these kinds of ghost guns and parts didn't exist in the year 2014. And now we live in a world where in California, 30% of all guns recovered by law enforcement are ghost guns. In Maryland, in the year 2019, ATF reported the recovery of 117 of these ghost guns, nearly a quarter of those in the city of Baltimore. The idea that, and again, as the senator mentioned, the change has been made this year to take a slightly different tack, which is to not prohibit these unfinished frames and receivers, but rather treat them exactly the way federal law treats finished frames and receivers. So they require a serial number and a background check, and they have to be traceable in the event that they're used to commit a crime. And again, that is a nod to people who enjoy that portion of constructing a firearm. If the drilling of those 4 holes is a significant difference, then now you can continue doing that. And I should make clear that it has no impact on hobbyists who want to build using finished receivers. Buying a frame or receiver of any kind that's legal in Maryland can be done easily with a background check and no additional cost and no additional work, and you can continue to build your guns from there. I do want to speak a bit about the process in the bill. Again, the premise is those who possess unfinished frames or receivers now, or have used unfinished frames or receivers to build an unserialized, untraceable gun, would have a better part of a year to comply with the terms of the law, have those items serialized to conform, or if they decided not to sell or transfer those weapons out of the state. And again, the process is clear and the process is simple, and the process treats unfinished frames and receivers exactly the way they're treated. Their finished counterparts are treated under federal law and the way they should all be treated, frankly, but for the ATF definition. I also want to mention briefly the other parts of the bill. One is a Maryland state analog to the undetectable firearms provisions that exist in federal law, which prohibits the manufacture of guns that are made entirely of plastics or materials that are undetectable by X-rays and magnetometers commonly used at airports and other secure locations. Again, the existence of this law will empower Maryland law enforcement, state and local, to enforce violations of that law, whereas now only the federal law exists. And finally, mention of disguised guns, again, guns that are more easily concealable because they're meant to look like cell phones or other things that you would not believe to be a firearm, which obviously poses a host of dangers for security and law enforcement in a host of spaces. How am I on time?
Time.
Oh, there you go. So thank you all for your time and consideration. I do urge a favorable vote on the bill.
Thank you, Mr. Levy. Perfect timing. We'll now go to David Puccino. Mr. Puccino, you're up.
Thank you very much, Mr. Vice Chair, and to Senator Lee and to the community for the opportunity to speak today. I am David Puccino, speaking on behalf of Giffords in support of SB 624. I'd like to first of all agree with and endorse the comments from Senator Lee and from Mr. Levy about the dangers that these weapons pose, precisely because they can be obtained without a background check, because they carry no serial number, and they require no record keeping or paperwork. I want to note that they are an increasing problem in Maryland. As Mr. Levy noted, there are over 100 of these have been recovered in 2019 from ATF, and we've had reporting that's more recent from both the Washington Post and Fox 45 News investigation. And both have reported spikes in ghost guns statewide and in Baltimore in particular. I also want to note the ease with which these products can be turned into fully functional firearms. They are sold, as Senator Lee outlined in her analogies, to be as easy to put together as possible while still avoiding federal regulation. That is what the sellers of these products design them to do. And so they do things like include plastic jigs that you put over the product that show you precisely where to drill out the holes. And as Mr. Levy noted, they also include, in many cases, the exact drill bits and other pieces that you need to put these things together. So it's really a process that's meant to be as easy as possible, even for people without technical experience. And in fact, there have been a number of instances where reporters and other people who don't have background and aren't particularly handy have been able to put these together in just a few hours. Finally, I'd like to highlight some of the changes that Senator Lee noted about how this bill would accommodate the interests of hobbyists and those who build firearms for recreation. First of all, there's a blanket exception for antique firearms, which is defined to include things like muskets and other flintlock weapons, and indeed any replica of a firearm manufactured before 1899. So this means it will not affect the scratch build enthusiasts who craft historically accurate rifles. There's another existing blanket exception for firearm frames and receivers that are serialized pursuant to existing federal law. So that means that if a firearm is, and a frame or receiver component is manufactured and sold through a FFL, a licensed dealer, it'll be exempt. So those individuals who have for decades now purchased and modified and customized their own weapons will be able to do so without any impediment. This bill targets a much narrower category. This is those people who are buying these incomplete parts from kits that are designed to be as close to a gun as is legally allowed without triggering any of the federal.
Time.
Thank you very much for your time, and I urge a favorable report.
Thank you, Mr. Puccino, and I apologize for mispronouncing your name earlier. We'll now go to John Herzog from the Baltimore Police Department. Mr. Herzog, go ahead.
Thank you. Good afternoon, Chairman Smith, Vice Chairman Waldstreicher, Senator Lee, and members of the Judicial Proceedings Committee. Thank you for allowing me to speak to you today about Senate Bill 624. So I just want to, and I'll be quick. I think that this is a really increasing threat to public safety in Baltimore, and I think the best way to illustrate that is through some of the statistics that we have. And so in 2019, we recovered 29 ghost guns in 2020, or in 2019, excuse me. And then in 2020, we recovered 126 ghost guns. And that's an extremely dramatic increase. We know that they are becoming more popular for criminals, prohibited individuals, and gun traffickers because they are easy to obtain over the internet, not difficult to assemble. And again, they're untraceable, as everybody's already referenced. And so some more statistics to show you how much they are being used by the criminal element are that in 2020, there were a total of 21 NIBIN leads. That's in linking cases through ballistics associated with ghost gun seizures. This indicates a 17% increase of ghost guns recovered that were directly linked to at least one act of violence through ballistic comparison. We also had 15 ghost guns that were directly linked to a homicide or shooting investigation, which we either recovered directly from the scene of the incident or as a result of a follow-up investigation. And also, our Southwestern District accounted for the largest volume of violence with 59 murders and 107 non-fatal shootings in 2020. And they led the city overall in recoveries of ghost guns with 26. In 2020, 29 of the 126, 23% of the polymer 80s were recovered from individuals under the age of 21. And that shows that polymer 80s or ghost guns, untraceable firearms, are falling into the hands of people who cannot even legally carry a firearm, purchase a firearm, or be in possession of a firearm. And I think most troubling was that the youngest person who we caught with a ghost gun was 14 years old. And so that shows that these guns are falling into the hands of criminals. And also, lastly, without a serial number, there is or any other identifying information. These firearms cannot be entered into NCIC if they are stolen, and therefore we cannot link them back to an owner to further our investigations to find out who is trafficking guns in Baltimore City. And so ultimately, we're not looking to infringe on hobbyists. This is about an avenue for the criminal element to have access to firearms and be able to get them over the internet and with very minimal effort to be able to put them together to use in crimes in Baltimore. And obviously, with 335 murders in 2020, this is a significant problem. So in short, ghost guns are a continuing problem in Baltimore, and the Baltimore Police Department would request a favorable report on Senate Bill 624. And thank you again for the opportunity to speak today.
Thank you so much, Mr. Herzog. We'll now go to Melanie Shapiro. Ms. Shapiro.
Thank you, Mr. Vice Chair, members of the committee. I'm Melanie Shapiro, the Public Policy Director with the Maryland Network Against Domestic Violence. MNADV is the state domestic violence coalition that brings together victim service providers, allied professionals, and concerned individuals for the common purpose of reducing intimate partner and family violence and its harmful effects on our citizens. And we are supporting Senate Bill 624. I would like to thank Senator Lee and all of the various individuals that have gone into drafting this version of the bill that has been introduced. Comparing it to last year, it appears to have taken into consideration many of the concerns that were raised regarding prior versions of the bill. And it's directed at extending existing law to a new type of gun. It is keeping current law current with today's world and technology. These ghost gun kits did not exist necessarily 10, 15 years ago. And so our laws must evolve to address this new do-it-yourself gun kit. Maryland is not alone in grappling with these issues. There were 18 state attorney generals, including Maryland's attorney general and the District of Columbia, who wrote an amicus curiae brief in support of a lawsuit that is currently pending against the ATF regarding the regulation federally of these ghost guns. Other states, including the District of Columbia, have enacted statutes to regulate them. As it pertains specifically to domestic violence, in the state of Maryland in 2020, there were 41 victims of domestic violence homicide, and 75% of those deaths were caused by a gun. We know that the risk of homicide for women increases by 500% with the presence of a gun in the home. The Fox 45 investigation has been mentioned by somebody. I won't repeat those numbers, but the one that I found most striking was that in that investigation, they found that more than 12,000 ghost gun kits have been shipped to the state of Maryland between 2016 and 2019, accounting for over $1 million in sales. And because of these guns are unserialized and untraceable, we don't know who has them. We have existing laws regarding prohibited persons. We have background checks, and none of those kits went to anybody who was subject to those. So for all of those reasons, we are urging a favorable report on Senate Bill 624.
Thank you, Ms. Shapiro. That concludes the testimony for those who are testifying straight favorable. We'll now move to those testifying favorable with amendments. Ms. Herron, you are next.
Thank you, Vice Chair Waldstreicher, members of the committee. I am Karen Herron, Legislative Director for Marylanders to Prevent Gun Violence. Our organization stands in support of SB 624 to regulate unserialized firearms in the state of Maryland. My colleagues have spelled out many of the reasons why this regulation is critically important, including the simple proposition that a failure to do so gives individuals a way of circumventing the protections that this body has put in place to reduce gun violence. I won't repeat those points. I do want to spend my time clarifying the amendment request to Section 5-704C4 detailed in my written testimony. It is worth noting that this legislation comes about with both the support of the sponsoring legislators and the collaborative efforts of national and state partners. The problem, in short, is that the current language related to record keeping is not strong enough to ensure that tracing will be enabled. So the bill specifies that the records be kept as required by federal law and regulation. While this language is intended to import the specific standards for record keeping that exist under federal law, this could easily be read as only applying where federal law already applies under the existing law and regulation. As interpreted currently by the federal government, there are no record-keeping requirements for unfinished frames and receivers. As drafted, existing ghost gun companies would still be able to continue to exploit the same loopholes their industry relies on to evade Maryland's record-keeping requirement, and thereby continue to sell untraceable ghost guns. The language suggested in my written testimony would correct the problem, and it has the added benefit of codifying the availability of these records to law enforcement. MPGV urges an adoption of this amendment and a favorable report thereafter of SB 624.
Thank you, Ms. Herron, for your testimony. We'll now go to Robert Hill. Mr. Hill, it's nice to see a friendly face. Go ahead.
Thank you. Good afternoon, Mr. Vice Chairman, and I also want to thank Senator Lee for all her work on this and many other bills that she's worked with us on. I'll talk about the amendment in just a moment, but I agree with Mr. Herzog and Mr. Levy and Mr. Pinnock. This is a growing problem. My office in 2019 prosecuted a man who had a virtual factory in his basement in the Four Corner area of Silver Spring, Maryland. His neighbors had no idea what was going on, but he was using kits to manufacture these guns, which of course did not have serial numbers. And he was selling the guns to criminals, people who were doing drug deals, people who were committing armed robberies, but there was no way to trace them. And, you know, they're still out there, a number of them, we still can't trace them. I think that this bill addresses in a balanced way the public safety concerns we have, along with the ability to allow hobbyists to continue to build and construct guns, but they will have to do so with serialized receivers and or guns. I wanted to bring up the amendment, and this bill, the legislation has passed in the state of California and in Connecticut, and there is a portion of this bill, the language of which appears to come from that Connecticut bill. It relates at the top of, or it's on page 13, and it relates to 5707B. And essentially what it does is it allows a court to order a suspension of prosecution if the court finds that a violation under this section is not of a serious matter, and that the person charged with a violation is not likely to offend in the future, has not previously been convicted of a violation under this section, and has not previously had a prosecution for a violation under this section suspended. The concern I have is it's a separation of powers problem. Basically puts a judge in the prosecutor's seat, which is the right to bring charges and to prosecute them. There are other mechanisms under Maryland law, namely the probation before judgment, where if a court sat through a trial and the person was convicted, and the court felt that this person was not a danger to the community, not likely to offend, and maybe the judge felt it was not as serious as the prosecutor thought, they could grant a probation before judgment. And the probation before judgment would then allow the person to go and have that offense expunged. So that safeguard is there, but the problem with this particular section is that.
Time.
Thank you. It's unfamiliar with Maryland law. Thank you for your time.
Thank you, Mr. Hill, and please give our best to the state's attorney. We'll now move to the unfavorables. Mr. Carlin Webb, there you are. You are up. If you could turn your camera on if possible and provide your testimony.
Good afternoon, members of the committee. Thank you, Vice Chair. I am Daniel Carlin Weber. I've testified you before similarly on this bill. And I do actually appreciate that there are some consolations and some things to take care of people who have been making their own guns all this time. I will object with some of the way that it's been described as if we're some sort of nefarious bad actor who just drills a few holes. But I will say that the requirements of the bill that are put upon people like myself who have made these firearms does not count into effect that there are 63 years worth of firearms that would need to be serialized and logged in a matter of time that's only a few months long. I heard it brushed off as the better part of a year, but we don't know how quickly these things pass. We don't know how well people are going to be educated on this sort of thing. That isn't trivial. There's 63 years of homemade guns that would need to be serialized in a very specific manner under the language of that bill. At minimum, the text would have to be at least a 1/16 of an inch high. You would have to engrave your full name, your full your city, the caliber of the firearm. All of that would have to be on the frame of the firearm itself. That is actually above what is required at the federal level. And again, this isn't a trivial process. While it might be easier for some people who have made their own guns to do this, if they have the right equipment, usually something like a CNC, that's a computer-controlled mill, and if they have the right tech, then yes, they can meet the specifications exactly. But someone who did just drill the holes, so to speak, they would need to find some sort of special engraving capability, or they would have to find a gunsmith who will even accept them to serialize their firearm in the prescribed manner. And that just isn't feasible for every single person out there. And if you fail to comply under the penalties of the bill, you're looking at a serious fine. And there are many people who have made many of these guns themselves, and the law is demanding that they serialize every single one of them with this very specific language, where they could have merely just put a serial number on it, something akin to what exists in California. But to close, I do not think that this bill is necessarily going to promote public safety, but it is a welcome change from what we had seen in the past, where the proverbial gun was put to every person's head who had made their own gun. So I do appreciate that there is less criminalization, but there's still too many penalties in this bill, and I think it is still too unweighted. I urge an unfavorable report. Thank you very much.
Thank you, Mr. Carlin Weber. Mr. Pennock, you're next.
Thank you, Mr. Chairman. Mark Pennock, I'm the president of Maryland Show Issue. You have very detailed testimony that I've written and include. I'd like to particularly direct the committee's attention to the attachment. So the trouble with this bill is that it includes far more than simply blower receivers that are drillable with 3 little holes. It includes this. This is a solid block of aluminum. It's a 0% receiver sold as such. I use it to illustrate this sort of bill, but I will tell you that on the literal language of the bill, I'm going to be penalized if I simply hold this after January 1, 2022. But the grading requirements, and you'll see this in the actual illustrated attachment to the testimony, the grading requirements actually go beyond those set forth in Title 18, Section 923I of federal law and the regulations. because it requires more than what you can reasonably put on an existing unfinished receiver that's typically purchased by many people. So it is actually inconsistent with federal law. But I wanted to address the scenario that State's Attorney Mr. Hill talked about. The guy was basically manufacturing these firearms in his basement for sale. I will tell you that is a federal felony. That is a violation of federal law that is a 10-year felony. So I'm willing to bet that every single one of the guns that were recovered in Baltimore and elsewhere that were ghost guns are already illegal guns, and the possessors of them are already prohibited persons who are already subject to federal felonies. This bill will do nothing to address that, because these individuals who are bent upon this sort of conduct can easily drive to Pennsylvania, Virginia, Delaware, and any one of many other states and procure all of this and bring it back into Maryland. If you want a solution to ghost guns, if you think there's a need for this, then you need to have federal legislation on this. And there's a whole bunch of litigation that was referred to already, in which certain groups are pushing the ATF to litigate that. But I have in front of you the testimony of some of that ATF experts as to what that would entail. I would urge an unfavorable report. Thank you.
Thank you, Mr. Pennock. We'll now go to Mr. Jocelyn. John Jocelyn, you are up. Go ahead.
Thank you, Mr. Vice Chair, members of the committee. John Jocelyn for 2A Maryland. As Mr. Pennock mentioned, his block of aluminum would be considered a firearm under the definition. 5101 R2 defines a regulated firearm as an unfinished frame or receiver. 5701J requires that unfinished frame or receiver would have to be included. It would be included with that block or any casting or anything else. It would have to have a serial number on it imprinted by an FFL manufacturer. However, to complete that piece, he would then have to machine it down. Machining it down would remove the serial number he's required to put on and put him in violation of 5-142A, which says that a person may not obliterate a serial number, which is a federal crime as well as a proposed state crime. In manufacturing sense, ladies and gentlemen, you can't get there from here. This is not a bill to address public safety. It's not a bill to address violence. It's a bill to ban firearms. By its very nature and structure, there's no way one can comply. We ask for an unfavorable report.
Thank you, Mr. Jocelyn. And the last to testify today in opposition to the bill is Mr. Spiker. Go ahead, Mr. Spiker.
Vice Chairman Walt Stryker, members of the committee, thank you so much. DJ Spiker, National Rifle Association, in opposition with asking for unfavorable report. We do thank some of the relief for the amendments that they have made from last year's legislation. As Mr. Colin Weber noted, there are considerable areas that has been improved, but we do have some concerns here. Would like to note there's a reason that very few states have gone into this area of the law. To date, there's only 5 states plus the District of Columbia who have gone towards this area of the law, because we're talking about a highly technical and difficult area of the law to understand, and for individual legislators and legislatures to go after this is a very, very slippery slope. It's a very highly technical area. The new administration certainly has just come in. We have, as litigation has been referenced previously, there's yet to be a new ATF director appointed, and we certainly think there could be changes on the horizon. And what we're seeing here is, unfortunately, any deviation away from federal law at the state level creates uncertainty. And with a new ATF director coming and the new administration, Maryland risks conflicting with new ATF law and regulation coming in. As Mr. Colin Weber and Mr. Pennock have noted, this, while it technically could allow possession, the burdens on the law-abiding individual, the hobbyists, and others who have constructed the firearm is now on them as opposed to previously. So it's 50 plus years of previously legal firearms would now be illegal. They don't take these burdensome standards. It's also important to note DC, when passing this in March of last year, has seen little impact. A perfunctory Google search will help you find that these guns are still popping up in DC despite an overarching and very stringent gun laws. This bill does not take the technology out of the marketplace. It can't do so. Lastly, our concerns with the undetected firearms. There are changes in technology. This is an ever-evolving thing, as you've seen with certain manufacturers, Glock and otherwise, who are turning to more plastic. Trying to regulate, again, in that very technical area is a very difficult thing for a state legislature to do. We urge an unfavorable report. Thank you so much.
Thank you, Mr. Spiker. I'm looking around the Zoom room and don't see any questions. Senator Castley, go ahead.
Thanks, Mr. Chairman. Just a quick question for Mr. Jocelyn, if I could, please. I think he's somewhere in all this kind of array. Are you unmuted, Mr. Jocelyn? Thank you.
Yes, I am.
I'm just trying to get to the bottom of the reports of ghost guns in Maryland and the numbers and sees. What's your understanding of the, I guess, first of all, of course, we have the dispute over what's the ghost guns, but do you know, what are the reported numbers that we've heard today and from previously? What's your understanding of where we stand on the numbers of ghost guns reportedly seized in Maryland?
For the past 2 years, 2019 and 2020, I have sent Public Information Act requests to 6 law enforcement agencies. While many of them did not respond, some of them did in fact respond. And Howard County reported that they had encountered 20 of them over a 3-year period. Anne Arundel County, that also responded, did not have any record of it. It's interesting to note that the responses I received in 2019 from the Baltimore City Police Department denied any knowledge or records of ghost guns. My 2020 PIA has not been responded to. The ATF trace report that was referenced with 117 ghost guns, I brought up that particular document, ran a word search on it, and the word ghost doesn't even appear. So I'm not sure where that data came from, but it didn't come from the 2019 trace report that's published by ATF. The report that was mentioned about ATF and ghost guns was in fact published by Everytown, not by ATF. So I think that we need to look at where it's coming from and what the point is they're trying to make. We really don't have solid information, and I think it's premature to elevate this issue to a crisis that needs to be addressed immediately.
Thank you. I appreciate it. And then I think I have a question for Mr. Pennock quite briefly also.
Go ahead, Senator Castley.
Thank you. I think he's unmuted. And so, Mr. Pennock, I'm trying to get it. So it's your, as I understand your testimony, that the nature of the process that's described in this bill is already subject to a 10-year felony. Is that right under federal law?
So it is against federal law to make these guns for sale. It is a 10-year felony already. So there is a whole process involved in that, which is enforced by federal law. U.S. attorneys all over the country enforce that. So it's with the person I was talking about is the individual that was manufacturing these for sale to criminal elements. It is a 10-year felony for a disqualified person under federal law. It's 18 U.S.C. Section 922G for a disqualified person to possess one of these. Indeed, it's a disqualified person possesses even the frame of 100% or 81% receiver. That is likewise a 10-year felony. So there are all existing laws that penalize these crimes very severely, including under state law. So you hardly need to penalize them further if you simply enforce what you have already. So the existing regulatory structure is responsive to the disqualified person problem, because if they're found with these, they go to jail. Now, the problem I have with this bill is they also designate unfinished receivers as regulated firearms, which now impose upon the state police a NICS check requirement that they literally is illegal for them to perform, because the way the state police now function on their regulated firearms, and this is a handgun, is that they're the source of contact with the FBI on the NICS system, and they run the NICS check. But the FBI has to make clear repeatedly, and this is true in the regulations that's cited in my written testimony, that they may not run a NICS check on a firearm that's not regulated under federal law. And the very premise of this legislation is that this is not regulated by federal law. So the state police simply may not conduct this investigation by doing a NICS check. They're relegated to using in-state databases, which is, of course, is a very faint background check compared to the nationwide NICS check that the FBI performs. So by forcing the state police to treat these as regulated firearms and getting a handgun qualification license for doing so, you impose all these costs on the state police to no avail, because they really can't do the job that they normally would do for a handgun. So the fiscal note, I know, doesn't include this in terms of the costs associated on the state police. But the background check is expensive, and which is something that now, under this bill, will now have to conduct on a truncated basis. I mean, the FBI check is the cheapest part of it. The state police conduct 17 background databases in the state, and that's still incomplete because they can't do a NICS check. So they don't understand how this works with existing state law by calling it a regulated firearm. It brings in section 5-117, section 5-117.1, the handgun qualification license, and section 5-118 in the application process. So that hasn't been well thought through in this bill. So there are all kinds of legal things that they've missed. Now, nobody here wants to have disqualified people having firearms, at least they're all guns that can't be traced. But you need to bring this into the existing regulatory structure to understand whether this is actually responsive to that problem. And it's not. All it does is end up penalizing the people who do this as a hobby, because they do try to comply, and the serializing requirements are impossible to comply with on most of these polymer frames, for example. Now, you can serialize my block of aluminum. That's not a problem. But Mr. Jocelyn is quite correct about that, because by the time I mill that down to an actual lower receiver, which it takes a $30,000 machine to do, I will have obliterated whatever serial number I will put on it. So I have to reserialize it, I guess. But that's kind of pointless too. So it hasn't been well thought through. Now, I appreciate the efforts. I appreciate the fact that they're no longer just criminalizing everything because it recognizes legitimate purposes of a hobbyist, but still not there yet. That's where I am on this.
Let me just keep it one second. I'm right back up. All right, Senator West.
Thank you, Mr. Vice Chair. Sorry to interrupt. I guess Senator Lee, I hope the Vice Chair is in a position to unmute you. Well, let me give you my question, then we'll try to pursue unmuting you. So I'm going to read just a portion of Mr. Pennock's testimony, and I want to ask your reaction to it. The bills require that existing owners of perfectly legal lower receivers or frames mark these with markings that includes that model, caliber, the full legal name of the owner, his city, and that these markings be conspicuously and permanently etched or engraved or cast. Federal regulations require these markings to be a minimum depth of 0.003 inches and a print size no smaller than 1/16 inches. Then he continues and he says it's the average owner has no way to make sure that these requirements could be met. So my question to you is, have you considered putting a grandfather clause on this bill? There's been testimony that 50 years of firearms are going to be rendered illegal if this bill is passed. Wouldn't it make sense to grandfather in all the firearms that have been made by amateurs like Mr. Carlin Weber up until now, and only have this bill apply prospectively? And now we need to worry about getting you unmuted. Mr. Vice Chair, are you nearby?
Senator West.
Yeah, okay, Senator West, no, I don't think you should grandfather. And also manufacturers, they can't make the label, but they can make the gun.
Yeah, my point is you've got 50 years of people who own these weapons that have been manufactured over the past 50 years isn't this bill going to make them all criminals? I guess unless they throw their guns away.
No, I don't think so. I don't think it's such an overburdened step to take in order to ensure that these guns can be traceable if they are,
Well, let's assume that let's assume I had bought a gun from Mr. Carlin Weber 5 years ago, and it's sitting somewhere in the closet or in a display case in my house.
You want to serialize it.
How in the world would I go about, if this bill is passed, how would I go about trying to put on the gun in 0.003 inches deep, all this
Senator Bress,
information?
I think that scenario is illegal under federal law, but I think Sam Levy can explain that a little bit more in particular. So I'd like to let Sam.
Fine, let's turn to Mr. Levy.
Thank you.
Senator Russ, good to see you again.
Good to see
So a couple of clarifying points, one that goes to some previous testimony and the basis of your question. ATF regulated these things till about 2006. So we're not quite talking about 60 years of unserialized, unregulated parts. But I take your point. For the time that they've had their faulty regulation, there is a world in which these weapons exist, and the technology exists, right? Gunsmiths and dealers serialize firearms all the time. The testimony provided by Mr. Pennack, I believe, talks about one of those gunsmiths who offers the service, and he makes claims about what it would cost, and I appreciate that. But yes, how do you grandfather these things without someone? How do you enforce that? You know, it would require registration of all those parts, proof of possession, and I know how you and counterparts on the committee feel about that sort of process. It also would hamstring attempts at enforcement, right? I've heard the points made about federal law exists and the ATF and the FBI can enforce those laws, and that's well and good. But if you don't have a state law that prohibits these things, your attorney general, your state and local law enforcement are powerless, and you can't stop the supply, and that's the problem. So the ask, to your point, no one's asking these people to throw their guns away. We're asking them to take reasonable steps to ensure that their firearms are serialized in exactly the way federal law requires. And the reason federal law doesn't require a name and a city is because those guns are manufactured within the chain of production through licensed manufacturers, licensed importers, and licensed retailers. So they can just use a serial number because those serial numbers are by law reported to the ATF and traceable when those guns are used in crimes. So
well, let me come back to my hypothetical then. So I acquired a gun, a handsome looking homemade gun by Mr. Carlin Weber 5 years ago. And it's sitting in my house somewhere in a display case because it looks so good. So if this bill passes, what would I be required to do? Where would I go? And how much would it cost me to comply with the bill?
you could, again, attempt to engrave it yourself if you had the equipment. If you were,
I don't have the equipment.
Fair enough. You could take it to a federally licensed firearms dealer, right, or manufacturer, and say, I need this information engraved on the gun to comply with the terms of state law.
And do they do that? Are they easily found, and do they do that for private citizens?
And Mr. Pennack's testimony includes one FFL who provides the service. He said it's $45 in some instances. If there's more characters or information that's needed, it might be more than that. But I've never, provided that service, so I couldn't tell you the exact cost.
Okay, let me turn to Mr. Pennack then. Mr. Pennack, Mr. Levy has indicated that if I have a gun on display like that in my house, I could easily find a licensed firearm dealer who could do the work for me for $45. What do you say about that?
Senator, I don't think that's accurate, and I'll tell you why. This requires some very expensive engraving equipment to meet the requirements of Section 923. And the attachment to my testimony illustrates this bill, contrary to federal regulations, requires more than what you can fit on some of the plates that are on the lures that are being governed by this bill. You cannot literally fit and comply with federal law, Section 923 regulations, all that information in the plate involved. And the number of FFLs, this is not covered FFLs, by the way, of which there are hundreds in Maryland. This is only manufacturers and importers are allowed to engrave this information. I know of one manufacturer in Maryland, that's the Engage Armory, who has give us the written testimony attached to my bill. There are two manufacturers of firearms, LWRC, and I think one more in Baltimore. I don't know of any others. So you would have to find a smith with a $7,000 machine minimum who's willing to do it and be able to comply with Section 923 and the regulations on information that you can't fit on it on a lot of these bills, on a lot of these guns. So
Oh, go ahead. Go ahead.
And that's the problem. This bill goes beyond the section 923 regulations by requiring more than what the regulations themselves require.
Okay.
Original
So I started out with this line of questioning by saying, isn't there any way we could do a grandfather clause that would exempt people who currently own these weapons and only apply the bill prospectively? Do you, in your opinion, would such a grandfather clause be workable?
Well, yes, because then people would be on notice as to what they would have to do in the future. And the bill already encompasses future acquisitions, which literally require basically a manufacturer or an importer to provide the serial number already. And that's then on their problem that they can do that because they have the equipment and the expertise necessary to do that. But
Okay, last question to Mr. Colin Weber. If this bill was only applicable prospectively, and there was a grandfather clause which protected people like my hypothetical situation where I acquired a gun 5 years ago from you, would you, in your future amateur efforts to, as your hobby to create these guns, would you be able to comply with the measures of this bill prospectively? We need to unmute Mr. Colin Weber, I'm afraid. Sandy, can you unmute Mr. Colin Weber?
Thank you very much. And Senator West, it's good to see and converse with you again. If I remember correctly, we've talked about this very issue the last two or 3 years or so.
Right.
Yes. And each time you have asked if I think that if I could comply with sort of thing, would I comply with sort of thing? In this instance, I think so, yes. Again, asking that someone serialize something versus go to jail, well, the choice is obvious there for someone who means no harm to others. But I will contend, I heard that this does not apply to those firearms that one made themselves, rather the kits. And the text of the bill doesn't say that. Under 5.703, under 5-703A, on or after January 1st, 2022, a person may not continue to possess a firearm or an unfinished frame or receiver that the person manufactured or assembled and lawfully possessed before January 1st, 2022. And then it prescribes the very complicated method of serializing or engraving or marking those homemade firearms. That is because the bill exempts firearms prior to 1968, that is 63 years worth of guns that would have to be serialized in this very specific manner. It's not merely a polymer 80 kit or an 80% receiver. It's any homemade manufactured firearm.
Okay, thank you everybody for your answers to my questions.
All right, thank you. Any further questions from the committee? All right, seeing none, that completes the hearing for that bill. Now, Senator West, I believe you are next with the Juvenile Justice Restoration Act.
Thank you, Mr. Vice Chair. And this is an important bill, which I'm enthusiastic about presenting to the members of the committee. First, permit me to proudly acknowledge that both Senator Sidner and Senator Carter have joined me as co-sponsors of this bill. It's always a privilege, and I might say sometimes an unusual privilege, to work alongside Senators Sidner and Carter on important legislation like this. Senate Bill 494, the Juvenile Restoration Act, affords reasonable protections to minors who are convicted as adults. First, the bill provides that mandatory minimum sentencing requirements do not apply to minors. Second, the bill states that a court may not impose on a minor convicted as an adult a sentence of life imprisonment without the possibility of parole or release. I think we just dealt with a bill that covered that yesterday that Senator Kelly introduced. So that provision is a little tiny part of this bill. Finally, the bill provides, and most importantly, the bill provides to an inmate who was convicted as an adult for an offense committed when the inmate was still a minor and who has been in prison for at least 20 years, an opportunity to file a motion in the sentencing court seeking to reduce the duration of the inmate's sentence. A judge may not modify the sentence unless the judge finds, after a hearing, that the individual is not a danger to the public, and that the interests of justice will be better served by a reduced sentence. This bill carefully protects the interests of both the state and the victim. The judge will be required to hold a hearing, where of course the state will be represented by the state's attorney. The state's attorney will inform the victim of the family or the family of the victim of the motion, and will extend to either the victim or the victim's representative an opportunity to be heard at the hearing. At the hearing, the bill provides that the court will consider quite a few factors before reaching a decision. Among them are the inmate's age at the time of the crime, the nature of the offense, the extent of the inmate's role in the crime, and whether and to what extent an adult was involved in the crime, the history and characteristics of the inmate's family and community circumstances at the time of the crime, including any history of trauma, abuse, or involvement in the child welfare system, the behavior of the inmate, which in confinement, whether the inmate has completed an educational, vocational, or other program, whether the inmate has demonstrated maturity, rehabilitation, and fitness to re-enter society and abide by our laws. That's a long list of factors the court has to consider. I think that's everything that seems relevant to me that a court should consider. The decision of the court must be in writing and must explicitly address the factors that I just listed. In the event the court denies or grants in part the motion to reduce the sentence, the inmate may not file another motion to reduce sentence for at least 3 years. In the event that a second motion should be filed and is denied or granted in part, once again, the inmate might not file another motion for another 3 years. And after 3 tries, the inmate is precluded from filing a fourth motion. So the court won't have to deal with these motions again and again and again every 3 years. Any human being who reaches his 37th birthday is a different person than he was at the age of 17. Quite literally, he's a different person because all the cells in his body when he's 17 have died and been replaced by new cells. But beyond this, a person's brain doesn't fully mature until he's 25 years old. And with maturity comes different thinking, different attitudes, and a different approach to life. If we were to reflect on our own lives, I'm quite sure that at the age of 37, we would look back at our lives at the age of 17 and conclude that a lot of changes had occurred in the meantime. The opponents of Senate Bill 494 are going to argue that if this bill is passed, there will be no finality for the family of the victim, that it will never be over. They will claim that if this bill is defeated, the victim's family will achieve finality and will be able to live the remainder of their lives secure in the knowledge that the perpetrator of the crime will never be released. But this is not the case. Consider all of the post-conviction options available to a prisoner right now. Many of these are merely remedies that are available shortly after the trial, but some of them are available as the years pass. Most significantly, the first parole hearing of a convicted felon is set as early as 11.5 years after his incarceration. And if he's not successful at that hearing, he can return over and over as the years pass and ask the parole board for relief. The only way to truly achieve finality for the family of the victim is to eliminate all possible post-conviction remedies and literally lock the prisoner up and throw away the key. As a society, we try to be just and merciful, and just locking people up in every single case and throwing away the key is not what we do. It's not who we are. Of course, the victims have rights. They're notified every time a prisoner applies for relief, and they have the right to be heard by the reviewing authority. And as embittered as the grieving families are, I suspect that in some cases, they have the capacity to hold out the hope that the person who committed an atrocious crime against their loved one will see the light and will transform himself into a different, better person. Thus, Senate Bill 494 will provide an opportunity for people who have committed crimes when they were 17 years old or younger, and who have served most of their lives, over half of their lives behind bars, to appear before the sentencing court and ask the court to consider whether they have so reformed their lives that they should be released from jail because their continued incarceration is no longer necessary for the protection of the public. People can change. Redemption is possible. When that happens, as a society, we should rejoice. Keeping someone in prison who committed a youthful crime and who has spent decades in jail, but has transformed his life and is no longer a threat to society is hard to defend. Now, there are some amendments proposed by both the Attorney General and the Maryland State Bar Association, which seem logical and reasonable to me, and I will be appreciative if the committee would take those amendments to heart and add them to the bill. And with that, I hope the committee will issue a favorable report on this bill.
Excellent. Thank you, Senator West, and thank you for bringing this bill before us. It's obviously a very important issue, and I've enjoyed working with you and getting to learn a little more about this. So thank you for this. So you have as your primary witness, Ms. Feldman, and Ms. Feldman as the primary witness. Good to see you. You will have 5 minutes. The floor is yours.
We need to unmute. There we go.
I've asked to unmute you. Let's see.
Oh,
There you go.
okay. Thank you so much. Good afternoon, Mr. Chairman and members of this distinguished committee. My name is Becky Feldman, and I am before you today to testify in favor of Senate Bill 494, the Juvenile Restoration Act. You guys may remember me from last session, but I spent the majority of my legal career as a public defender, advocating for shorter sentences for persons serving very lengthy sentences in Maryland. I managed the Unger litigation, which resulted in the release of 200 inmates from maximum and minimum security prisons back into Maryland communities with less than a 4% recidivism rate. Now I'm at the state's attorney's office for Baltimore City, creating a new unit where what I'll be doing is reviewing these older cases of juveniles and geriatric inmates and determining whether we think that they are safe to be, whether they can be safely released back into our communities, and whether there's a viable legal mechanism to make that happen. And usually there is not. Under the current Maryland rule, the sentencing judge may review his or her original sentence if the defendant filed that motion within 90 days of sentencing. The motion expires after 5 years. And in nearly all of these older cases that we're talking about, the modification was not filed or it has already been denied. So other than the parole board, after 5 years, the sentencing judge and the state's attorney are presently without a legal mechanism to review whether the continued detention of any incarcerated person is appropriate. And of course, there's appeals and post-convictions, what Senator West was talking about, and those go to whether the conviction was constitutional. It's not a review of sentence. So this bill would allow courts to revisit their original sentence after a juvenile has served 20 years and determine whether that sentence should be reconsidered in light of the many factors outlined in the bill. We are in the midst of a public reckoning with racial justice and mass incarceration in our nation, and also in Maryland. We need to deal with the painful truth that we often choose lengthy incarceration over rehabilitation, and that we just incarcerate people for much too long. Maryland has earned the embarrassing distinction of incarcerating more Black people than any other state in the nation. More than 70% of our incarcerated population are Black, which is more than double the national average, which is 32%. The states that follow are Louisiana, Mississippi, New Jersey, and Georgia in that order. Maryland also has a significant geriatric population. Over 1,100 inmates are over the age of 60. 500 have served more than 20 years. Oh no, my battery's running low. I'll talk faster. Nearly 100 have served over 40 years. So the current parole process is not enough. And I don't want this bill to be viewed as a runaround parole or a parole substitute. What it is a review 20 years later by the sentencing court that is sorely needed to ensure that the continued detention of a juvenile offender is appropriate. Under this bill, victims or victims' representatives will be given the opportunity to participate in the process. I understand that for some it will be painful to come back into court 2 decades later to talk about how the crime has affected them. I understand those feelings. I am in the strange and unique position to say that the person who pulled the trigger and killed my brother 20 years ago will be able to request a review of sentence if this bill passes. It was 20 years ago where my brother was shot and killed in Baltimore City. One of the offenders was 17 years old. And I still support this bill without reservation because it's the right thing to do. Since being in this office, I have had the opportunity to contact victims and ask them, how are you feeling? Where are you all these years later? Because I've been looking at these 30, 40-year-old convictions. And I've gotten the full range of responses. I've gotten what we expect, which is, I absolutely oppose any type of relief for this individual. Most of the people were somewhere in the middle where they felt what I would call neutral, which is, it's been a long time, I've moved on, and I don't want to participate in the process. And then I had a couple victims who said, oh, is he still in there? I actually run a reentry group. How can I help him? You know, and I had another one that said, I forgive him. We were both kids at the time. So, you know, I use that example just to explain that grief and redemption is very complicated and complex. And I can only speak for Baltimore City, but what we will be doing is linking victims up with rehabilitative services and providing them with the opportunity to time? Oh my gosh. Okay, I'm so sorry. I just wanted, okay, so let me just say thank you for this opportunity, Senator West. And this is an opportunity for Maryland to show real leadership in juvenile justice reform and mass incarceration reform. Thank you.
Excellent. Thank you, Ms. Feldman. Always good to see you. And thank you for sharing your story and your perspective. I know you've been in the your new role for, I guess, a couple months now, right? So thank you and good luck with in your new role.
Thank you.
And I'm glad your battery didn't run out. All right. So with that, we'll move on to the next witness. We'll just go in order. So Mr. Ellis, good to see you. You're up next.
Good to see you. Good afternoon, Chairman Smith and committee. My name is Eddie Ellis, and I'm a resident of Montgomery County, Maryland. And I work for the Campaign for the Fair Sentence of Youth, where we lead and support campaigns to ban life without parole for children and other children who have extreme sentences. I joined CFSY as the Incarcerated Children Advocacy Network Coordinator in 2018. And in that role, I work with over 140 ICANN members in 26 states, including the District of Columbia. And these ICANN members, men and women, are former life sentence children or children who were sentenced to other harsh sentences. I also work with other directly impacted communities, including the family members of juvenile lifers, survivors of violence, etc. At the age of 16, I was arrested and charged with murder, later found guilty of manslaughter and sentenced to 22 years in prison, where I served 15 years in prison, 10 years in solitary confinement. I came home in 2006, and since that time, I have worked on various issues, including reentry, solitary confinement, bridging the gap between the community and law enforcement, bullying prevention, and I've also worked on behalf of people with disabilities who are in the system, because I am someone with a disability, and I'm also a proud father and husband of 3. On August the 24th, 2021, it will be my 15th year home. And all that I've done since I've been free is be a part of change in the community. And there's so many others that are still incarcerated in the Maryland prison system that should be allowed to have a second chance and a review to give themselves a chance of freedom. This bill does not open up the floodgates for people to walk out of prison, but this bill will allow them to get a review in front of a judge, and that judge will decide if that person has rehabilitated themselves or not. The legislation will bring Maryland in line with recent U.S. Supreme Court rulings and 24 other states and jurisdictions, including Virginia, West Virginia, and the District of Columbia, that have passed similar legislation abolishing life without parole for children. When a person can demonstrate rehabilitation, we must give them an opportunity for a second chance. And this legislation takes an important step towards these things. If I would have never gotten a chance to come home, I would have never been able to do the things I've done since I've been home for almost 15 years now. I respect and taking, full responsibility for my actions at 16 years old. Someone lost their life. And I live my life in a way to be representative of myself and my family first, but also my victim and his family. And there's so many others who are in prison, if given a chance, would do the same. So I would end with saying that I ask for favorable report for this bill. Thank you.
Excellent. Thank you, Mr. Ellis. I see that I didn't see you earlier, so my apologies. I see our state's attorney from Prince George's County is here, so I'm going to skip over. I'm going to grab her first. So, Madam State's Attorney, you're up next. And I know that you have a busy day, so we'll get you in and get you out of here. So, the floor is yours.
Thank you so much, Mr. Chair, Mr. Vice Chair, and members of the committee. For the record, I'm Aisha Braveboy, State's Attorney for Prince George's County, here to support Senate Bill 494 with an amendment, and the amendment only addresses the issue of notification to victims to ensure that there's a mandated notification provision for victims included in this bill. But other than that, let me just say that Mr. Ellis, and I'm so grateful to testify right after him, is the reason why when I was elected state's attorney, I decided to have a conviction and sentencing integrity review unit. It is the first of its kind in the state. Baltimore City, I'm so grateful that they have also recently created such a unit. But this unit does review cases of juvenile lifers and others who may have been disproportionately sentenced. So far, we have had 9 individuals either supporting them through the parole commission or through the court system to be released. But the mechanism to get in these individuals before the courts is unclear. And certainly if you don't have a state's attorney willing to support and join in on motions for reconsideration, it is nearly impossible to get these matters considered by the courts. It's really important that we have an opportunity for redemption in our justice system. And to think that someone like Mr. Ellis would have spent 22 years in prison, that's really a lifetime for people. Today, the very first individual who we got through got into our reentry court process, who's been released for about a year now, had his final hearing before reentry court, where everyone talked glowingly of his progress. He's going to be a great member of our community, and he's already touched so many people's lives, but he wasn't able to really fully enjoy his life behind bars. And now he has an opportunity to do both. And that's what this is really all about, this opportunity for individuals who were 15, 16, 17, when they committed their offenses, yes, very serious, but they were children. And current brain science tells us that children behave, think, and everything else differently than adults. And so it's really about giving them an opportunity to prove that they have been restored and that they will be productive members of our community. And so my office and I am personally committed to this issue, and I hope that this committee will give all juvenile lifers around the state the same opportunity that I've been able to give juvenile lifers in Prince George's County. Thank you so much for your consideration.
Excellent. Thank you, State's Attorney. So always good to see you. Thank you. Next, we'll have Mr. O'Day. You are up next. How are you?
Thanks, Mr. Chair. Nice to see you, members of the committee. Thanks for your time today. I'm Garrett O'Day for the record for the Maryland Catholic Conference here in support of SB 494. We're here in support of this bill consistent with years past with our friends from the Campaign for Fair Sentencing of Youth. And I'm also here as an affiliate of the Maryland Youth Justice Coalition, representing them as well. And thanks to Senator West and Delegate Lewis for, in a bipartisan measure, really sort of melding 2 efforts together from last year. And from our faith perspective, the church supports elimination of sentences of life without parole. And the teaching of the church is one with what the Supreme Court has recently ruled that our Constitution requires. So as I said in the House side, you've already, and will, I'm sure, hear the case law cited as well as throughout the testimonies on this bill, in support of this bill. The Graham decision, the Miller decision, and Montgomery decisions really over the last decade or so. So I'll cite Pope Francis, who has labeled such life sentences as a death penalty in disguise, and expressing our position that sentences of life without parole in this instance with regard to juvenile offenders are devoid of hope. And we thank you so much for hearing us on this bill today. We hope that you'll vote favorably for it.
Excellent. Thank you very much. Good to see you as well. I know you're muted yourself, but good to see you. All right, next we'll have Mr. LaRuffa. Are you here?
Yeah.
There you are. You're up.
Thank you. My name is Paul LaRuffa, and I am a survivor of violent crime committed by a juvenile. Very quickly, in one sentence, in 2002, I was shot 5 times by a 17-year-old boy and left for dead. I'm here today to express my support for SB 494. That means I want to address some common opinions and misconceptions that I think Senator West said, but I'd like to reiterate. Not all, I'm trying to be an example that not all victims of violent crime are in favor of life without parole. And I am one of them, and I know more people who were affected by violent crimes that are also in favor of this. A couple of other things that I've run into about this bill is the misconception that, and I think Eddie Ellis mentioned this, it's not a guarantee. There's nothing guaranteed in it. It does not eliminate punishment for a crime. It doesn't eliminate personal responsibility of the perpetrator. In my view, SB 494 is a realization that children who commit crimes are not miniature adults. They are different. There are numerous medical and psychological studies that show teenagers' brain itself, as well as their character and judgment, are not fully developed. Children do not weigh the consequences of their actions. They act impulsively. They act on emotion rather than reason. But most importantly is that children have a profound capacity for rehabilitation and positive transformation. I've learned that basically a life without parole sentence for juveniles condemns them to 50, 60, or maybe even 70 years of a life without hope. Bills like SB 494 basically provide for the possibility, the chance, the second look, the chance at freedom and re-entering society after serving time, meeting certain requirements and standards. It provides hope for teenagers who face the fact that he or she has been condemned to die in prison. I've been privileged to meet and speak at length with people who committed crimes as teenagers, like Eddie Ellis.
Time.
Okay, and it's been a great experience, and people like Eddie Ellis are an example of this bill works. Thank you.
Excellent. Thank you very much for your testimony. We'll now move on to Ms. Williams. There you are. You're up.
Thank you. Good afternoon, Chairperson Smith, Vice Chair Waldstreicher, and members of the committee. Thank you for having me. My name is Carrie Williams, and I'm here on behalf of the Attorney General to ask that this committee adopt 2 perfecting amendments to Senate Bill 494 and then issue a favorable report. We're asking that the committee amend Senate Bill 494 to require proof of victim notification, or at least an attempt to notify the victim, before a hearing on a motion to modify under this bill proceeds. We're also asking this committee to amend the bill in order to explicitly allow the state to enter evidence at a motion to modify pursuant to this bill. With these amendments, we believe that Senate Bill 494 strikes the appropriate balance between public safety and allowing inmates who were convicted as juveniles to demonstrate rehabilitation. By providing a list of factors for the reviewing court to consider, the bill ensures that all relevant circumstances will be considered when evaluating a motion to modify. With the amendment requiring victim notification and explicitly allowing the state to admit evidence at a hearing, the bill will ensure that the court has information from all of the relevant parties. By requiring that the inmate serve 20 years before being eligible to file a motion to modify, The bill ensures that an inmate who files a motion for modification has already served a substantial sentence and has had an opportunity to demonstrate true rehabilitation. But even then, the court will have to determine that the inmate is not a danger to society and that justice will be served by reducing the sentence before granting the motion to modify and ordering that the sentence be modified. Finally, the bill would prohibit courts from imposing life without the possibility of parole on defendants who committed the crimes that they are convicted of when they were under the age of 18. And it'll give the courts flexibility when imposing a sentence on a juvenile that's been convicted of as an adult by not requiring the courts to impose the mandatory minimum sentence that might otherwise apply. The Attorney General urges this committee to adopt the suggested perfecting amendments and issue a favorable report on Senate Bill 494. Thank you very much.
Thank you, Ms. Williams, and good to see you. All right, so next we'll go, I think that concludes the testimony for the proponents. We'll now switch over to the opposition panel, and Mr. Schellenberger, you're up first.
Thank you. So several years ago, I sat in the JPR committee room and I said these words: when you get rid of the death penalty, you mark my words, we will be back here again, and next thing you know, it will be an assault on life without parole. And here we are again. As soon as the death penalty went away, they started attacking life without parole, and we've been here and we're going to keep coming here because every time you set a maximum sentence, they want that sentence to now be lower. So please remember, someone asked me to tell you the facts of the Ben Garris case since I only have a very short period of time. But most importantly, I hope you look at my written testimony. There are already 13 post-trial rights that all these defendants have. 13. All but one is even if you plead guilty, you have a right to ask for 12 different things from the court. That means 12 notifications to the victim's family. That means time and time again, the victim's family is being notified, and I appreciate that we're going to notify them again on this occasion. But remember, Senator West, it's not one notification, it's not two notifications, it's not three, it's 3 notifications. So we're now up to 15 notifications that the victim's family could get in each case. And please remember, Officer Amy Caprio was murdered in cold blood by 3 juveniles who committed felony murder. Guess how many more hearings the Caprio family will have to go to 20 years from now? 12 more hearings. 12 more hearings. When does it end? And impressively, even Dante Harris didn't get life without parole. He got life for running over Amy Caprio. But again, there's going to be 3 more hearings. There were 3 co-defendants who are going to be in for more than 20 years. So in addition to those 13 things they can do, 12 more hearings. When does it end? And mark my words, if you get rid of life without parole on this, we're going to be back again, and then they're going to take care of life. So with that, I urge an unfavorable report.
Thank you, Mr. Schellenberger. All right. Next, we'll go on to Mr. McAvoy. You're up.
There we go. I'm muted. Thank you. I appreciate it, committee. I'm going to try and keep it brief, but we talked about redemption. That's not listed as one of the 5 purposes of jails. Rehabilitation, Senator West mentioned. What about deterrence, incapacitation, retribution, restitution? And I'm sorry, but the essays took my thunder on the Maryland's proclivity. These things aren't done in vacuum. They're progressive. Proclivity for, as Governor Hogan termed it 2 years ago, a lawless agenda. I want to quote a newspaper article in the news right now, which puts it in the context of which we're looking at this. 2020 a perfect storm for homicide surge. In 29 of 34 major American cities, criminologists observed an increase in homicide rates last year. They say is likely. Urban violence is perpetuated by a small number of high-risk individuals, and they drive a disproportionate amount of violence in a city. And so what I'm trying to say is we've already had all these exceptions made to not have these children charged as adults, and yet the judge has gone forward and charged them as adults. So even though we're saying the brain's not the same, the judge has determined they're adults. They're acted as adults. Their crimes were that heinous. We know who they are. They're facing a sentence, and now you want to release them. There's a small number. If we stop the small number, it stands to reason just by that article that we are curtailing our crime exponentially by stopping those most violent. We didn't get here from someone just beating up somebody on the way home after work. People are shot, killed, raped. These are heinous crimes. And each year the legislature tries to remove issues from them, from that list. So we have really honed this down to just the worst of the worst. So I urge you to go with an unfavorable on this, not just on this, but all these. Look at where we are with crime in this state and this nation at the time. This is just not the time. I do thank you, committee, for listening.
Thank you, Mr. McAvoy. And with that, that'll conclude the testimony for Senate Bill 494. We'll now switch over to the panel for questions. I saw Senator Carter first, then Senator Castley.
Thanks, Chairman Smith. Thank you, Senator West, for leading on this bill, and you, Senator Sidnor, for the past work that we've done on this over years. I want to say that, in my opinion, Maryland is slow to address this issue. Thank you, State Attorney Braveboy, for your efforts on this as well. I recall all the way back, I think it was 2016 or 17. No, it had to be 16 because I was not in the legislature in 2017, when similar to your testimony, Mr. Ellis, we heard from Christopher Wilson from Baltimore City, and we heard from Xavier McElwith Bay, who works with the Campaign for Fair Sentencing of Youth. I believe he did it anyway. And these are two people who, quite frankly, committee, Chris Wilson's accomplishments since being released probably far surpass most of us here. I know I can speak for myself. And Xavier has dedicated his life to their sentencing. I just wanted to say that I have a lot of emotional feeling about this bill, because as the campaign often says, we're all so much better than our worst act. And I know that for me, I'm glad that I'm not held to account for all of my acts, not just up till the age of 18, but probably even until recent years. So with all of that said, Mr. O'Day, it's been stated that there's a number of different states that have moved forward after the Supreme Court decisions in revising their sentencing policies for youth charged adults. And I wanted to know if you could speak to and elaborate on the policies in those states and how that's been working. Has there been any downside that you can speak to with states that have revised their sentencing policies and even offered the opportunity for review that this bill offers?
Thanks, Senator Carter. If you don't mind, I'd actually like to defer that to either Eddie or Paul, because they do work sort of nationwide and would have the more up-to-date information on that.
That's fine.
Thank you. Thank you for the question, Senator. Well, we work around, as you know, we work around the nation, and Xavier is our co-executive director now, an ICANN member, but Chris Wilson is also an ICANN member. But around the nation, everything has really been positive with juvenile life assessment come home. Look at Philly, for instance, they have a 1% recidivism rate. We work very closely with their population and other population. Like I said, our ICANN members are in 26 states and the District of Columbia. So we had a positive result with people coming home. People are feeding community with food, giving out PPEs. People have their own organizations. People are giving back to different organizations. People are working with victim organizations. People are doing a lot of different things in their community. And that's the only way that we allow people, to be honest, to be an ICANN member, that you are showing these positive, attributes, and you're giving back in a way that's positive and constructive to the community. But overall, this population of juvenile lifers, they are less likely to recidivate opposed to other populations of people. They're more older, they're more mature, and when they come home, they're going back and trying to get a life, or find out what a life looks like after all these years. And if you look to Philadelphia, God has came home doing 68 years as a kid. He's older than my mother. He's older than my mom. So the thing is, it doesn't take those many years to prove that you've changed. And I'm an example of that. I did 15 years. This will be my 15th year home. And I'm proving that it don't take us that long to change for those of us who are changing. And it doesn't take away from what happened to people, and it's very important that we acknowledge the victims and acknowledge what happened. That's so important. But we can't take away that a lot of these men and women have changed. And if given a chance, they will prove that they changed. And I just want to point out something, if I can, that, you have 3 guys who were released in Maryland over a year, Ransom Watkins, Alfred Chestnut, Andrew Stewart, who served 36 years in Maryland. And they were innocent. They were innocent. But then you look at the disparities in Maryland, which is horrible. You're talking 87% of people are Black. And the population of Black people in Maryland doesn't even make that up. And you're talking about over 114 are over 50 years old. But it's a lot that needs to be done. But to go back to your question, yes, it's a lot of us are doing very well. The recidivism rate is very low when it comes to the juvenile life population. It's been proven that these men and women are coming home and putting their life together as best as they can, with the time that they spend in prison. So yes, it's a very positive response to releasing these juvenile lifers around the nation that's coming home.
And how many states have been, for anyone on the panel, but how many states exactly have been in front of Maryland in revising their sentencing policies from 2012 until now?
I can answer that, Senator Carter, if you want me to put a specific number on it. It's 24 plus our neighboring DC as well. Virginia was in 2020 and Ohio last month.
Right, that's what I was trying to get to. So we're actually on the tail end of revising our sentencing policies in consideration of other states. That's what I was trying to get to. And in those 24 states and the District of Columbia, what I was trying to get to is there's been no, great, epidemic of recidivism or problem with the aftermath of them implementing these sentencing revisions, correct?
Can you say something? I don't know the exact numbers, but Eddie might know. I think it's around 700 people have been released in all these states. And the recidivism rate it was less than 1. I don't know if it's reached 1, but that's incredibly low. And the last I heard, and this may have changed, but I don't think so, why it was 0, and why it got raised a little bit was something minor. It was somebody who missed their parole hearing or didn't show up. It wasn't even a person going out and committing another crime. So just that alone would kind of tell you that it's working. If 700 people were released and none of them recommitted crimes, something should say something.
And in Maryland, are we talking about?
Go ahead.
I thought I read about 314 people in Maryland. Is that about the number that we're talking about will be impacted by this bill currently? Well,
I don't know the exact number in Maryland.
Not thinking of the future ones that won't be sentenced, but the current people that are serving life sentences that were sentenced as children. It's about 314. Is that an accurate?
I don't know. Eddie might know that. I'm
Yes,
not sure.
that's close enough. But my fact sheet showed that over 400 who are serving life or life equivalent sentences for this crime. You know, so it's a lot of people who are really serving life sentences or equivalent sentences for these crimes in Maryland.
Thank you.
Thank you.
And thank you, Senator Carter. All right, Senator Castley, you're up.
Thank you, Mr. Chairman. I got some questions for Mr. Schellenberger, please, if you could unmute him. Thank you, Mr. Schellenberger. Just a couple of questions here for you. I guess first off, we heard a lot of discussion on the numbers here. Do you know how many folks who are serving life without parole for sentences committed while they were juveniles there are in Maryland?
I do not. I believe that number of 300 or 314 are individuals who are serving life or life equivalent. And there's a portion of those are life without parole, but I do not know the exact number. I think the number of 300 is really the lifers who are convicted as juveniles.
Okay.
So there's an even smaller number here.
Yeah, I mean, that's what I thought. I didn't think there was something anywhere near that number of life without parole. I mean, we're hearing we're sort of conflating the two here this afternoon between people serving life and those serving life without parole. And this bill specifically refers to life without parole. So I'm not going to get into the lifers. We haven't heard any testimony here today from anybody that I know was serving life without parole, or victims whose offenders were sentenced to life without parole. So I want to just stick to the topic at issue and only crimes dealing with life without parole. We tend to go into, Mr. Schellenberger, often in the discussions here about the sad predicament of the 16-year-old, 15-year-old kid who was walking down the street and wanting to be part of the in crowd. The car pulls up and says, hey, Tommy, jump into the backseat. We're going to have some fun. And next thing Tommy knows, they're involved in a service station robbery, and Tommy's in the car when the robbery goes down. Everything goes wrong. Some kid has a gun and shoots the service station attendant, and he dies. And now everybody's going to be sentenced to life without parole and never see the light of day again. And that's sort of the mantra that goes on here. So I want to find out from you, people eligible for life without parole, what gets you that sentence?
Well, typically it's obviously a first-degree murder. Usually not a felony murder unless you're actually the principal in the first degree. So even someone is like Nick Browning, who killed his mother, his father, and his two brothers. We filed life without parole, but he pled guilty and he got 2 regular life sentences, which means he's eligible for parole. So the life without parole is really saved now for the worst of the worst. And I'm not familiar with anyone, and there could be someone from 20 years ago who was in a different county who was a getaway driver who got life without parole. I can tell you that Ben Garris was 16 when he was at Shepherd Pratt, and he started a fire, and he murdered Sharon Edwards, who at that time was only 28 and had a 7-year-old child, and was her first night working the overnight shift at Shepherd Pratt. He stabbed the victim 26 times. He confessed to the murder. He said that when she was pleading for his life during his confession, he stated, "You're dead. That's right. Now you're nothing but a piece of meat." And during his trial, he mocked all the actions of the movie A Clockwork Orange. I mean, there are just some people who should never be in a free society again. But remember, even life without parole can get a commutation from the governor. That there is still a potential out. But I believe, this should be for the worst of the worst. And Senator Castley, this is what I used to argue about the death penalty when I talked about Stephen Oken, who killed 3 people, or John Thanos, who killed 2 teenagers. They were sentenced to death. And now everybody says, well, we've come a long way. Well, we still have a lot of bad murders. And Nick Browning just killed 4 people, and even he didn't get life without parole. So it really is saved for the worst of the worst, but it needs to be on the books.
Your association provided us last time we had this on the floor with a very handy reference list of descriptions of all the crimes committed by the life without parole juveniles. And I'm hoping, I'm unable to find that. I remember Senator Brochen standing up on the floor of the Senate and began reading from that until people became nauseated by the absolutely grotesque circumstances of these crimes, which were not just simply A shot B during a robbery thing, you know, these were like incredibly complex, grotesque, prolonged, just really evil deaths. So I'm hoping you can provide that to us. So that
I do have a 32-page document, which I thought some of you had already gotten.
I've not seen it this time around. I was just looking through my files. I was going to ask you about some of those cases, but I'm sorry.
The cases that I provided in a 32-page document are juveniles who committed murder and got life or life without parole. I will ask everyone in the state to narrow it down to those who got life without parole. And I saw Senator Smith seems to be interested in that number, and I will find that.
Yeah, well, that was rather depressing reading. My next question is, I mean, you deal with victims all the time, and I fully appreciate that every time you come before this committee, you are almost exclusively the only one that, well, you and your fellow prosecutors are the only ones that actually come here talking for the victims, because I understand that dragging them before this committee every year to testify in yet another bill to release offenders, yet another bill to give wrist slaps on, you know, for violent crimes, it can just, eventually it wears them out. So I appreciate your tenacity, your perseverance in coming here to try to convey to us some sense of what they're facing. And believe me, I understand.
And Senator Castley, to that point, I considered strongly approaching the Caprio family. They did testify before you all, I believe either last year or the year before. And after we walked out of that committee room, and you were all extremely deferential and polite to that family, but after we walked out that committee room, I saw what that had done to them, particularly Officer Caprio's husband. And I just, honestly, I could not do it again. And I actually wrote a sticky note the other day that I need to find that testimony on your website and send it to you all. But I did hear last night, folks were talking about all the emails and texts I send all the time. So I might get someone else to send that, so.
So I know in Senator West's opening testimony here, he referred to the bitterness that he would hope that the victims could get over their embitterment, that they would feel and oppose this bill. And I know you deal with victims of violent crime. You've been prosecuting for many years. I remember my first day as a young attorney working with Judge Levitz, and I think you were a young prosecutor way back then in the courtroom. So, so I know you go back a long time representing the interests of victims of crime, and that's unique in all the professions in this state, in this country. So thank you for that. But if you can just share with me a little bit, are these people the folks who have been victims? A, do you think they would support this reduction to this proposed bill? And B, if you could just, if in your opinion, their refusal to do that would just be because they're a bunch of bittered old people who can't get over the fact of life and move on and let the people who took their loved ones' lives in such a grotesque fashion to just roam free.
No, and so in deference to Mr. Ellis, Mr. O'Day, Mr. LaRuff, and Ms. Feldman, they have been accurate in that victims run the gamut. I have seen victims who have shown the forgiveness that I believe Mr. Ellis described. I've experienced that and seen that. I've seen victims who have been neutral and just kind of want to get on with their lives. And then I see victims who, I don't want to use the word bitter, but I use the word feel that the appropriate punishment is that if their loved one can never walk the face of the earth, then the person who did it should never walk the face of the earth. And I don't consider that bitterness. I consider that in certain cases the appropriate sentence.
Yeah, I just, I was sitting and watching after this is my 7th year on this committee, and every once in a while you would get the victims of crime who come before us. And fortunately, it's not too often because it really is emotionally draining when they get up and talk about the trauma. And this is often 10, 15, 20 years after their crimes, and to just watch the, feel the demeanor, the emotional wrenching. And I recalling some of those life without parole. I mean, some of these cases involve violent rape, beatings with pipes, torture, leaving them in the woods, coming back and realizing that she wasn't dead yet. So again, beating them to death with a metal pipe and then burying them in a shallow grave. And then the investigating officers themselves, we talked about just being traumatized for the rest of their lives, just having seen the evidence, not having lived through it or even ever known the victims. And then listen to survivors talk about the trauma of the realization that the person who did that they may someday encounter them as the counter person in the store, or the BG&E repair guy who shows up at their house, to know that, oh yeah, you're the one that slit my sister's throat and violently raped her and tortured her. Was just, the possibility of that was just too much for them to even conjure up. So, and I realize that the folks who brought this bill are trying their best to be sympathetic, empathetic, and loving, but I guess I appreciate you coming in here to express to us that there's actually, there are the victims, and they have to go on with lives the best they can too. And often it's not just one victim, it's a whole family of victims whose lives are forever shattered and ruined by the constant memory and the haunting of their loved ones being violently raped and their skulls smashed in and pipes shoved into their various body orifices until they died. So I appreciate you coming in. Thanks, Mr. Challenger. That's all I got, Mr. Chairman.
Thank you.
Thank you, Senator Castley. We'll now move on to Senator Hedelman.
Thank you very much, Mr. Chairman. If I could ask, I don't see Senator West, but so I would ordinarily direct this question to him. But if I may, I'd like to ask Ms. Feldman if she could answer this question. So, and you yourself have experienced, and I'm sorry for the loss of your brother, a horrible crime, and your family has experienced a horrible, horrible crime. And I'm very sorry for that. And you also have talked to many people, families of victims of crime, and so have heard from them directly about how they feel. And you described that, the range of emotion and the range of feelings about a bill like this. But if I'm looking at this bill and I'm looking at page 2 and at page 3, and it to my mind, clearly delineates what a court needs to take into consideration when they're making this assessment. And so I just wanted to give you the opportunity to talk about, this is not unlocking the jail cell for tons of prisoners, right? This is a very, very careful consideration of what someone has done over the past 20 years about what their individual circumstances were and the changes that they have made throughout that period of incarceration, throughout that period of punishment. And so I just wanted to give you an opportunity to share with the committee and share with us kind of the gamut of things that somebody has to demonstrate before this is even a consideration for them.
Yes, I'm happy to answer that question as best I can. I love that the statute does, or the proposed statute has all of those factors that a court should consider. And it's very consistent with Supreme Court decisions that have come out over the past 10 years about juveniles and what we really need to look at. And it's pretty extensive. But when I was preparing for this hearing, I also, when I was at the Public Defender's Office, managed the Justice Reinvestment Act modifications for the agency. And I don't have my data anymore, but I seem to recall that, and this was for drug offenders. This was for people who were convicted of possession with intent to distribute, distribution, and had mandatory sentences. And they had the right to go back in and request a resentencing. And it was only about 30% of those cases got resentenced to something less. A lot of the judges decided, no, we still want you to serve that mandatory sentence. So, you know, in practice, you know, I can't predict what judges are going to do. I think every case is going to be completely different. And judges are different from one judge to the next, and counties are different. But it definitely is not a, oh, you meet this criteria, it's time for you to go home. It's going to require a lot of convincing. And I don't think this is a get out of jail free card by any means. Yeah, I just had a hearing today, actually, for someone who's been in for 40 years and had one of the best institutional records I've ever seen, and I've seen a lot, and the judge still would like to think about it. So, you know, I understand judges are in a tough position as well. It's hard to predict public safety, and they want to take into account the victims as well, and all that's important, and they're going to have a tough job.
Thank you.
To be clear, Senator West was testifying in another committee, so schedules being what they are, that's where he was. Just to want to make sure that was clear for everyone. Mr. Ellis, go ahead.
Yeah, I wanted to say, if I may, that I had the pleasure of sitting in over 50 cases in DC when they was resentencing, you know, the juvenile lifers in DC. And all the things that need to be considered in the case, the judges had the opportunity to look at all these things, the crime, the victims in the cases. And I just think I don't want that to be overlooked, that wouldn't happen with these judges not having a chance to look at these cases. And I also wanted to say that I'm also a victim. My father was killed when I was a kid. And I dealt with that pain, that trauma, bitterness for years because my father was killed. But the reality is, my father being shot 3 times in the back, he was killed. I'm hurt. I was hurt then, and I still grieve for my father to this day. But my forgiveness was based on me healing. And that's what was important to me as a victim. I needed to heal. I needed to be the best person that I can be for myself, for the community, for my child, for my wife. So that's very important, that these things don't overlook what victims go through, what people go through. And judges are put in place to look at these cases and to be able to decide if a person has earned the right to be resentenced. We believed in these judges when we put them in place. And I think it's important that we believe in these judges when making these decisions, that the judges will make the right decisions for our community as a whole, and taking into consideration what happened in these cases and what happened to the victims that may have passed away and those who are living. So I just wanted to say that. Thank you.
Excellent. Thank you very much. Further questions from the committee? All right, seeing none, that will conclude the hearing for Senate Bill 494. Thank you all. We'll now move on to Senate Bill 583. Senator Heddleman, you're up.
Thank you very much, Mr. Chairman, Mr. Vice Chair, members of the committee. Senate Bill 583 is actually a pretty straightforward and pretty simple bill. A number of years ago, the General Assembly tasked, we're not quite ready yet. Hang on one second. The General Assembly tasked the Maryland Police Training and Standards Commission with developing policy around the use of body cameras. And we seem to be moving in the direction of requiring law enforcement to use body cameras. And I know my county has had a policy of using them for a number of years now. We know that body cameras have the capacity to record audio and video before the devices are actually turned on, when they are in what's called pre-event buffer mode. They run on a loop of recording and deleting, but are not stored automatically until the officer hits the record button. And right now, the factory default sets devices to buffer for 30 seconds, but the cameras have the capacity to buffer for a full 2 minutes before they're turned on. You will hear in a few minutes and see evidence demonstrating the benefits of increased transparency and accountability with cameras. This committee has heard at least one state's attorney who had been adamantly opposed to them to see the benefit of having them. And there are certain events where it would be extremely helpful to have a better sense of the context of what's happening at the time if we had access to a full 2 minutes. We have the technological capacity, so why not do it? And you may hear about privacy concerns, and I acknowledge them, but they also exist with the 30-second buffer, and we've been able to manage them so far. So they're the same exact issues that we have now. Most departments, you might hear about cost as an issue, and most police departments in Maryland have an unlimited storage plan. So cost shouldn't be a factor with regard to storage. I would argue this bill is just as much about protecting law enforcement as it is about exposing wrongdoing. In my view, this is about good government, transparency, and accountability. I'd like to show a short video before we head to our panel to talk about why this is important.
I'm gonna check here. Hold on.
I just remember. Was that 30?
Yo. Hold up. Not yet.
So what you just saw, but when it was in silent mode, is you saw officers planting drugs in a Coke can or some sort of soda can and putting it in the back. And then you hear, they walk out that little alleyway and you hear the audio go on and they go walk back in as if miraculously they just are finding drugs planted there. And if you listen closely, you heard a little laugh and then you heard someone say, is that 30? And that means the 30 seconds before. So without further ado, I'm going to turn it over to other folks who have a great deal of experience in this area. Thank you.
Thank you, Senator Hedelman. And for your primary witness, I have Mr. Frazier. You're up. As primary witness, you'll have 5 minutes.
Thank you, Chairman Smith and members of the committee. My name is Stanford Frazier, and I'm with the Government Affairs Division of the Public Defender's Office, and we are asking for a favorable reading of this bill. As you saw in that video was actually discovered by an attorney in our Baltimore City office that was just regularly going through their individual cases and saw this. But what you don't know about this case is that the individual who was arrested and charged with drug possession in this matter spent 6 months incarcerated on a $50,000 bond before the case was eventually dismissed once this video was brought to the attention of the Baltimore Sun, as well as the state attorney's office. That the officer that was allegedly planting evidence was prosecuted for misconduct in officer, as well as, misconduct in office, as well as fabricating of evidence. But because those criminal charges are misdemeanors, he wasn't automatically removed from the police department. So we've had conversations about transparency this session and accountability in the police department. And while the 30-second buffer did provide some of that, if the buffer was 2 minutes and included audio, there may have been evidence that would allow the state's attorney to pursue felony charges against this officer, which would have actually had the basis of removing him from the police department. Another fact from this that's important from this video is that the other 2 officers, including one that's presumably laughing, you can't identify, both of those are still on the police department. They still are part of the police force. But if you have the buffer, which the technology exists, so instead of 30 seconds, if there was 2 minutes along with audio, there would be more evidence that possibly could have fully exonerated those other officers or provided evidence so that those officers could be investigated either by the state's attorney's office or by the Internal Affairs Division. The reason why all this is important is because it demonstrates why this simple bill can provide more transparency and accountability in policing. I know one topic of this session is the issue of no-knock warrants, and that the tragic story of the killing of Duncan Leff, a 21-year-old man in Montgomery County, who was killed by Montgomery County officers while they executed a no-knock warrant, has been discussed in both chambers of the Maryland General Assembly. But one of the tragic circumstances of that case was that the officers didn't turn on their body camera, the SWAT officers, during the execution of the warrant. They only turned them on afterwards. However, if we had this simple legislation, we would have more information about the circumstances surrounding his tragic killing. And for all of these reasons, we at the Public Defender support a favorable reading of this legislation.
Excellent. Thank you very much. Next, we'll have Mr. Soderberg. You are up.
Hi, thank you for having me today. My name is Brandon Soderberg, and I'm a reporter and the co-author of I Got a Monster, The Rise and Fall of America's Most Corrupt Police Squad. I have to admit it's a little strange to be a reporter here discussing a bill in this capacity, to say I am asking for a favorable reading of Senate Bill 583, but that's exactly why I've decided to do it. I'm here to share what I've learned and how my mind has been changed over the past 4 years spent talking to people victimized by the Baltimore police and watching body camera footage of police misconduct. What I've learned is body cameras, while hardly a panacea, make it harder for out-of-control officers to lie, beat, and steal. And the ability to see 2 minutes prior to the camera being switched on would make it even harder for out-of-control officers to lie, beat, and steal. Consider this. When body cameras were introduced to the Baltimore Police Department, the prospect of having to wear them struck fear in some of the embattled department's worst cops, the Gun Trace Task Force. A body camera recording and saving 2 minutes rather than 30 seconds would make it harder to begin orchestrating some of that squad's complicated ruses, which often began as questionable police stops, devolved into criminality upon an arrest that was also questionable. In another incident I have seen, it was obvious that a police officer coached someone on what to say when they were recorded. A man, his face swollen almost beyond recognition, declared on camera, he ran and he fell. The police did nothing to him. Whatever happened before that recording began, however they convinced the victim of police brutality to announce on camera that he was not a victim of police brutality, I think would have been a bit more difficult to set up and sustain for 2 whole minutes. More broadly, the nature of a police stop or an arrest or additional context about an incident that became violent will be further clarified by capturing 2 minutes before the cop chose to hit record. Now, I know that police officers turn their cameras off at inopportune times, or they conveniently forget to turn them on at all. They position them in a way where you can't see what their hands are doing. They swing them around so you see a blur instead of their partner's fist meeting someone's face. This bill won't stop any of that. Other bills can try and do that. But the incremental increase in transparency, let me start that over. But the incremental increase in transparency Senate Bill 583 suggests will, by expanding what is recorded, make it a bit more difficult for police to get away with misconduct. Thank you.
Thank you very much. All right, so that'll conclude the testimony for the proponents. When I'll switch to the opposition panel. Mr. Schellenberger, you're up.
Yeah, I guess you could stop calling it panels. You all know I am a huge believer in body cameras. I think they're the greatest thing we ever did. Baltimore County's got 1,400 of them out on the road. I love them. I think it's terrific. I supported Senator West's bill, the omnibus bill, where he mandates body cameras all over the state. Here's the problem. I currently have 15 people working full-time to redact personal information in the body camera videos. And Senator Hedelman and I discussed this last night. Right now, the 30-second look back is video only. So it's very rare that you're going to collect personal information in that video only. If you add another 90 seconds to those videos, Baltimore County Police Department last year had 552,000 uploads of videos and photographs. Now, I know Senator Hellman said right now the companies aren't charging us for extra storage. But if you add 90 seconds, I guarantee you for that 552,000 videos, I guarantee you when the contract comes up in a couple of years, those storage costs are going to go up. But more importantly for my office, my 15 people can barely keep up with the 40,000 cases that we hand a year. Remember, every time a police officer walks up to you, the first thing they ask is name, address, phone number. I have to turn that over to the defense counsel who gives it to the defendant. We even have defense counsel play these videos at the detention center. We set a whole thing up so they can do that. Now, I don't want them to get that personal information, and I have to shield that, and that's what my 15 people do. If you add an extra 90 seconds to that, I'm going to need even more people, because during that prior 90 seconds, it's going to be the officer on the phone with their spouse. It's going to be the officer texting their son. It's going to be the officer looking at their next call that has the victim's name on the computer screen. And you're going to have 90 seconds of that. Plus, remember, if you add audio, you got to change the wiretap statute, because that's why we went with only 30-second videos. The body camera statute that you all passed required notice, and the notice is required to get past the wiretap statute, which makes it two-party consent. Okay, I know, I'm stopping. But see how all this all circles around? We keep having the same conversations, wiretap and things like that. The problem is, if you do 30 seconds video and audio, you're going to have to adjust the wiretap statute, because now people are going to be recorded who don't know they're being recorded. And I think that's a problem. I did mention to Senator Hellman when we talked last night, maybe if we did 2 minutes of video, then you're still capturing stuff. You don't have the notice provision, and then you don't have the wiretap violation. So we had a good conversation about that. Happy to work with you on those issues, but I wanted to just bring the money to your attention.
Excellent. Thank you very much. All right. We'll head off to questions from the committee. Senator Huff, and then Senator Casserly. Where'd you go, Senator? There you go.
Yeah, thank you. That was my question, is what Scott brought up, is the two-party consent, because I remember when we were drafting this and coming up with it, especially, I mean, out in the public, there you don't have any expectation of privacy, but if they come to your house, hey, is it okay if I record you? No, it's not okay. Well, I just recorded a minute and a half of you anyway. So how do you address that, the two-party consent?
Well, you'd have to give notice like you do now. Either that, or, I'm open to just talking about video rather than audio. So I'm certainly, willing to have that discussion too.
Yeah, because the notice is, in Maryland, it's obviously two-party consent. So you have to say, I'm going to record you. And the person says no. Well, you've already recorded 90 seconds to them before you've already violated for 90 seconds the wiretap statute.
I hear you. I mean, I think that's, something we can work out.
And then I looked at the Chiefs testimony. They said the International Chiefs Association recommends 30 seconds. So where did we get 90 from? That's
actually the technological capacity of the cameras. And I do have a breakdown of different folks who have them configured differently. Right now, each law enforcement agency can make its own policy. We don't have a statewide policy. Most of them do 30 seconds that right now, but 32% of users have 60 seconds. This is just on the Axon cameras, which do have the contracts for a number of our larger counties. 32% of users have 60 seconds configured. So you can do it in those 30-second increments. They have the
Senator Huff, the original 30 seconds was the limitation of the original cameras. And then as the cameras have gotten more sophisticated, the timing element has been able to be adjusted.
I'd also like to say, technologically, they're really making quite a lot of advances. So at some point in the not too distant future, the officer won't even have to turn it on. It'll be automatically be certain things right now. If you take your, they can come on automatically from like a release on your holster, or the use of a taser, or the opening of a car door. So, it is this continuum that the technology is changing so much that I think these issues are going to be, are here already for us to consider.
I don't like the fact that they can come on before they show up. I mean, if something, I like the body cameras. I like them in public, but I've always been concerned about, especially if you show up to somebody's home. So if you're, I don't know, a domestic violence victim, you got beat up and, hey, can I record this? No, I'd rather not be recorded all night.
Right. Well, I know in our
I'm going to serve a search warrant of your house and catch you and your wife in your underwear when we come at 2 a.m. Can I record this? No, please don't. So I've always been concerned about in people's homes. So but the last question, because like I said, I like the program, but it's figuring out how to pay for it. I mean, do we know what the costs are? Because my county's struggling to even cover the current, what Maryland requires.
I don't know what the costs are right now, but, and that's, that's another bill. This bill doesn't require that we have cameras, but we seem to be moving.
But no, it changes the data. So right now, Frederick County, our state's attorney as of last year was in a fight with the county over the storage.
Mhm.
Said he needed more money to pay for the storage, and the city and the county and everyone was squabbling whose problem it was to pay for it. I think it was at least $100,000 or more of the current what we require. Scott has his hand up, so I don't know, Scott, if you know.
So I have previously sent one of my famous emails with a breakdown of how much it costs in Baltimore County. For my office, our first time equipment cost was $138,000. My 15 support staff is about $800,000 a year. And that includes a part-time. I have an attorney who oversees the unit and they do other things. So I allocated part of his time. The storage for our 1,500 units for 12 months was $1,500,000. And remember, that goes on ad infinitum, and that's just one county. And then—
Oh, wait, hold on a second, Scott. This per what we currently require costs you $2 million to do?
Yes, and if you add 90 seconds to me, I estimated the other day I'm going to need at least 5, maybe 6 more employees to have to watch, give me time to watch that extra 90 seconds. And again, I think that's a place where you're going to have more personal information from the police officer because they haven't gotten the active call to go out. A lot of times they'll get the call to go out, they'll hit the button, the 30 seconds before might be them driving. When you go back 2 minutes, you're going to get a lot more personal things that you're going to have to cut out.
So
I got to look at it.
So a couple things. One, so Scott, if you look in the committee testimony, the bill does have the support of the county executive.
Good.
So that is one thing that you'll see.
Well, there's your.
Two is.
Well, then I amend my testimony. I'll need 10 more people.
Too late. Two is, each county, I just know what Baltimore County has policies on body cameras with regard to domestic violence situations, with regard to sexual assault. So there are very clear delineations of when you can put someone on the camera and not.
Absolutely. So, I went to about 110 meetings to create those policies. And I can tell you that my chief and I have shared Baltimore County's policies across every jurisdiction in the state and actually in other states.
Right.
All right, Senator, have you all good to go?
Yep.
Very great. I appreciate the line of question because as we, tomorrow we're going to start talking about body cameras, and my number one question was just about the cost as well. When you expand to 2 minutes, just understanding how much it was going to cost, how much more it was going to cost. So thank you for that. Senator Castley, I think you were next, and then Senator West. So Senator Castley.
I just really have a question on the technology. I guess Senator Helderman's probably maybe knows more. It sounds like from what you're saying that these cameras they're actually always recording. I mean, from the time the officer puts it on. I'm just trying to understand the technology.
Yeah. So they have this pre-buffer. They don't. It goes to the cloud, but it's not saved until it's actually hit start.
So I mean, in a technical sense, from the minute they put their gear on and start their duty day, it's recording. I got it.
It's a loop.
We're not saving any more than whether 30 seconds or 2 minutes or whatever.
Right.
Technically, it's going to the cloud. And then when the officer pushes the button to turn it on, then it says save 30 seconds, 2 minutes prior, right?
Correct.
So it's doing?
Yes.
And then, so I've never seen somebody put it on. I mean, I imagine when the officer puts the equipment on, and my shift just started, I get all my stuff on, and then I turn a button and turn my camera on. Is that how it works?
That's
right. So there's a power button and then there's a record button.
Mm-hmm.
With the power button on, the loop starts, which is currently set at 30 seconds. When they hit the record button, which is typically just hitting a button, that saves that prior 30 seconds and then records from there on out until you turn it off.
And you have to hold it, to turn it off for
Right.
some length of time.
It's
So,
more than
so you
just a
can't like,
pack.
to reduce accidental turnoffs, yeah,
Yes.
you hold
Right.
it and it shuts down, like an iPhone, kind of hold it so for a while. And then, I mean, batteries, what's this got? It must have like an external battery pack or something?
The Axon has a 12-hour battery life.
Okay, so you presumably like a 8 to 12 hour shift is what it's set up for.
So what they do is, this is your equipment. So you have your own body camera, just like your gun, your holster, whatever, your uniform. When you go on duty, you put your body camera on if you're a patrol officer. When you're now off duty, you put that camera into a locker, and it plugs in to recharge the battery. And so while you're off your shift, it will recharge the battery so that the next time you come on, it will be completely recharged for your shift. So that's why it's individual officers have their own equipment.
Okay, all right, thank you. Thanks for the info. That's all I had. Appreciate it.
Thank you, Senator Castley. All right, Senator West.
Thank you, Mr. Chair. Very interesting. Senator Castley just asked some of the questions I was going to ask about how this equipment worked. So let me ask Scott first. If we modified the bill slightly to only require the video for 2 minutes and not the audio, would that give you virtually all the usable information that you would want about what happened in those prior 2 minutes?
I think it would, and that's what jotted. In fact, Senator Heldman and I didn't have this conversation, but it dawned on me an hour after I was watching TV, and I called her and left a message. So the thing about the video versus the audio is, the audio, I have to have them play that 90 seconds in real time, and if it's in real time, then it's a real 90 seconds. If it's only video, they can actually speed it up, and you can actually watch the video at double speed and 4 speed. And so you can actually see if there's anything on there that would be personal. And, a lot of times it's just a lot of fancy driving, as they're driving to the scene of the call out. So that's why I felt like the video might, if Johnny O's watching, might cost me a little less, and I think, and not just me, I think everyone, I think it would cost a little less if it was video only. I don't think it changes the storage costs, but I think it would affect state's attorney's office a little less if it's video only. And in Senator Heldman's example, we would have seen 90 seconds earlier of that situation in the city.
And again, I'd just like to, in terms of cost, many of our jurisdictions have these unlimited storage contracts.
That's correct. I'm talking about cost for me.
I hear you.
Yeah.
So
it's good.
Finally, because I have a cynical side, if officers know that it records 30 seconds before they push the button and plan accordingly in order to plant evidence, why wouldn't the same officers know that it takes 2 minutes and plan ahead? If they're going to plant evidence, wait for 2 minutes to pass and then push the button.
Well, the next time that happens, I'll know who to blame, Senator West. Look, I operate under the assumption that officers are good and that they're doing their job. And if they're that bad, Senator West, then
we'll catch up to them.
Yep.
We'll catch up to them. Right.
Yep.
Okay, thanks. That's it. Appreciate it.
Thanks, Senator West. And then I had a question for Senator Heddle. We talked a little bit about this this morning on the way to the floor, but just the concern, I never even thought about this, but the 2 minutes before the 2 minute loop. So let's say, someone goes into Dunkin' Donuts or Starbucks, they use the bathroom, and then they get a call, and then you've captured, that 2 minutes prior is now part of the record. Someone's, on the toilet or in some other compromising position. Just wanted you to address that because it's likely to come up, during a voting
Sure.
session.
I would argue the same thing happens with 30 seconds now. The same possibility exists. And I assume that, Scott's folks are sitting there and, looking at those and redacting those too. But maybe you can talk about that, Scott, with regard to your staff. look, I'm not interested in capturing somebody in the bathroom, obviously.
No, I mean, that was the most
Right.
extreme example I was given, so I was just.
Yeah,
So
no, it's a fair concern.
You would have the option if you were going into the bathroom and you know that it's 2 minutes and not 30 seconds, you could turn it off, really off. The problem is then you get the 911 call and you bust running out to your patrol car, you jump in and you don't necessarily think I got to turn it on so I can turn it on or that I can catch the loop. It definitely poses more problems. And, it's a balancing test that you all can make.
Could we pitch that to Stanford too to respond to?
Sure, absolutely.
Thank you. I would say the public defender's office, of course, doesn't want officers to commit violations of the wiretapping statute. We would suggest that audio is important for conversations, if proper information was given to people who are interacting with officers, for things such as consent searches. If there was truly consent, things of that nature might be important and we would want to be captured. Also, the type of language officers are using, right, when they interact with the citizens, with residents, might be important information. I would say it's my understanding that from reviewing body camera footage that they inform individuals once they arrive on the scene. So if you're showing to someone's house and it's 2 minutes beforehand, you get time in the car, you get time walking up to the door. But obviously the time when you come inside, can we record? It wouldn't capture 2 minutes inside the home. It would be the 2 minutes leading up, getting into the home. And of course, I believe when we provided this information to the Senate Judiciary Committee, we used evidence.com's what's called blurring feature, right, to redact people's faces and images. And I believe that's the same technology that the state's attorney's office, as well as police departments have, that they could also use. Yes.
Excellent. Thank you very much. All right, looking at the committee for additional questions, seeing none, that will end the hearing for Senate Bill 583. Thank you very much, Senator Hettleman. We'll now move on to Senator Sidnor with Senate Bill 588. Senator Sidnor, you're up.
Thank you, Mr. Chair and committee. Senate Bill 588 is somewhat similar to the bill that we heard back in September. The one change in the bill that we heard back in September, the Brady list that would have been required for the state's attorneys to keep in the September bill would have been transmitted to the Maryland Police Training and Standards Commission. I had some conversations with people who are a bit more well-versed in this area of police law and the like, and was told that it might violate officers' due process. So that portion of the bill was removed so that now this particular Brady list would remain with the state's attorney. Outside of that, the other portion of this bill is that after it is actually this particular database that would happen or would have allegations of misconduct submitted to this Police Training and Standards Commission. The submission would include the officer's name and badge number, general description of the alleged misconduct, the date and location of the alleged misconduct, the date that the complaint was filed, the law enforcement agencies where that officer is employed, as well as the disposition of the complaint. And I'll tell you, I believe most of the consternation around this bill lies in that last piece, which in dealing with complaints that are sustained versus unsustained or unfounded. This bill would encompass all of it, and I think many of you have heard my position is the more information that's out there, you give the general public the credit that if they read something that's unfounded and have all the information in front of them, which would guide you to why the agency made, or the decision was made for it to be unfounded. I don't think that's a bad thing, and I think the general public knows if people are filing frivolous complaints and would be able to distinguish that. So that's why this bill pushes for all complaints rather than just the sustained. As we noted in our discussion yesterday, I do believe that where there's smoke, there's fire, but I will tell you that after the conversation, I think yesterday that we had with regards to another bill that looked at some of this stuff, I'm thinking that there may be something there where we can have some sort of an agreement. But with that, I would ask that this committee provide a favorable report on SB 588, and I'd like to turn it over to my expert witness.
Excellent. Thank you, Senator Sidnor. And Ms. Levy, you're up next as the primary witness. You'll have 5 minutes. Good to see you.
Thank you. You as well, Senator. The Maryland Office of the Public Defender supports Senate Bill 588 with the following amendment to page 2, line 32, after the word act, inserting the criminal rules of discovery. We would obviously want this list and this information discoverable in criminal cases. My name is Debbie Katz-Levy, and I am the Director of the Special Litigation Division with the Maryland Office of the Public Defender. I focus my practice on litigating issues related to police misconduct and discovery abuses. All too often, my phone will ring and another public defender or private lawyer from inside Baltimore or another jurisdiction, perhaps on the Eastern Shore or even as close by as Columbia, will say, my case involves Officer X. Is this the same officer who I read about in the paper? Or worse yet, my case involves Officer Y. Are you aware of whether that officer engaged in any serious misconduct while working in Baltimore? There is a lot that I don't know for sure, but I am positive of one thing, that a public defender in the city of Baltimore should not serve as a human database for acts and instances of police misconduct, even for the city, let alone the state. But until there is a proper disclosure system in place, this is what we have to rely on. One lawyer picking up the phone and calling another, or pre-COVID, bumping into each other at the proverbial water cooler to see if we can piece together instances of misconduct. As law enforcement officers move from one jurisdiction to another with the confidence of knowing that their disciplinary files will not follow them. According to the Harvard Undergraduates for Bipartisan Solutions, quote, this practice has become common enough for officers across the country to have testified to its existence and have assigned it names such as, quote, wandering officers or police hopping. Wandering officers are not uncommon, and they essentially amount to bad officers migrating away from previous posts to new ones, spreading their bad behavior to different forces. A study published in the Yale Law Journal counted over 800 wandering officers in Florida per year, who then went on to interact with hundreds of thousands of civilians. That same study noted that if a police officer left the department before a misconduct investigation concluded, they had a 39% chance of reemployment. And if they were terminated, a 17% chance. This culture of ignoring previous misconduct is aided and abetted by a reporting regimen that is neither public, nor exhaustive, nor mandatory. In 2019, the USA Today Network gathered misconduct records from hundreds of police departments and state licensing boards in nearly every state in the country. They amassed one of the largest stores of information on police wrongdoing. The USA Today Network identified 32 people who became police chiefs or sheriffs despite a finding of serious misconduct and usually at another department. 8 of those police officers were found guilty of a crime. Others amassed records of domestic violence, improperly withholding evidence, falsifying records, or other conduct that could impact the public they swore to serve. That same study also found over 10 years, nearly 2,500 officers were investigated on 10 or more charges, yet retained their badges. These findings are supported by a myriad of studies that underscore the fact that there is very little to keep bad officers from keeping their badges. Not only do criminal defense lawyers and lawyers in general have to rely, and the public have to rely on happenstance and conjecture, but we're actually prohibited from sharing details about an officer's misconduct and fact-sustained findings related to dishonesty. Every time an IAD file is released, at least in Baltimore, it is accompanied by a protective order prohibiting lawyers from sharing the contents of that file, even with other lawyers in our own law firm. These highly protective orders are regular practice across the state of Maryland and are just one more link in the chain to help officers and prosecutors shield acts of misconduct. Enacting Senate Bill 588 in tandem with other police reform bills focuses on transparency. It will help catalog and disseminate important misconduct information. It will streamline mandatory disclosures, reduce discovery litigation, and most importantly, further the administration of justice. Criminal litigation is a significant component of police oversight, but it is only effective when the relevant information is readily available and shared. Current practices across the state make clear that individual prosecutors are either unwilling or unable to gather disciplinary records on a case-by-case basis. And shielding information from public view and prohibiting lawyers from sharing these details, even with their colleagues, allows for instances of misconduct to fester and grow into egregious patterns of abuse, such as that occurred during the investigation of the evidence room breach in Salisbury, the DUIs fabricated by a Maryland state trooper.
Your time is complete.
And most notably, the various crimes committed by the Gun Trace Task Force in Baltimore. Senate Bill 588, with other basic mechanisms to allow for disclosure and transparency, will shine much needed light on the actions of officers that challenge their credibility and reliability, but have been shielded from consideration for far too long.
Excellent. Thank you very much. And with that, we'll move on to the opposition panel. Mr. Schellenberger, are you still here with us? There you are. You're up.
You've all heard enough from me. Maybe you'd like to hear from Chief Morris and Joe Riley, unless that messes you up, Mr. Chairman.
Sure. And by the way, we love getting your emails. Just we don't like them when they're opposing our bills. You know, when they're in opposition of our proposals. That's just those pesky emails. No, but seriously, we like them. Thank you for the information.
And I did laugh when I heard that, but I'll step back to Mr. Riley and Chief Morris, and if I need to weigh in, I'll raise my hand.
Excellent. Mr. Riley, you're up.
Thank you, Chairman Smith, Vice Chair, members of the committee. My name is Joe Riley. I am the State's Attorney for Caroline County and the Legislative Chair for the Maryland State's Attorneys Association. We are seeking an unfavorable report as to Senate Bill 588. Mainly the items that were in conflict with on the Giglio list. Here are the requirements that the State's Attorney's Office compile these lists. Once we compile this list, it becomes work product. So making it subject to public disclosure could be problematic. Also, they are often accompanied with protective orders, which we would have to violate in order to satisfy the Maryland Freedom of Information Act that this is subject to. So based on those, as far as the state's attorneys are concerned, we seek an unfavorable report on those angles, and I'll leave the rest to Chief Morris.
Excellent. Thank you, Mr. Riley. All right, next we'll have Chief Morris. There you go.
Thank you. Good afternoon, Mr. Chair, members of the committee. I'm Chief Morris, representing Maryland Chiefs of Police and Sheriff's Association. Our primary concern with this bill is that it requires reporting of allegations of misconduct to the Maryland Police Training Commission, allegations that are oftentimes unsubstantiated and not supported by evidence. It's interesting, I did a quick search of the Maryland Board of Physicians, and on that search, see that there are pending charges against the licensee, but it's interesting because they have a disclaimer that the public should be aware that the charge constitutes only the board's preliminary vote that there is probable cause that a violation of the Medical Practice Act occurred. So it's important to note that that probable cause would support that there's at least been an indication that a preliminary investigation has been conducted into the allegation. It further states that that charge has not yet been tested in the hearing process, and in that hearing process, the licensee will have a chance to produce his or her own evidence and to argue the violation did not occur. Similar process occurs with attorneys, with academicians, and even within the General Assembly has a review process, and I'm thinking in terms of the Ethics Committee. This committee has addressed provisions in other bills that address requirements for early warning and intervention policies. The Presidential Executive Order 13929 stipulates that there's performance management tools that need to be in place for early intervention systems, and we urge the committee to move forward with those provisions in those bills. I'm not going to speak to Florida because I'm not familiar with Florida law, but I am familiar with Maryland state law, and specifically point to the Maryland Police and Correctional Training Commission's requirement on a notice of personnel action. That notice of personnel action form is completed anytime that there's a change in an officer's status to include separation from employment and the conditions of that separation, specifically whether the separation is in good standing, whether it's under administrative or investigative charges, even to the effect to the point that the individual separated employment because of a felony or a misdemeanor conviction. It also details officers' suspension status, promotions, and demotions. And this form is subject to the Public Information Act. It's noted right on the form, and the form, upon its completion, has to be done so and signed under the penalty of perjury. So the information that's being sought
Your time is complete.
is in this notice of personnel action form, and I can go further into the process if the committee would like to hear what Maryland does. We urge an unfavorable report. Thank you.
Excellent. Thank you, Chief. And then Mr. Schellenberger, go ahead. You had just a quick
Very
comment.
quick. So just briefly, where else in the law do we allow unfounded charges? Not only unfounded charges, but unsubstantiated. Someone says this didn't happen or isn't true. When we put this in the public record, unsubstantiated charges, and I follow up with Chief Morris in those other areas where the public is allowed to view it, there's at least been a finding of probable cause. So now I recognize there's a big difference between my obligations to Ms. Levy, which I recognize. If there is evidence of untruthfulness, under the discovery rules, I have to provide that to Ms. Levy. Our concern is mainly with the Public Information Act and then also the unfounded part of this whole unsubstantiated and unfounded.
All right, excellent. Thank you very much. All right, with that, that'll conclude the testimony for Senate Bill 588. We'll
Mr. Chair.
Yep, we'll turn to the committee for questions. Senator Sidnor, you're up, and then we'll follow up with Senator Castley.
Thank you. No, I just wanted to see if Ms. Levy had something to say in response. There was a reaction that I saw. I wanted to see if she wouldn't mind.
Well, Mr. Schellenberger asked a good question. Where else in the law would just allegations come in? And although he said he would have the responsibility to give it to us, me, Ms. Levy from the Public Defender's Office, the truth is we don't get these records regularly anywhere across the state. I can say that with certainty, leading a team of lawyers from across the state. And the second answer to Mr. Schellenberger's question is it's in 608B, where Mr. Schellenberger knows very well that instances related to dishonesty that do not result in a conviction are subject to examination at trial for any witness the state offers in any trial. Instances of misconduct not resulting in conviction are required by rule to be disclosed and are ripe for cross-examination. So that's the answer to the question, is where else in the law does that appear? And that's the place. And that's why we want those records regularly disclosed. And at the end of the day, I would just say to the chief that we should all agree, if we should all agree that transparency is going to help root out officers who don't serve any agency's purpose. And we are all here to let the good work of the officers who do their job well permeate and flourish across the state of Maryland. And everybody here is proud of those officers who do good work. And hopefully at some point we can join together to say we'll work together to root out the officers who don't help us achieve that goal. We can look to other jurisdictions like Larry Krasner in Philadelphia, who has said, look, if you want me to give you the list, I'm happy to. As long as the court orders it, I will give it to you. And in other jurisdictions where prosecutors are saying, it's time for us to work together to root this out. And we're only asking folks to join us in that quest to shine the light on the good officers and help us root out the ones who aren't working towards the same goal.
Excellent. Okay, Senator Sidnor, you're good to go?
Good to go. Thank you.
Okay, great. Senator Castley.
Thank you, Mr. Chairman. Mr. Riley, I'm really curious on this piece on the disclosures between prosecutors and defense attorneys. Can you expand upon that a little bit for me?
Sure. As Ms. Levy knows, when we're talking about the things that have to be disclosed that aren't convictions, that means a personnel finding. Like, for example, I get $100 for a shoe allowance every year as a Caroline County Sheriff, and I take that money and instead buy my wife a pair of shoes with it. That would be that's not a crime. That would be something that would be in my personnel record that would be handed over to the state's attorney, and the state would have to do that. That's a 5068B non-conviction thing that's required to be disclosed, not an allegation that is unfounded or unsubstantiated.
So are you differentiating between just a kind of allegation that might be present in a personnel file as opposed to in the prosecution?
An allegation in a personnel file that is founded, not one that is unfounded or unsubstantiated. You wouldn't have to give over an unfounded or unsubstantiated claim.
Ms. Levy doesn't agree with that. Maybe you can, I'm sorry, Mr. Chairman, I was kind of popping back and forth. I'm really curious.
No, of course, we got to get the information soon.
Yeah, go ahead, Ms. Levy.
Yes, certainly under Fields versus State, the seminal case on discovery and internal affairs records, and a unanimous opinion by the Court of Appeals, absolutely 100%, Judge Barbera writing for the court says it does not turn on whether the complaint is founded, substantiated, or not. If it is discoverable as it relates to cross-examination of the witness, of an adverse witness, that means whether I've called it or the state, it is discoverable and it does not turn on the finding, which would make sense and buttress what the DOJ found, that the culture of hiding misconduct, at least in Baltimore, resulted in lots of unsustained findings. And it also makes sense. I gave you an example last time when we first litigated a police misconduct file, and we had 12 unsustained findings of theft and misconduct and abusive behavior from 12 people across the city. And we had the opportunity through that discovery to round up those witnesses and say, were you actually ever interviewed? What happened with your complaint? It was discoverable, the court ruled. And so there should be no distinction, because the court says, and we have to follow the law, that it doesn't turn on the finding of the complaint.
If Mr. Chairman, if you would indulge me and continue with the battle of the attorneys and bring Mr. Schellenberger into this too, please.
So Ms. Levy and I are not far apart here. I mean, it really is not. So I just re-looked at 5608, and the thing I'm trying to emphasize, there's a huge difference between what I have to turn over to Ms. Levy. And so if I have information about potential untruthfulness, and I'm going to call that witness to the stand, then I have to give that to Ms. Levy. And it may be that a mere allegation is enough. That's a whole lot different than it being available to the Baltimore Sun and WBAL. And that's why this whole topic should be dealt with where it belongs, in the Rules Committee and not in this statute. And so that's the place where I'm having a problem. I agree with Ms. Levy. If I got a list, if I got a basis, and the case ain't done in the police department yet, I will have to talk to her about untruthfulness. But that's what the rules require. And what I'm saying about this statute is, don't put it in the Baltimore Sun, particularly if it's an unfounded finding or unsubstantiated finding. We can have a conversation. I've said this 5 times during this session. Substantiated, we can have a conversation about that depending on what the topic is, whether it's use of force or honesty.
I think, but how do you respond? The bill also not just on the disclosure part, but also addresses the compilation part. And you can't discuss the disclosure unless you compile. Isn't that correct?
Well, that's true, but that's me compiling. And the thing that is important about the rule is it allows me to object in front of a judge, Ms. Levy to argue why it's relevant, me to argue why it's irrelevant. We could even, if it's hasn't been a hearing, if it's just a filing, we could even ask that the hearing be closed and a judge could rule whether it's admissible or not.
But if I understand where the bill's coming from, it's that you have an officer who's one of your officers in Baltimore County, so you would probably know because one of your assistants would have come and said, Officer Jones, something about that, or your local. But what if the officer also testified in Baltimore City, Harford County, and Anne Arundel County? Then that wouldn't be known to you. So it seems to me what they're trying to get at here is to accumulate for your Baltimore County case the knowledge from the other 3 counties.
Well, and what I would say to that is that if I had a Baltimore County officer who was on my list and they somehow were a relevant witness in my friend Rich Gibson's County, I'm sure one of Rich Gibson's assistants or Rich himself would call me and say, is there anything I need to know here? And then I would feel an obligation, obviously, to tell him. But again, it's not that often that my Baltimore County officers end up in Howard County. Although Ms. Levy is correct, they do end up in the city, and it has happened. I see her shaking her head. I'm trying to make sure we're on the same page, but we think this is a rule, and it certainly shouldn't be a statute like this about making it public. It's my obligation as the defense counsel.
And I'm just trying to sort of bifurcate the bill here into the accumulation versus the discovery. And you make a really good point that the ultimate discoverability of it would probably be best left to the court through the Maryland rules for the attorneys for both sides to fight out whether that's an appropriate discovery. But you can never have that information without some kind of a accumulation mechanism, which the Maryland rules can't direct. So that's the only thing I'm wondering on that.
I think you are asking a very reasonable question. I have not talked to my fellow state's attorneys about that, but I get it. I hear you. There might be some mechanism where we would have the list so that if there were a situation that an officer was going to another county to testify, yeah, I get you. I hear you.
Okay. And then I just want one more question, if you would, Mr. Chairman, is for Chief Morris, because Chief Morris, you did refer to the process of certification. Can you just take us through that briefly, not too much, but give us a brief overview?
So again, thank you. So briefly, again, the Maryland Police Training Commission is the regulatory commission as it relates to the certification of police officers. So certification occurs when an agency submits an application for certification to the Police Training Commission. When that application for certification lands in the certification unit, particularly if the individual is going from one agency to another, then they will look to see what the notice of personnel action form from the former agency has to state as far as stipulating the conditions of the separation when they left their other agency. And if there is derogatory information in that notice of personnel action form, then that entire process goes to the executive director. The executive director will reach out to the former agency and obtain the derogatory information from that agency, and then it goes before the full commission for consideration for application of certification. So there is a process. That notice of personnel action form is a critical document, if you will, for agencies. And again, it's required to be filled out anytime an officer separates employment, whether that separation is for, whether the condition separation is for retirement or because they're under criminal investigation and everything in between. So the documentation is kept, but again, to the degree that there's validity to the allegations, not just some unsubstantiated allegation that has to be summarily sent to the training commission simply because it was received by the department.
Thank you, Chief, and thank you, Council. And Mr. Chairman, that's all my questions. Appreciate it.
Thank you, Senator Cassidy. We'll go on to Senator Hellman.
Thank you very much, Mr. Chairman. Could I also ask Chief Morris, I just want to follow up on that line of questioning a little bit. You talked about the notice of personal action form, and we've had this conversation in the context of some other bills, but I don't think and I'm sorry if I missed it, if you stated it earlier, but how many people are actually uncertified or decertified? I don't know the right language by the commission. I mean, each year, ever?
There we go. Okay. So it's important, Senator, to understand that decertification occurs the minute an officer leaves employment. The certification only carries as long as the officer is employed. What is often misunderstood in the process, and I would I'm providing kind of a layman's response to this. The executive director of the Maryland Training Commission is probably better suited to answer it. But when that employment ceases, so does the certification. The more likely occurrence is when an officer goes to be recertified and that derogatory information exists vis-a-vis this personnel action notification form. And when that recertification is sought and the derogatory information is in the file, then it's at that point that the executive director would take that entire packet of information to the full commission, and it would be up to the commission as to whether they would recertify that officer or not. Does that explain?
It does, but so during the recertification process, does it happen often that someone is not recertified after review of what's in their file?
There are occasions where individuals are not, where the commission has denied certification or recertification of police officers. And again, I don't have, I'm not prepared to respond in greater detail. I would defer to Al Liebno. He's the executive director and could give more specific information on that.
Okay, but do you see that process as part of the continuum of discipline of holding officers accountable is in your mind?
I see the process as a process that allows for the transparency and accountability and for the full commission to be able to weigh all of the factors that are within the information available to them to make a determination as to whether they should certify or recertify a police officer. Yes, ma'am.
Okay, thank you.
Thank you, Senator Heldman. I see Senator Bailey has his hand raised. So Senator Bailey, you're up.
Thank you very much, Mr. Chairman. I was just wanted to make a comment when we, and then ask one question. When we talk about tracking unfounded allegations, and if we're talking just about unfounded allegations, this has the ability to be extremely biased, either against that police officer or against that department. But when Senator Sidnor presented this bill, he said that it was his intent to gather all information available about the officer. So what we're really talking about here when we're talking about unfounded allegations, we're talking about a reputation of this officer. So if we want everything out there that exists about this officer, just question, why wouldn't we also request the attaboys, letters of recommendation, letters of commendation, letters from the public that these officers received that go to their credibility, that shows what they were doing? And I would ask that question to you, Chief. I know, Scott, if you get engaged, you're going to say, wow, this is going to be a lot of time and effort. But if we're going to do it one way, I do think that there should be some fairness. Thank you.
All right. Excellent. Thank you, Senator Bailey. Looking around the room for additional questions. Senator Sidnor, you are up.
Thank you very much. And I just wanted to be clear that the statement I made is more colloquial than anything else. But so I just want to make that clear. We're looking for the complaints that have been made. So thank you.
So Senator, who is that directed toward? I'm sorry, are you?
Oh, Senator Bailey had noted something that I said, and so I just wanted to make certain that it was clear. I was talking in the colloquial sense.
Got it. Excellent. Okay. Just want to make sure we're good. All right. Looking around the room, seeing no further questions, that'll end the hearing for Senate Bill 588. Next, we'll have Senate Bill 589. Senator Sidnor, you're up.
All right. You all have my written testimony on 589. So what I'd like to do is to kind of walk everyone through the bill, because this is nothing. This is a new bill. It's not anything that we saw back in September. It's a cross-file of Delegate C.T. Wilson's bill, which goes to ensuring that our citizens, when they're stopped by law enforcement, they know their rights, and it obligates the law enforcement officer to share those rights with the person that's being stopped. So if you look on page 2, section A is definitional. And in there you can tell we're talking about stops of a person outside of a vehicle, which is in those definitions in 3, and then you're also talking about traffic stops. So what happens when an officer makes one of these stops, absent exigent circumstances, and that's what it says on line 14 and 15 on page 2, we're looking for law enforcement to do a few things. One, we want to make certain that they're displaying the proper identification to the individual that's stopped. And why is this important? When you look at things that have been happening nationally, you've had, and I can think about in Buffalo, New York, where you had law enforcement officers that were purposefully covering up their nameplates and their badge numbers. I believe that when law enforcement's approaching its citizens, those types of identification should be clearly seen by the citizens, so that we know that you're a true law enforcement officer. So you have that. You have also the officer providing the information to the individual, what their name is, their badge numbers, and the like. Again, we're trying to make certain that you're not putting it on the pedestrian or the driver to have to ask who it is. And I would say that in the times when I've been stopped, law enforcement, they may do this. Some do, some don't. We just want to make certain that it's consistent. Number 3, we want to be able to ensure that law enforcement informs that the person who's stopped of their right not to speak. I mean, that is what it is. You have a right to remain silent, correct? Next, to be informed of the justification for the stop. If you're stopping me, I shouldn't have to ask you what you're stopping me for. I think it makes sense that it be a part of the stop. When you do this, you're not just sitting there wondering, and I think it helps to de-escalate the tension that's already there between that officer and that person being stopped. Next, at the commencement of the stop, we want to make certain that you understand that the officer is informing all the occupants, other than the driver, their right to refuse to provide identification to the police officer. Again, one does not have to identify themselves. If you're driving in a car, the only person that should have identification is the driver. And I know there was an argument that was made that said that this provision kind of flies in the face of the traffic laws that say that one would have to display or to hand over their identification. The fact of the matter is, if the person doesn't hand over their identification, they're subject to arrest. But again, you have no obligation to say who you are. During that, and on page 3, section D, lines 5 through 9, from the testimony that I've read in opposition to this bill, I think this is a section that could be drafted more carefully and look to amend this section. But the intent of this section, there have been times when law enforcement officers, they have taken people's phones who happened to be recording the stops. And why were they taking the phones? Because they claimed that it had evidence of the stop on it, therefore they were taking it for evidentiary purposes. Now, the fact of the matter is, if that phone is important to the case, there's no reason why they can't seek a warrant. What I've heard that happens is these phones are seized, and then for whatever reason, when it comes time to turn this evidence back over to whomever it was taken from, it somehow disappears. But again, this language does need to be written a little bit more clear, because it's no way that that this bill is meant to say that a law enforcement officer can't seize contraband or anything like that. So with that, that's the bill. I will say, one other thing I wanted to mention in Section D, Part 2, the whole use coercive tactics or deliberately misrepresent facts in order to obtain information. I want to say this. And I believe State's Attorney Gibson points this out, under Supreme Court law, yes, law enforcement is able and lawfully to use coercive tactics and deliberately misrepresent facts. This bill looks to change that. Just because it's legal doesn't mean it's moral. And when law enforcement officers are coming, who are the professionals and who are supposed to know the law much better than the average citizen, comes up and says something like, well, I can search your car. Given the state of education in these United States, most people don't know that they can say, no, you don't have a right to search my car. They're going to say, oh, okay, well, then search my car. That type of deliberate misrepresentation of facts, while legal, I think it's wrong, and I think we have an opportunity to stop it with this bill. So with that, I just ask for favorable 589, and with amendments, so with that, I want to hand it over to my panel.
Thank you, Senator Sidnor, and your primary witness is Mr. Frazier. Mr. Frazier, you'll have 5 minutes.
Thank you, Chair Smith and members of the committee. I'm glad to be back speaking with you. The Office of the Public Defender respectfully requests that this committee issue a favorable report of this Senate Bill 589. The right to remain silent, the right to due process, the freedom of movements are rights that are protected by the United States Constitution and the Maryland Declaration of Rights. Here, this bill codifies some of those rights into law, as well as requires officers to inform individuals of these rights. Additionally, it requires transparency by requiring badge numbers and other identifying marks to be available to the residents of Maryland. 14 states around the country have some similar requirements. For example, the Seattle Police Department manual requires officers to provide identifying information upon request. There has not been data presented that suggests that doing these actions would create safety concerns or jeopardize investigations. Moreover, further, this bill protects an individual's constitutional right to record interactions with police officers. As defense attorneys, we've seen clients and bystanders, attempt to record police officers' actions and have had their phones taken away. Even more so than body cams, the public's ability to record police interaction provides accountability and transparency in policing. This bill makes clear that officers should not snatch individuals' phones or charge individuals with misdemeanors. We've seen clients charged with failure to obey or disorderly conduct for merely abiding by their constitutional right to record their interactions with law enforcement. I know there's been conversations that, as Senator Sidnor said, that it is constitutionally permissible, right, to say misleading things or to try to lie in police investigations, but that the Constitution in those cases are setting a floor. They're not setting a ceiling of rights, and that state legislatures like the Maryland General Assembly can create rights on top of that floor. They can't go below the floor that's set by the Constitution, but of course they can create rights above that floor. And for those reasons, the Maryland Office of the Public Defender requests a favorable report on this bill.
Excellent. Thank you very much. Next, we'll have Mr. Greenberg. You're up.
Thank you, Chair, Senator Sidnor, fellow senators. As it's good to be back in front of you. My name is Larry Greenberg. I am here both personally and on behalf of the Maryland Association for Justice. And we are, and now currently have, the largest amount of civil rights lawyers in the state of Maryland. This Senate Bill 589, as Mr. Frazier just said, it just makes sense. We get calls in my personal capacity as counsel. I get calls every single week of people who got pulled over, got harassed, got stopped, accosted in some way, shape, or form. And when I say, and they weren't charged. And I say, well, who's the officer? Don't know, wouldn't give it to me. I tried to record it and they wouldn't let me, which, by the way, they're allowed to. So this goes on more than you could imagine, and it's not right. So when it comes to that displaying identification, I don't understand who would be against it. I understand that there may be occasions where it could cause, or at least the argument would be, and we're going to hear from the people who oppose this, possibly a safety issue, but I still don't see that either. But the second, and you heard from Makia Smith earlier in another Senate bill, Chairman, Makia Smith, this bill should be named after. She was driving on Harford Road. Traffic came to a standstill. She looked to her right. She had her daughter in the car. She looked to her right and she saw a bunch of police officers facing outwards. And in the middle of that melee was a police officer kneeling on a young boy's head. And these other officers were discouraging others to come closer. So she stood out of her car, she picked her phone, she took her keys out of the ignition, she took her phone, and she started recording when one of the officers came barreling towards her, grabbed her phone, and as she got in the car, grabbed her by her hair, yanked her out, took her phone, and destroyed the evidence, destroyed the phone. So, you know, Senator Sidnor, if you want to call it the Makia Smith bill, by all means, she's willing to assist you. But, you know, listen, there are simple things, and Senator Sidnor, I heard about some amendments. We would gladly assist you in making this right. And Mr. Frazier, I heard a lot of what you said. It just makes sense. So we are asking for a favorable report on Senate Bill 589.
All right, excellent. Thank you very much. Next, we will switch over to the opposition panel, and we'll start off with Mr. Schellenberger. You're up.
Well, we have another new face. Do you want to go to Mr. Gibson?
Hey, there you go. Mr. Gibson, good to see you. You're up.
Good evening, everyone. Good to see you all. Glad to be here. My name is Rich Gibson. I'm testifying today in dual roles as State's Attorney for Howard County and as well as the President of the Maryland State's Attorney Association. The MSAA and I humbly request an unfavorable report for Senate Bill 589. There's nothing wrong with criminals engaged in violation of our laws being held accountable for their actions. This bill, as drafted, would lead to a less safe society. I have no problems with sections B1, B2, B21, B22, and B23. Right, the officer having to identify who they are, what department they work for, and the name of the entity they represent. There are issues, however, with section B3, right, which aims to allow individuals stopped by police to refuse to speak or provide information, or even to terminate, it proposes, the interaction in contradiction to our current laws, and in particular our current traffic code. How else would an officer ascertain whether a driver of a car has authorization to drive or operate the vehicle, if they can't ask that person questions and get answers from them? And obviously, it's an arrestable offense if you were to drive off. A person pulled over can't say to themselves, "Nah, I don't feel like being pulled over today or getting a ticket. I'm going to go." That would amount to fleeing and eluding, which is also an arrestable offense. Section D of the bill stands in direct contradiction to almost 200 years of settled constitutional case law. Supreme Court has defined Terry stops, the scope, search, and incident arrest, and the Carroll Doctrine, which defines searches of vehicles, and under what circumstances law enforcement can lawfully use deception. So it presents a supremacy clause issue. As was argued before, yes, you can legislate in Annapolis on issues that the Constitution hasn't spoken, but where you contradict those things, it simply wouldn't be proper. And I would argue this bill can no more change those things than, some state in 1954 wanted to maintain segregated schools after the landmark decision of Brown v. Board of Ed. The Constitution has spoken, Supreme Court has spoken, these issues are resolved. Let's examine, each of these kind of briefly. So a Terry stop, detention of an individual when an officer has reasonable suspicion to believe that a crime has been, is being, or will soon be committed. Constitutional analysis is clear that Terry stop can last as long as it takes for that reasonable suspicion to either blossom
Your time is complete.
Into probable cause or fizzle into a release. This bill slows the acquisition of that information, which would lengthen the amount of time to sit there and interact with a person. Let's say an officer pulled over a vehicle and there was a person driving the car, a baby crying in the back seat. And the baby saying, "It's not my daddy, he's not my daddy." Well, the driver won't communicate with the officer, and the officer has to now determine, and society has a vested interest in allowing the officer to determine, is this an unruly child, or is this in fact a kidnapping process? The central disadvantage to statutory law is that it works best when items and issues are static. It's not well suited for dealing with dynamic situations that are very fluid. Police interactions with the public
Mr.
can
Gibson.
be extraordinarily fluid. Yes, I'm sorry.
Hey, no worries. No, that was the time. I just want to make sure you briefly conclude because I want to be fair to all the panelists. That's all. So
absolutely. I'll expedite this. I spoke with Delegate Wilson this morning, 7 a.m. He gave me a call. We chatted about the bill. He did indicate that he's willing to make amendments to it. I just heard Senator Sidnor say the same thing. I am completely willing to have conversations with them and with anyone, related to making this a more palatable and reasonable solution to a problem they perceive in society. Again, we don't have issues with with the officer identifying themselves, badge number, but preventing officers from seizing items, preventing officers from searching to arrest or carry stops. I mean, we clearly have a problem with those things. And I'll welcome any questions from the group. Thank you.
excellent. Thank you very much. All right, Mr. Riley, you're up.
Thank you, Mr. Chairman, Mr. Vice Chairman, distinguished senators. My name is Joe Riley. I'm the elected state's attorney for Caroline County and the legislative chair for the Maryland States Attorneys Association. As you heard from Mr. Gibson, we are seeking an unfavorable report on Senate Bill 589. I'm going to deal with what the bill says, not what it supposedly says or supposedly will say. When we talk about exigent circumstances, they have, as the Senator Sidnor said, they have in this bill would have the right to not only to refuse to speak, but would have to be told that they have the right to not provide information. And that's simply not the law. And as my colleague, Mr. Gibson, said, it could further extend the police person interaction when we're dealing with Terry, as he said. Also, I'd like you to look at D. The exigent circumstances is only in the B section, not in the D section. So what does that mean? Officer pulls over a car, sees a loaded gun in the passenger seat, get a warrant. Sees a ticking time bomb, get a warrant. Sees a package marked fentanyl, get a warrant. These are all ridiculous things to add to an officer to make them do, and also could cause the dangerous things to happen to the officer, along with evidence that could be lost. My colleague, Mr. Frazier, talked about the city of Seattle. The city of Seattle says upon request. Does the state of Maryland really want to go beyond what the city of Seattle offers? I don't think so. So I would encourage you to think long and hard about this bill. And when you look at the bill, it's clearly not a bill that you should support. And we ask you to give it an unfavorable report. Thank you.
Thank you very much, Mr. Riley. Looking around, I think the last witness here is Mr. McAvoy, but I don't see Mr. McAvoy in the room. And with that, that'll conclude the testimony for Senate Bill 589. We'll turn it back to the committee for questions. Go to the sponsor of the bill, Senator Sidnor.
Thank you. And this question would be either for Mr. Riley or for Mr. Gibson. in spite of Supreme Court case law, I'm curious in looking at D2, do you find it acceptable that law enforcement officers are able to use coercive tactics or deliberately misrepresent facts in order to obtain information from people who are either in their car or on the streets that may not know their rights in order to obtain information?
I'll answer briefly, and then I'll defer to Mr. Gibson. When you talked about the consent scenario that you gave, that was clearly non-voluntary consent. That can, like, hey, you know, I can search your car, and they couldn't search the car, that false statement, and then the person all of a sudden voluntarily says, okay, or voluntarily says, okay, you can search my car then. That would not be voluntary consent. That would be illegal. That would be wrong. So I'll defer to Mr. Gibson as to the rest.
I just want to make sure you answers my question. The question is, do you think it's okay for law enforcement to use coercive tactics or deliberately misrepresent facts in order to obtain information? Not if it's
scenario you gave.
I'm not talking about my scenario.
The scenario you gave is
I'm not asking about my scenario. I'm not asking about my scenario. I'm asking for you to answer my question, not my scenario. And my question is, do you think that it is okay? And I'm asking that it's okay, not that it's legal. I understand that it's legal. Do you think it's okay for law enforcement to use coercive tactics or deliberately misrepresent facts in order to obtain information?
Well, without the definition of what you have as coercive, I don't know. So I would have to.
Do you think it's okay to deliberately misrepresent facts in order to obtain information?
In certain cases, no.
Secretary Ryle, let me take a stab at this, if I may. So I think what the pushback was the example that was used, because that an officer cannot lie about the constitutional rights of an individual. So they can't tell you something that's constitutionally untrue. So in other words, an officer couldn't arrest you and another officer pretend to be your lawyer and say, I'm your lawyer, and then tell me what happened and get a confession. You couldn't do that. That would be completely impermissible, and that officer should be fired, and all kinds of crazy things should happen. What you can do, what the Constitution of the United States and the Fourth Amendment and the case law from the Supreme Court says you can do, is an officer can represent facts like they can say to someone, we found your fingerprint. For instance, it's now 5:53. If an officer said, Senator Sidnor, I have you on video robbing a bank at 5:53 p.m. on February 17th. And I know you were there. Talk to me and tell me that, what do you have to say for yourself? You would answer, a reasonable person would answer, I was in a virtual room full of 20 people, and I was discussing with District Attorney Gibson what an officer can and cannot do. At the time you alleged I did this, get out of here. You're full of nonsense, right? A person who is of a guilty mind, who may in fact have left something behind. The case law that I referenced in my written testimony referred to officers saying that someone with a fingerprint behind when they didn't have the fingerprint analysis done, is allowed by the Supreme Court to that behavior, that type of deception is in fact lawful and serves a greater societal purpose than saying, nope, you can't ever lie. And so to answer your question, deception, as long as it doesn't infringe the actual rights, pretending to be a lawyer, lying about consent, things of that nature, is lawful. And I'll go a step further. Whether we like it or not, whether we find it offensive or distasteful, is really, you're entitled to your opinion. It's certainly it's yours.
But I'm not trying to make it an opinion. I'm trying to make it the law, because I'm offended that law enforcement is going to lie.
But so that's the point. So in 1950,
and again, I'm not arguing legal. You got
no. I'm saying to you,
right there. It's legal.
What I'm saying to you is, there were certainly states in this country when Brown was passed that did not like the idea and found it deeply offensive that schools would be integrated. And they certainly would rail against it and didn't like it. The point is, it doesn't matter. The Supreme Court has spoken on this issue. And whether you personally find it offensive or not, It's of no moment because the court has occupied that space with constitutional law. They have said legally speaking, this is permissible.
But I
And it's
believe
been
Mr.
resolved by the
Frazier
highest court in the
spoke to
land.
that, and he said that it was a floor. And me,
Yes.
as a legislator, if I don't like that floor and I expect more from my law enforcement officers, I certainly have the constitutional power to create a different standard, correct?
So let me, no, I disagree.
That's not correct.
I agree with.
Okay, no, that's fine. You said it's not correct. That's fine.
No.
I'd like to ask Mr.
Please bear with
Frazier,
me. Please
if
bear
I
with me 1
can.
second, please, Senator Sidnor. If I agree with Attorney Frazier's analysis.
So I do have the right.
No.
I have that authority. This General Assembly has this authority.
Please let me finish. No, please let me finish, Senator Sidnor. Mr. Frazier's analysis is correct. They can set the floor, you can set a ceiling. So in other words, if the Supreme Court said every officer in the United States has to have 10 hours of implicit bias training, state of Maryland could say, okay, well, we require 20 hours. It's not less than 10, it's just more than that. Howard County could say we require 30 hours. It's not less than the state's 20, it's not less than the federal government's 10, it's more than that. However, in this instance, you're not going above the ceiling, you're not going above the ceiling, you're contradicting it. The federal government, the Constitution said you can lie in these circumstances. Therefore, you can't turn around and say you can't lie in these circumstances because that would be a contradiction from what the federal government has said. So
these non-people with robes can say that it's okay for law enforcement to lie, and then a General Assembly, a legislative body can say, you know what, we don't like that.
You can't say, if the federal government, through the constitutional analysis from the Supreme Court, has said you cannot abridge an officer's right to lie in these circumstances. Officers have the right to lie in these circumstances. You cannot then turn around and say, I believe officers don't have the right to lie, any more than a school could have said in the Deep South, we don't agree with desegregation, and we believe our kids should be kept separate.
Okay, thank you. Mr. Frazier, do you agree with that analysis?
I would disagree. What State's Attorney Gibson is referring to is that in interpreting the Constitution, right, and Miranda and its progeny and other case law, the Supreme Court determined that it's not unconstitutional, right, to use deception, so that certain constitutional protections or certain exclusionary rules do not apply to that conduct. But then a state saying, actually, the state could say, well, we don't like that conduct, we can ban that conduct, and then create a state level exclusionary rule, right? And this bill doesn't even create the exclusionary rule. But a state could do that, and it wouldn't be unconstitutional. Versus, right, the Constitution saying you are protected from unreasonable searches and seizures. So a state can't say, actually, we will allow unreasonable searches and seizures, because that would violate, right, the Constitution. So I think that's where we have a legal disagreement.
So legislatively, as a General Assembly, we as a body, we have the authority to make that section of this bill law, correct?
Under D2, yes.
Thank you.
It's a policy question, not a constitutional question.
Thank you very much, Mr. Chair. I'm fine. Thank you.
All right. Thank you, Senator Sidnor. We'll now go on to Senator West.
Thank you, Mr. Chair. Let me ask this Mr. Schellenberger, who has remained unusually quiet during this conversation. So I have watched my share of police procedurals over the years, and one of the programs I really liked when it was on was NYPD Blue, and it was not unusual for Officer Sipowicz and his partner, whoever his partner was at the time, to bring in two assumed culprits, two suspects, and put each one of them in a different interrogation room, and then they would interrogate them sequentially. And when they got into one room, they'd say, you know, one guy here is going down. The other one, if he sings and tells us exactly what happened, we're going to go easy on him. I got to tell you, your partner is talking right now, so you'd better get on top of this thing right now and help us out. And then they go to the other room and they'd say the exact same thing to the other guy. And frequently, well, generally speaking, one of them would give up the goods and would tell the truth. And that's the one who would get the break, and the other one would go down for the count. Now, I'm assuming that that is what happens not infrequently in law enforcement. Now, this bill, of course, talks about a traffic stop, but the same principle that Senator Sidner is espousing here could be just as applicable there, which is the police shouldn't lie. Well, clearly in that situation, the police were lying. They were telling one of them that the partner was singing. Do you think that the police should be precluded from engaging in that sort of activity?
No. The courts have ruled that that type of deception that doesn't go to what Mr. Gibson was talking about, a core constitutional principle, is constitutional and it can be done. And in fact, it is done all the time. And what I would say to Senator Sidnor, who I've sent to my friend Delegate Sandy Rosenberg for 10 years, and who I now say repeatedly to my friend who I testified in favor of yesterday, David Moon, you know, the state of Maryland has a right by passing a law to give more rights to a citizen than the Supreme Court does. You have that right. But I live by what the Supreme Court and the Court of Appeals does. And while my friend Senator Sidnor may find it distasteful that the law permits officers to mislead, the Supreme Court has said it's constitutional, and it is in fact an effective way to sometimes investigate cases. And look, ladies and gentlemen, I got to tell you, nobody's lying. Well, they're not lying to people on a traffic stop on a regular basis. You know, the factual scenario that Senator West is talking about, where, and by the way, I don't watch any of those shows because I don't watch shows that are my life. But at any rate, in that scenario, more likely than not, they were investigating a homicide.
Right.
These two individuals who they had probable cause to believe had committed a murder. I mean, that's when you put two people in a different room. You got recording devices going, at least in Baltimore County we do, and you're recording everything that's going on. And every court has said in this state that deception to get that confession, as long as you didn't violate the constitutional, is legal. And I understand Senator Sidnor doesn't like that, but it's allowed.
Okay. Thank you very much.
Excellent. Thank you, Senator West. Now, Vice Chair Walstreicher.
Yeah, my question is less about policy and just about practice, and really out of curiosity. So many of the bad police stops, and I mean bad in the sense that they resulted in something that we don't want to see as a society, start escalating when police officers don't answer the question, why did you pull me over? And it seems like an easy question to answer. And so I'm just curious, I know we don't have the state police here or any police here. I would love to hear from them, but to the extent the state's attorneys can offer just a kind of general explanation why police officers tend not to answer that question.
Joe, go ahead.
Afterward.
I've talked to officers about that very question prior to this testimony, and it was explained to me that officers usually don't like to answer that question until they have the license or the identifying information, because inevitably it becomes an argument about, why did you pull me over? Well, you were speeding. No, I wasn't speeding. And then it just escalates from there. Whereas if you say license and registration are handed over, then you can terminate you can stamp down the confrontation by walking away. As the person is yelling, no, I didn't speed. Okay, well, I'm going to go write the ticket and I'll be back in a minute. Now you have the ability to do that. That's why they don't answer it immediately, but typically they will answer it. And if they don't, this bill, as we were talking about, I mean, if it's that simple, the problem with this bill is that it says you will notify them of the infractions. The problem is it could be one infraction, it could be a dozen infractions. This bill isn't very clear.
Yeah, my question wasn't specific to the bill, just to the general practice.
So that, well, I guess the general practice answer would be typically they do, and it's usually not at the immediate part. It's typically after they have a license registration, is my experience from talking to law enforcement officers.
I figured as much. And I guess my follow-up is that still true? In other words, it seems like people get so frustrated by the lack of an answer to that question on the front end that in fact, the escalation by not doing it on the front end is worse than the possible argument if you answer the question. No, I wasn't. Yes, I was. No, I wasn't. But so many of these bad interactions have been just kind of this refusal to answer. I just have a sense that it might be easier, even if occasionally it ends up in a yes, I did, no, I didn't kind of thing, to just answer on the front end. That's common courtesy when you pull someone over.
Vice Chair Wallstriker, there's also a public safety aspect to it. So there are times where, again, you didn't talk about this bill specifically, but there's times where an officer might not want to state the actual basis for why they're stopping the car until they get back up there. So, if they had information that this car was involved in a robbery, but they saw it make a turn, an illegal turn, right? They don't want to announce before they get support there, if it's an armed robbery, certainly because they're assumably still armed. They don't want to announce, hey, I'm stopping you because of the armed robbery you committed a day ago and there's an APB out for you. I'm stopping you because of the illegal turn. You want to just kind of de-escalate things, play it soft until you get support there, and then you'll ascertain, is this the same car? If it is, are these the armed robbers? Are they still armed? Is it dangerous? These situations are very kinetic, and they happen to unfold very, very rapidly, and they happen to unfold in many different ways. And so it's really hard to create a statutory solution that captures all of the different permutations of the ways that traffic stop can unfold.
All right, excellent. Thank you very much. I think Senator Lee has a question.
Yeah, thank you, Mr. Chair. This is for anybody who can answer this question. You might have already done it already because I've been in and out. Aren't there certain protocols, right? Are there consistent statewide protocols that law enforcement has to follow when they stop someone? Isn't this something that, at the very least, present identification by the law enforcement officer, not just be able to, so it doesn't escalate into something horrible later on, especially if there's a lot of misunderstanding? Do you have those policies already, or is it by different jurisdictions?
Go ahead, Joe.
I believe that is more of a policy question that would be something for the training of the officers when we're talking about a traffic stop. My experience in observing traffic stops and then being pulled over in my 49 years and I guess 30 plus years of driving is that an officer does identify themselves. And I believe it is probably one of their training procedures.
But does it happen very often? Like, how do you enforce that how do you get them to actually do this, to actually, present their identity? I remember one time, probably about over 10 years ago, I was stopped by a law enforcement officer, but they did not present identification. But they had stopped me because they thought I had a strange license plate, which actually turned out to be a House of Delegates license plate. But I was surprised that I would get stopped at all, and but no identification was presented to me. Just that where'd you get your license plate? It's really strange. And then when I started mentioning the chief, then they she kind of, or the law enforcement officer got a little rattled. But even then I didn't get any identification. Isn't that the very basic they're supposed to present? Is just at least who they are and their badge and all that?
So in my personal experience, again, I 44 years of life and being pulled over plenty of times for all sorts of silly things and real things, substantial things. I've not, to answer your question, Senator Lee, I have not routinely been told I am so-and-so, I am officer so-and-so from, Howard County Police, State Police, whatever, and I'm stopping you because, right? They usually ask for it. My experience, and it's anecdotal, is it's usually officer pulls up to the window, My hands were attended to, my radio was off, and they asked me for license, registration, and insurance. I provide that information to them. And then, there usually is a brief exchange, and what happens from there happens from there, whether you get a ticket or you get no ticket or whatever. That's been my experience. It has not included, typically speaking, their badge number, their name, the department they're associated with, in my personal anecdotal experience.
Excellent. Thank you, Senator Lee. We have Senator Jackson.
So just to briefly answer the question, look, in basic training, you are taught to identify yourself when you approach someone's car. I'm Corporal Jackson, Prince George's County Office of the Sheriff. I'm stopping you because of X, Y, and Z. Please give me your license and registration, and then I'll be back with you. That's typical. So, most of these things that we're talking about, I'm sort of sitting back and kind of watching, but has to do with accountability at all levels. Starts with the officer, but it really starts at the top. So someone sanctions any bad behavior by someone that's out there on the street. And, from an accountability standpoint, if you have challenges or concerns, it's our duty at the legislature to make sure that each citizen has some sort of recourse. That's what we're trying to get here. But to answer the question, yes, that officers should identify themselves and why they're stopping you. So thank you, Mr. Chairman.
Excellent. Thank you very much. All right. Seeing no further questions, that'll conclude the hearing for Senate Bill 589. We'll now move on to Senate Bill 590. Senator Sidnor, you're up.
Thank you, Mr. Chair. Senate Bill 590 has been, let me back up. For the past year or so, I've been trying to read a variety of law journals and books and things because of some issues that I had heard with regards to prosecutors turning over Brady material. And in searching and trying to figure out some sort of a solution, there were a number of articles that talked about how part of the problem is members of the judiciary not calling out attorneys for doing this sort of thing, and where they could do so in their holdings. So they, rather than talking about a specific assistant state's attorney or state's attorney that may have committed one of these violations, they talk about the office. So then that attorney then goes to another judge and continues on that same type of behavior. And that behavior, for whatever reason, is never properly dealt with. And in the midst of all of that, you have a number of citizens who are getting caught up and not getting the information that they should have in order to provide themselves with a proper defense. Brady, or I should say since Brady, there have been a number of different court decisions that really have, I believe, chipped away at what the Brady decision attempted to do. So my intent was to harken back to really put back the framework that the Supreme Court had when they had Brady. I reached out to some other people who know this issue much better than I, and had just began asking, I mean, is there something out there that we might be able to grasp on as a basis to really help provide or get us back to what Brady was before it began being chipped away. This bill was essentially built around a DC U.S. court rule. But I will tell you, between the time when the bill was drafted and today's hearing, and talking with some of the members on my panel, I discovered that there have been some court cases that have decisions that have been made that actually probably are better suited to having this particular bill amended, and I'd like to hand it over to them so as they could talk about this bill and how we intend on tweaking it. So thank you.
All right, thank you, Senator Sidnor. So we'll go on with your primary witnesses. And Ms. Levy, you're up. You've got 5 minutes.
Thank you, Senator. So to start with the recommended edits for this bill, we essentially are asking that this bill be amended on page 2 to track the requirements pursuant to Rule 4263, which is the criminal discovery rules in circuit court. We'd ask that this bill last as long as the pendency of a case, including appeal, quorum nobis, post-conviction, and writs of actual innocence. We ask on page 3 that the bill include information that is in the state or law enforcement's possession. We ask that the bill be amended to include impeachment information as identified in Rule 4263, deleting subsections 1 and 2. We ask that the information be obligated to be disclosed at arraignment or as when a trial date or preliminary hearing is set. Those are the bulk of our amendments. We also ask that in the sanctions page, it also says, including in subsection 4, enter any other order that is just under the circumstances, including dismissal. So let me go on then to my formal presentation with those amendments in mind. This year, the legislature has gone to unprecedented lengths to address police reform. And based on the very good work of this committee and others, we are hopeful that at the end of this session, the citizens of Maryland will have a new law making at least some police misconduct files more accessible to the public and criminal defendants in general. The genesis for your good work has been, and the impetus beyond transparency, is to create a more fair and just society. But making records public is only one smart of the work towards this goal. My name is Debbie Katz-Levy, and I am the Director of Special Litigation with the Maryland Office of the Public Defender. I focus my practice on litigating issues related to police misconduct and prosecutorial discovery abuses. Although my practice is largely in Baltimore, I lead a team of lawyers from every jurisdiction in the state who litigate these very same issues throughout the state of Maryland, and I myself have appeared in several jurisdictions throughout the state, litigating issues related to discovery and police misconduct. I can say with 100% certainty that while every jurisdiction in Maryland is slightly different, in terms of custom and practice, there is one thing that is incredibly clear and certain. But for Baltimore, there is no jurisdiction in Maryland that has any system in place for prosecutors to exercise due diligence and review and disclose through the rules of discovery police misconduct files. Senator Sidnor's bill, as amended, codifies every prosecutor's duty as it already exists in Maryland Rule 4263, as well as Rule 3.8 of the Maryland Rules of Professional Conduct. The bill affirms in message to the members of this state that not only does this legislature take seriously issues related to and miscarriages of justice, but the legislators of this state are sending a message to the prosecution that the judicial branch and the legislative branch require them to seek and disclose. As a matter of public policy, this issue should be covered by the courts through the rules and by the legislature through the statute. And I can hear my colleagues on the other side of the aisle holding up a book in a minute and probably saying we don't need this because we have a rule. And I posit two things to you in response. Number one, the rule is not working, and I can tell you with experience in no jurisdiction are these documents being regularly disclosed. And number two, I will tell you Public Law 116-182 passed in our United States Congress on October 21st, 2020 with bipartisan support, enacted a law in the United States of America called Reminder of Prosecutorial Obligations. Our Congress decided that this issue is so important, we must pass a public law to remind prosecutors of their obligation. In this contentious and difficult time in our society, it passed in the Senate on May 20th, and it passed in the House on September 21st, bipartisan support to remind prosecutors of their obligation. Until prosecutors learn to exercise their muscles and get comfortable with disclosing this material, something must be done. This new statute codifies 4263, and it is necessary because 4263 alone is not working. But for one current contentious prosecution by the Attorney Grievance Commission for a discovery issue we do not regularly see in Maryland, prosecutors taken to task for failing to meet their discovery requirements and obligations. But we know that discovery abuses lead to wrongful incarceration and wrongful imprisonment. This bill seeks no criminal penalty. It only seeks to
Time is complete.
To prosecutors across the state that they must do better. And in the words of Justice Souter in Kyles versus Whiteley, this is as it should be. Such disclosure will serve to justify trust in the prosecutor as a representative of a sovereignty whose interest in a prosecution is not that it shall win a case, but that justice shall be done.
All right, thank you very much. I will now move over to Mr. Giannetti. Good to see you.
Hey, good to see you, Mr. Chairman, Mr. Vice Chairman. It's an honor. I'm John Giannetti. I'm testifying for the Maryland Criminal Defense Attorneys Association. It's an honor to appear before this committee that I spent 4 years on, and I've been watching every minute of your hearings today, and I must say that I have forgotten how much fun the long JPR hearings are. And when I say fun, of course, I mean soul-crushing. It is, you guys work very hard and you should be commended. And I hope your constituents understand how much time and effort you put into this, and you're doing a really great job as far as I can tell. Thank you very much. I'm coming here to speak for the MCDAA for Senate Bill 590. And I want to commend Senator Sidnor about his efforts to try to codify what we see as discovery rules. And I think he should be commended. He met with all of us. Of course, it's very clear from her testimony. Debbie Levy has been carrying the water with this. She's the expert. And he met with members of the MCDAA, with Deborah, also with Stanford, Mr. Frazier. And, I think we all come to an agreement as if we can codify right now, when a decision comes down from the Court of Appeals, such as Brady, Maryland v. Brady, it's up to the court to create rules to put that into effect. The legislature doesn't have to, but the court needs to make sure that the discovery rules apply to the different decisions. Well, it's there in the circuit court rules for discovery. However, absolutely, the legislature can take it upon themselves, and that's what Senator Sidnor is doing. Put it in as legislative intent, and we can tweak it and we can fine tune it. And we can learn from the experience of folks like Debbie Levy, who have seen how the rule itself isn't enforced enough, and maybe we can make the rule a little stronger, a little better. Certainly, if you look at the original rule that Senator Sidnor came up with, he puts in what's in there in the federal rules, and we'd rather make it track along with the state rules, all right? Because in the federal rules, it only talks about materiality. Well, in the Maryland rules, it's really strong because the prosecutors have the duty to disclose things that are either admissible or not admissible, all right? That could either be impeachment evidence, or it could be used for impeachment, or could be used to
Your time is complete.
To help the defendant's rights in the case. And listen, the main thing that's most important, let me just finish up. I apologize. The main thing that's most important is you have this information, you have this discovery, and it helps resolve cases quicker. So we're in favor of this. We're in favor of this bill with amendments. Thank you very much.
Excellent. Thank you very much. All right. So now that concludes the proponents. We'll go switch over to the opposition panel. So Mr. Schellenberger, your hands up. You're next. So
thank you, Mr. Chairman. And yes, I absolutely want to talk about this one. I'll do what Ms. Levy said. I'll hold the book up. Maryland Rule 4263. It sits right behind my desk. It sits right behind the desk of every assistant state's attorney in my office. I would say to Senator Sidnor, next time you want to learn something about discovery, come to my office and let me show you what I do and what we jam down the throats of our assistants every single day. How important that discovery rule is and how important doing the right thing is every day. I tell my prosecutors all the time, the only thing worse than trying your case today is trying it 5 years from now when you didn't turn over what you were supposed to. I tell them that every day. And it's a little hard to find amendments and follow amendments when they're being read on the day of the hearing and suddenly changing how the statute is going to look. But let me tell you what this bill does the way it's written right now. It says the state's attorney shall seek from all government sources all information subject to disclosure under this information. All government sources. Does that mean I need to go to Billings, Montana to find out if there's information about this victim or this family in this case? And Senator Sednor, you're laughing, but that's what this thing says. It absolutely says that it's right there. It also says that section C511 requires disclosure of all criminal convictions. That means if I have a victim who got convicted in California of DUI 20 years ago, I have to somehow find that and go look for that so that I can turn that over. The Maryland discovery rules are very extensive. They tell me what I have to do. Believe it or not, I not only testify at the legislature all the time, I'm on the rules committee. And so I understand what these rules mean, and we do follow them. And if judges aren't enforcing them, maybe it's because they're not being violated. You can't tell me every judge in this state, when they get confronted with a potential discovery issue, every judge in this state has ruled for the state in these cases. I can't believe that. Every prosecutor in this state states their obligations very importantly. I understand.
Time is complete.
Thank you. I understand Ms. Levy may have cases here and there. They do happen. We try to right the wrongs, and it's our intent to follow the rule. We don't need a statute. The rules cover it.
All right. Excellent. Thank you very much. All right. Now, Mr. Riley, you're up.
Thank you, Mr. Chairman, Mr. Vice Chairman, Senators. My name is Joe Riley. I'm the elected state's attorney for Caroline County and the legislative chair for the Maryland States Attorneys Association. We are seeking an unfavorable report as to Senate Bill 590. I'm going to sound a little different from my testimony in the last bill, but what you want to be careful of when you codify case law, which is what this bill does, you have to be careful if the Supreme Court or the Court of Appeals says that Maryland's obligations are greater, or changes the law somewhat, or changes how they're interpreting the law, then you're going to be stuck with a law that's going to have to be changed. Whereas if it's in the rules, it's much more flexible in the rules. So I would just be very careful about codifying case law, which is what this bill does. And I could certainly go into what Mr. Schellenberger was saying about cases like, am I obligated, if I have a nurse who is a victim of domestic assault, am I obligated to go to the Board of Nursing and ask if there's ever been anything about her nursing record that could be possible Brady material? The shall in all government sources is hugely problematic, and we would never get a case done. It also isn't very clear as if this has to be done pre-plea. Sometimes this is talking about at arraignment. So I don't think that's also what Brady had in mind. And with that, I'll hopefully be under time.
All right, thank you very much. Senator West, I see you there, but we have one more. Mr. Potashnik, you are up.
Thank you, Mr. Chair, Mr. Vice Chair, members of the committee. Gavin Pashnik, Deputy State's Attorney for Harford County. I'm testifying on behalf of the MSAA. We're asking for an unfavorable report. You know, for as long as I've been an attorney, and one of the first lessons I learned is that cases are won and lost by discovery, and that strict compliance to discovery rules will always yield you a good result, even if you lose the case, because you did so honorably. You know, I will say I recognize what Senator Sidnor is doing. I appreciate what Senator Sidnor is doing with respect to this bill, and I recognize and appreciate what my colleague Deborah Levy is saying. However, the sole purpose of having rules is that they are flexible. The discovery rules are flexible. They are fluid. They change constantly. There's always parts of different things that you have to provide that could change that in an instant. Electronic discovery is a good example, and case law is a good way to manage that. The rules are a good way to manage that because they can be changed and adaptable very easily. Legislation cannot. Legislation happens once a year in Maryland, 90 days, and here we are at 6:31 at night arguing this bill, and there still may not be a resolution. So, at the end of the day, I think the current system we have for discovery works. And in all due respect to Ms. Levy, I share what Mr. Schellenberg indicated, that our prosecutors are very serious about making sure we follow the discovery rules, and we do so in every single case. And yes, things do happen, but I would say that overall, the discovery rules and the process by that works. I would also like to echo a sentiment that said that the state's attorney shall seek from all government sources all information subject to disclosure under this section. I think that sets up certain types of problems between the state's attorney and other government agencies who may have privileges, such as DSS, the Department of Juvenile Services, whistleblower protections. All of these things would set up situations where we'd have to pre-litigate whether or not we could obtain this information just for the purpose of satisfying this particular statute. So with that, I would ask for an unfavorable report, and thank you very much.
Excellent. Thank you very much. All right, we'll now move on to questions from the committee. Senator West.
Thank you, Mr. Chair. I have two lines of inquiry, both of which will be brief. Mr. Schellenberger, Ms. Levy says Brady is being violated every day. To the best of your knowledge, you've been state's attorney for Baltimore County for how many years? A lot.
Oh, we got it. Since 07, so 14 years.
14 years. During 14 years, how many times, to the best of your knowledge, has someone on your staff violated Brady?
Well, I can't say that. I can't count. And I can't say that it's never happened. I can't tell you the number of times that, as someone referenced before, a young prosecutor with dark hair, I had interviewed an officer twice, told him to bring his file to me, looked through his file, made sure I had every piece of paper. And just as we're walking into the courtroom, I asked him a question. He said, "Oh, I have this supplement that was done," and that happens. And I will concede that to Ms. Levy. And I had not provided that because there was a mistake. But then what I can tell you is that the very next thing that I did and my people do is walk into that courtroom, tell the judge I need a break, and Ms. Levy and I go into the hallway so I can get a Xerox of that piece of paper. I do not put it in my pocket, and none of my people do. So I do candidly admit that sometimes things are missed. I mean, honestly, in a homicide case, the discovery is often supplied in large boxes, along with, a folder full of CDs and DVDs. So, I mean, we are talking about a massive amount of information. So it can happen, but what I can say is that it's not intentional.
All right, so if we were to pass this statute, would there be any extra inducement to you and your office to comply with Brady?
I do not believe so. And I think that Mr. Potashnik made a great point. As a member of the Rules Committee, I get called emails all the time. There's a criminal subcommittee in 2 weeks because a case came out and we need to change something. And if that happens in May, you all can't change this statute until next January to April. And I think Gavin made an outstanding point. The Rules Committee is very mobile and moves quickly.
All right, and then finally, my second line of inquiry, which hopefully will be even briefer than that, the one I just had, was the last bill involved trying to codify Terry and all the various case law involving Terry. I think Terry was law when I was in law school 50 years ago. There's a lot of case law.
Terry was when you were in law school. And I hate to tell you, but Brady was in 1963, so you don't need to answer that question. But Brady has been around since 1983, and there is a ton of case law. So trying to codify that ton of case law from both the Supreme Court and the Maryland appellate courts is a very difficult task. I think the Rules Committee doesn't.
So here's my question. Is there any useful purpose to be served in trying to put into statute in Maryland, Terry and all the case law that's been inspired by Terry, and Brady and all the case law that's been inspired by Brady?
No, I have said over and over this session, why are we trying to codify case law when the lawyers know what the case law is?
Okay, thanks very much.
Yes.
All right, excellent. Thank you very much. All right, looking around the room for further questions from the committee. Seeing none, thank you all very much to the panelists, and thank you, Senator Sidnor. That'll conclude the hearing for Senate Bill 590. We'll now move on to Senator Jackson with Senate Bill 607. Senator Jackson, you are up.
Thank you very much, Mr. Chairman. For the record, Michael Jackson, Senator for District 27. Today I come to you to present Senate Bill 607, Harm to Service Animals. Senate Bill 607 is a straightforward piece of legislation that strengthens penalties for those who intentionally or recklessly kill or injure service animals. And according to the Human Services Article 7-701G, the definition for a service animal means a guide dog, signal dog, or other animal individually trained to work or perform tasks for the benefit of an individual with a disability, including guiding individuals with impaired vision, alerting individuals with impaired hearing to an intruder or sounds, providing minimal protection or rescue work, pulling a wheelchair, fetching dropped items, or detecting the onset of a seizure. Thousands of Marylanders with physical and emotional challenges rely on service animals to perform everyday tasks and to function in society. When one of these animals is injured or killed, it creates an extreme or costly emotional financial hardship. This legislation simply provides a better means of restitution to the victims of such malicious and intentional crimes. If enacted, the bill would make a violation of this type of misdemeanor punishable by up to 5 years in prison and or a maximum of $5,000 fine. Additionally, and most of note, it would require the violator to pay full restitution for veterinary expenses and or replacement of the animal. Increasing the penalties, these penalties recognizes the critical role that animals play in the lives of those they serve. Due to the amount of training that these animals receive and the unique capabilities that they provide, their value is clearly different than that of a household pet and uniquely worthless and uniquely worthy of the strengthened protections that this legislation would create. Strengthening these penalties will simply recognize the critical role that the service animals play in the lives of many individuals facing challenges. So many of us personally have either friends or acquaintances or colleagues who are in need of the use of such animals. A great friend of mine, the founder of Dark Horse Automotive Services, Mr. John Darvish, had a wolfhound. He unfortunately has Parkinson's, a 160-pound dog that is about as gentle as it needs to be, but it's something he couldn't do without, as well as I have a friend who had some sort of disease which caused her to have her hearing diminish over a rapid period of time. So she has those. So, with that, Mr. Chairman, I think, seeing how vital these service animals are, and I did the definition to clarify what service animals are. I would ask you and the committee for a favorable report of this legislation. I'd like to bring in my panel of supporters, including Ms. Dangle from the Humane Society of Maryland, Lisa Radoff, Maryland Votes for Animals, and Kim Fullerton of the Animal Law Section of the Maryland State Bar Association. Thank you, Mr. Chairman, and I'll certainly stand for questions after the panel.
Excellent. Thank you, Senator Jackson. And we have your primary witnesses, Ms. Bevan Dangle. So you're up. You have 5 minutes of the primary witness. Good to see you.
Thank you.
Good night.
Thank you, Mr. Chair, members of the committee. I will not take my full 5 minutes. You have had a brutally long hearing already, and hopefully it's a much simpler bill that will not engender the level of discourse that we have been enjoying watching you navigate all afternoon. Service animals deserve a higher level of protection. Obviously, the Humane Society of the United States, we've come to you before with, a whole litany of cruelty, neglect, and other laws that we need to pass to protect all animals. But we are talking tonight about a very select group of animals, ones that have received expensive and extensive training, and ones that are also very limited in the number and type of animals that even have the aptitude and the attitude to perform this type of work. Service animals really are a cut above, and I say that as a passionate dog owner who at the same time can acknowledge that my dog in no way could cut it in this type of role. These animals, by the nature of their life-saving work, must enter a wide variety of situations, all manner of public places where they do unfortunately encounter the risk of harm. If you as a dog owner decided, oh, I'm not going to take my dog to this event, or I'm not going to take my dog to this location, you have the ability to do that. Owners who rely on service dogs for their own safety cannot simply say, well, my dog might be in danger here, let me just leave them behind. So that's another reason why we do believe that this additional level of protection is critically important. And the owner and the animal must both have confidence when they're in these public settings that they will both be safe. The senator spoke to the risk if the animal is unfortunately killed or unable to, physically perform its job. That obviously deprives the owner of a life-saving work and of a bond that they formed with this animal. There's also a risk that incurred, even if an animal is not killed or severely injured. If a service animal is harmed in a way that makes it scared, skittish, unable to concentrate, then that animal can no longer perform its work because it will not be able to maintain the level of attentiveness to its owner in all settings that is required to truly keep the owner safe. I do want to reiterate, as the sponsors mentioned, service animals are very tightly defined. We are not talking about your emotional support peacock or your therapy hamster. These are simply service animals who are trained, who do meet these standards. So it is a limited universe of animals that's very clearly established. So for those reasons, we urge a favorable report on the legislation.
Excellent. Thank you very much. And next we'll just go in order. So Ms. Lisa, there you go. Ms. Radoff, you're up.
Chairman Smith, Vice Chairman Waldstreicher, members of the Judicial Proceedings Committee, thank you for the opportunity to share my testimony this evening. My name is Lisa Radoff. I'm the Chairman and President of Maryland Votes for Animals, here in strong support of SB 607. The hour is late. You've had many contentious bills. This bill hopefully should be pretty straightforward. Just wanted to make a few points. These animals undergo vigorous training in order to perform their duties, as you heard. While their owners often develop strong bonds with the animal, service animals are there to serve. They perform vital tasks and life-saving duties, including guiding the blind, which I think we've seen, alerting and protecting a person from increased harm during a seizure, as well as reminding a person to take medication and more. In a personal example, our treasurer's adult daughter decided to become involved with Maryland Votes for Animals because of her daughter's beloved seeing eye dog. She is able to live on her own thanks to her big black seeing eye Labrador. This dog takes her everywhere in Baltimore City, including her Braille classes. If this dog were to be injured or killed, she would most likely be unable to live independently and would have to move home with her parents. In short, penalties for harming these service animals, often on whom their owner's very survival depends, must be increased to reflect the seriousness of the integral role they serve for their owners and to society. I would like to thank Senator Jackson for introducing this bill and urge a favorable report on SB 607. Thank you.
Excellent. Thank you, Ms. Radoff. Good to see you. We'll now go to Ms. Fullerton. There you are.
Good evening, Mr. Chairman, members of the committee, and thank you, Senator Jackson, for bringing this bill forward. My name is Kim Fullerton, and I represent the animal law section of the Maryland State Bar Association. 44 states have already enacted criminal interference laws similar to Senate Bill 607, recognizing that service animals perform extraordinary duties and require specific protections. As most of the country has realized, tort law and animal cruelty statutes do not address the unique challenges that service animals and their human users face. So this is an area where Maryland has really fallen far behind. We have a gap in the law that Senate Bill 607 resolves by providing the statutory protection that service animals need to perform their jobs free from interference. I'll just very quickly highlight why this bill is so important. Service animals are specially trained to provide extraordinary duties, and even a momentary interference could endanger human life. Emotional value aside, service animals hold a significant monetary value. The cost of breeding, training, and matching a service animal is between $20,000 to $60,000. The data also shows that this is a problem we must address, as the greatest difficulty service animals encounter is public interference. There's also an increased risk of injury to both service animals and their users during an attack, in part because the service animal is trained to be non-aggressive. So given the magnitude and responsibility carried by service animals, the animal law section urges a favorable report. Thank you.
Excellent. Thank you very much. And next we will have Ms. Flint. You're up.
Chairman Smith and Vice Chair Waldstreicher and members of the committee. I'm Stephanie Flint, and I'm a proud member of the National Federation of the Blind of Maryland. And I also work as a government affairs specialist at our office here in South Baltimore. My address is 200 East Wells Street, and my phone number is 410-659-9314, extension 2210. As a part of my role, I monitor, advise, and work with policymakers to ensure partnerships between service animals and handlers are at the forefront of the conversation. And as a guide dog user myself, I can attest to the powerful bond between service animals and their handlers. From guiding me around fallen trees on our hikes in Patapsco State Park to navigating with me through the mentally and emotionally exhausting woes of life, my guide dog Nalabelle has certainly helped me to maintain not just my physical independence, but also my emotional independence as well. Whenever I think about the unimaginable happening to Nalabelle, I honestly get sick. Even, writing my testimony it certainly struck up a lot of emotions. And in our 5 years together, we've had some close calls that frightened both of us. But fortunately, Nalabelle was still happy and eager to work after a few days once the fear subsided enough. However, I recognize and know all too well that a lot of service dog teams are not as lucky. And this is why SB 607 is so vital for Marylanders with service animals. And while the penalties prescribed in this legislation cannot replace the handler and a service animal, they can relieve some of the costs that are associated with the medical care, God forbid, if the animal gets injured, or if the handler needs to, it decides that after the animal is injured and the team is no longer able to perform their work, that they are ready to have their animal or to go get training. I urge the committee to give a favorable report on SB 607, and I really hope that Maryland will become the 43rd state to punish perpetrators for doing harm to service dog and animals and their teams. Thank you so much.
Excellent. Thank you, Ms. Flint. And with that, that'll conclude the testimony for Senate Bill 607. Turn to the committee for questions. Excellent. Seeing none, we thank you very much. Thank you all very much. Good to see you all. Lisa, I owe you a text. I'll give you a holler. All right. So with that, that'll end the hearing for Senate Bill 607. We'll now move on to Senator Jackson with Senate Bill 608. Senator Jackson.
Thank you, Mr. Chairman. Michael Jackson, for the record, Senator for District 27. Today, I present to you the public safety article for the Maryland Police and Training Standards Commission. Just a quick backdrop. HB 1016 laid out, after the Freddie Gray incident, laid out the public safety and police work group. Out of that work group, there were directions given to the Maryland Police and Commission. Out of that came the Maryland Police Training and Standards Commission. This is the last step of that process. Last year, due to COVID, this bill passed the House, but it did not get a hearing in the Senate. So we are bringing it back this year, starting in the Senate. Senate Bill 608 is a piece of legislation that makes a few changes to both the work and administrative processes of the Police Training and Standards Commission. As we all know, the Training and Standards Commission sets the basic practices for police training throughout the state, and in one way or another touches each of the communities that we represent through their work, that's represented through their work. Made up of 24 members, the governor appoints 8 members to 3-year terms. 2 senators are appointed by the Senate President and 2 delegates by the House Speaker, with 12 members serving ex officio. Since its inception, I have been one of the members that have been assigned to this process. I believe Mr. Chairman and Senator Huff as well. There are 2 primary administrative changes that the bill makes to the commission. The bill will make the Secretary of the State Police the permanent chair of the commission, as opposed to having commission members elected to elected chair. The bill will also allow non-gubernatorial appointed members to designate representatives to attend meetings and perform committee functions on their behalf. The legislation will also make some changes to training requirements for new and current officers. These training requirements include enhancing entry-level and in-service training requirements to supplement training in criminal law related to rape and sexual assault, human trafficking, and evidentiary procedures. Additionally, new training programs will now be required in the areas of de-escalation in the use of force, the prevention of profiling, and in the recognition and prevention of discrimination based on race, color, religion or creed, national origin or ancestry, sex, sexual orientation, gender identity, age, physical or mental disability, marital status, veteran status, genetic information, and citizenship status. As you all may know, my background in law enforcement leads me to have a keen interest in these issues. Ensuring that law enforcement officers receive the most thorough and effective training possible is something that's very important to me. Training must always be assessed. Something that I believed when I was in uniform and when I was leading my agency, and it must be assessed to ensure that that training is applicable to tomorrow. The delay of this bill last session due to COVID kind of put us behind the 8 ball and kind of lent us to not be able to share the steps that have been taken by the Training and Standards Commission. I'm confident that this legislation will help to provide officers with the tools necessary to their jobs effectively and to ensure successful performance of their duties. With that, Mr. Chairman, I'd like to ask this committee for a favorable report. And I'd also like to introduce my panel. We will have Sheriff Troy Berry from Charles County. He is the current chair of the Training and Standards Commission. And Mr. Al Liebno, the executive director for the Training and Standards Commission, to offer testimony and to help answer any technical questions that the panel may or the committee may have. Thank you.
Excellent. Thank you, Senator Jackson. Looking forward to working with you on this. The primary witness you have is for Sheriff Berry. Good to see you. Sheriff Berry, you've got 5 minutes, so the floor is yours.
Thank you very much, Chairman Smith and members of JPR. For the record, again, I'm Sheriff Troy Berry with Charles County Sheriff's Office. I'm also, as Senator Jackson stated, the chairman of the Maryland Police Training and Standards Commission. With me today virtually is Mr. Albert Liebno. He's also the executive director of the Police Training and Standards Commission and the Maryland Police Correctional Training Commission. We did submit written testimony for your review, and I'll keep my remarks very brief. The Police Training and Standards Commission is an independent commission housed within the Department of Public Safety and Correctional Services that establish officer certification standards and training requirements for approximately 16,000 police officers in the great state of Maryland. Senate Bill 608 will have a positive operational impact on the commission as it clarifies language that had been subjective and realigns all training mandates to the same section of the statute. The proposed changes remove initial legislation language that impose requirements to develop standards and policies that have already now been developed and also implemented. It replaces such language with continual monitoring and revising these standards and policies as necessary. Additionally, Senate Bill 608 provides statutory mandates that every police officer must be certified by the commission and adds regulatory language that currently does not exist. For these reasons and others, we are asking for a favorable report on Senate Bill 608.
Excellent. Thank you very much, Sheriff. And now we'll move on to Mr. Liebno. Mr. Liebno, you're up.
Here we go. Okay. Thank you very much, Mr. Chairman and members of the committee. I have nothing as far as testimony to present to the committee other than what Sheriff Berry has and Senator Jackson did. Thank you.
All right, excellent. Thank you very much. Looking to the panel, that concludes the testimony for Senate Bill 608. Looking to the committee for questions, seeing none. Thank you all very much. Sorry, that's my daughter. So with that, that'll be that's it for that'll end the hearings for this long day. So with that, that'll end the testimony for Senate Bill 608. Thank you all very much.
Thank you.
And so for the committee, look, council needs 30 minutes to prepare for our voting session tonight. We have to vote. And so we'll vote for a maximum of 2 hours, and that is it. I hope it doesn't take that long. And then we are voting tomorrow. So I know some folks may need to make some travel arrangements as we're supposed to have some inclement weather over the overnight, but we're scheduled to vote tomorrow. We have to keep that schedule as it is. Senator West. Sorry, I'm asking.
There we go. Thank you, Mr. Chair. Because of the weather forecast, which looks dreadful, and it's supposed to be snowing heavily from about 6 in the morning all the way through 4 or 5 in the afternoon. Would it be possible for us to conduct the voting session remotely? And because as it is, we have to respond orally to yay or nay or yes or no on the bills. Why can't we do it just like we are right now? And Sandy can write down our votes as we do it.
So let me consult the powers that be, and I'll get back to you this evening when we meet.
Yeah,
I second that motion.
Message received. I got it.
I guess the concern is that if we work till 9 o'clock or so tonight without having any food, and I would rather go home and be home. I just got vaccinated for COVID this morning, my second, but people who've gotten vaccinated twice sometimes get sick. I'd rather be home if I get sick than in a hotel down here. But I don't want to be home. And if I'm going to have to come back tomorrow morning through a blinding snowstorm.
So message received. Let me get you an answer on that as soon as possible. I'll be back. I'll get back to you within 10 minutes of when we log on.
Yeah, look, I mean, just
All right, so it's already-
to make it clear, I don't consent to any kind of remote voting. We've established already voting in the voting room. I realize there's all kind of, I'm not going to use the words exigent circumstances because we just went through hours of that. I realize there's concerns, but that just is not in line with what we have agreed to previously with the rules or anything to do remote voting. We're extending to remote hearings and all the like, but that's a bridge too far, Mr. Chairman.
Could we take a informal vote to give you advice as to where we're coming down?
No, I think I've got that message. I got the message. Look, Senator Castley brings up a strong point. And so I will, like I said, I'll consult the powers be. I'll get back to you all relatively shortly.
Okay.
So let's do this.
When are we going to start the voting?
It is 7 o'clock. Let's be down here. Let's be down in the committee room at 7:30. All right. Thank you all very much.
For,
No,
for 2 hours.
Yep, maximum.
Then we can get dinner at 9:30. Thank you.
Appreciate it. Thank you all for your fortitude.